Steve, are we live?
We are live now. Where do you go?
Yeah, we said we're ready.
Yes.
Okay, good morning. I'd like to call to order this public hearing of the Judiciary Committee for Friday, March 5th. There are two bills on the agenda. Senate Bill, actually they're both House Bills, sorry. House Bill 6355 and House Bill 6491. Before we start, any comments from my co-chair or the ranking members? Seeing none, we'll begin by calling the first person, which on our list is Kevin Lawler. Is Attorney Lawler in? I do see you. You have your 3 minutes and you may begin.
Good morning, Chairman Staffstrom, Chairman Winfield, ranking members Kissel and Fishbein, and distinguished members of the committee. Thank you for providing the Division of Criminal Justice and myself with the opportunity to discuss House Bill 6355 and House Bill 6491. I know you have a long day ahead of you, so I will refer your attention to our written testimony. Briefly, our testimony reflects our support for the concept envisioned by House Bill 6355, that people seeking protection from police and the courts who believe someone is a danger to themselves or others and possess firearms have an ability in some way to bring that to the attention of the court. The division would recommend, however, that rather than shoehorning the newly envisioned risk protection order into the statutory scheme of 2938C, which was set up for police and prosecutors to obtain search warrants, that the legislature create a civil mechanism similar to our civil protective orders. This would relieve civilians of the requirement to swear under oath, that their complaint rises to the level of probable cause, a legal standard which they are not trained to understand, and which a failure to bring evidence to that level may cause their motion to fail in court. The civil mechanism could be effective for a shorter period of time, and I believe would be more effective at bringing their justifiable concerns to the attention of the court. We believe that 2938C should remain as a tool for law enforcement to obtain search warrants after an investigation which shows to a trained law enforcement professional that it rises to the level of probable cause. As for House Bill 6491, the division understands that a reading of the U.S. Supreme Court decision in Caetano versus Massachusetts could support a removal of the electronic dangerous weapons from 29-38 and from 53-06. Given these weapons' potential for offensive use in the wrong hands, however, the division strongly opposes removing them from 53A to 17. We believe that if the legislature does believe that removing these electronic dangerous weapons from these statutes is appropriate, we would recommend that individuals obtain a permit. We also, again, strongly oppose removing them from 53 to 17 because people with documented disqualifications that are outlined in 53A 217 should be prevented from legally possessing these weapons because those people, by their own actions, have proven to be a greater danger to society. Thank you very much, and I'm happy to answer anyone's questions.
Thank you. I see that Representative Fishbein has a question or a comment.
Yes, sir. Thank you. Thank you, Mr. Chairman, and good morning, Mr. Lawler. Looking at your written testimony, you reference joint favorable substitute report, and I'm not aware of such a report. Do you ever?
I believe what we were requesting was joint favorable substitute language. So I believe that was phrased in that way in order to reflect that we were requesting that the current language be amended.
Okay, it's just not written that way. It says respectfully recommends the committee's joint favorable substitute report. So
I think that may be inartfully written.
Okay, thank you. And you mentioned a lay person, not a police officer, not a state's attorney, not having knowledge of the probable cause standard. You know, I run into a lot of these cases. Have you had experience of case and/or cases where the present system, which allows the state's attorney or two police officers to swear to an affidavit that somebody's of potential harm to themselves or to others, is insufficient?
For those professionals, no, I don't think it's insufficient.
Okay, well, I'm asking specifically about the present system, because I know that presently one who has a concern can reach out to their local law enforcement. I've been involved in these cases. Law enforcement, you know, goes and speaks to the individual, ascertains whether or not, you know, is the person suicidal potentially, has this person made threats utilizing some sort of weapon or activity that would give rise to that, and then they swear, you know, they bring an action in effect. That's the present system. Are you aware of any times that that system has not worked?
I think the design of the system to relay those feelings to the police has worked well. I think, you know, as is documented in our testimony, we've seen that, you know, Connecticut has led the way in this particular area over the last 20 years. It has been used more in the last 10 years than it was in the first 10 years. Due to it, I think, becoming more known. But I believe there have been some documented examples where people who I believe may be testifying here today have talked about how they believed that the police investigation fell short, and that they felt that their voices did not have an ability to be heard once that decision was made at the local police department level. So I believe you know, the purpose behind the bill of giving people an opportunity, in addition to the current system, in situations like that is what's given rise to the bill. And the division is just pointing out that if that is something that the legislature believes is meritorious, that this would be a more effective way of resolving that issue.
Okay, but you're not aware of any specific cases where the present system has failed an individual? I
believe one of the cases that's been pointed out is a case arising out of the city of Bridgeport, where certain individuals felt very strongly that the investigation or lack thereof in that case, where they believed more action was necessary, and kind of fell upon deaf ears. I am aware of that particular case.
And is there some sort of site that I can go to for that case?
I believe a complainant in that matter, who her daughter was murdered, is a woman by the name of Jennifer Lawler, and her, I believe she's testifying here later today. I believe I saw her name on the list of people to testify today. Her daughter was horribly murdered in a case that is currently pending in the Bridgeport State's Attorney's Office. And because it's pending litigation, I really wouldn't want to discuss that.
That's a criminal matter that's
Yes.
That's currently pending. There's no civil collateral action involving that, to
Not that I'm
your
aware of.
knowledge. Okay, I'm sure we'll get there. Okay. Thank you. That's all I had. Thank you, Mr. Chairman.
Thank you, Representative Dubinsky.
Thank you, Mr. Chairman, and thank you, Mr. Lawler, for coming in. I read your written testimony, and I was not sure that I believed that I was reading it correctly, but in your oral testimony this morning, you confirmed that I did read it correctly. Right now, what is the standard that has to be met in order for a court to seize somebody's firearms under a risk warrant?
Under a risk warrant pursuant to the Constitution, the standard is probable cause to enter a person's property and seize their property.
Okay, probable cause.
Probable cause.
it appears to me, and please tell me if I'm wrong, that you're proposing that be reduced to good faith belief.
Not for a search warrant, no, sir.
Okay, but not for a search warrant, but for a citizen to go into court and seek a risk warrant,
Not a risk warrant.
okay, a civil risk protection order.
Correct.
Okay, so the standard would be good faith belief.
Correct, for the standard for a person to be ordered to turn in their own weapons, not for the government to go and get them. It would be similar to the standard.
And if they fail to do that, then there would be a warrant issued and there would be seized.
No, there would have to be a hearing held prior to that, where a judge makes that initial finding. Then the person would be ordered to turn in any weapons that they may have. And then there would be a subsequent hearing within 14 days where that person would be brought in and have notice and an opportunity to be heard. Very similar. The reason we suggested this as an alternative is because this has already been held to be legally sufficient for temporary or for civil protective orders, which are analogous to what we're referring to here, which have as a criminal component the full protective orders that are issued by the court in criminal cases under a different standard. So that, it's already found to be legally sufficient in that regard. And those civil protective orders also carry a possibility of having your weapons being prohibited from possessing your weapons as well. So, that type of standard has already been held to be legally sufficient in this instance.
Okay, so standard of, so you're saying that an individual without any law enforcement involvement at all would go into court and seek a civil risk protective order on a standard of good faith belief and get a court to issue an order requiring another individual to turn over all of his or her firearms.
Pending a hearing, yes. And again, this is the state, the Division of Criminal Justice is offering this as a what we believe to be a legal method to effectively do what I think the intent of the bill is. This is obviously a legislative decision. We're just stating that if this were the intention of the legislature, that this would be a way that it could be done.
Don't you think that the standard of good faith belief is awful low to strip somebody of their ability to protect themselves and their constitutional right?
Well, this is similar to the standard that is used in civil protective orders, which as a collateral consequence of those orders results in the same thing.
Okay, now you'd mentioned something about now would this good faith belief be done under penalty of perjury?
The hearings, the individuals would have to be placed under oath, yes, similar to in a civil protective order situation.
Okay, you're saying the hearing, but the hearing happens after the firearms are relinquished.
No, there would have to be the initial hearing where whatever information they had would be presented to the court, similar to a civil protective order. A judge would then listen to whatever evidence is provided, make a decision based on the standard you cited, which that decision would then be served upon the party to whom it was directed. That would then kick in the order to surrender the weapons. They would then have a hearing where they were present 14 days from that hearing, where the burden would then be placed upon the state to prove by a clear and convincing evidence that it should remain.
Okay, so what happens if they don't voluntarily turn over their firearms?
Well, then, whatever remedy this the legislature would provide for making that a penalty, the state would then, I guess, have a duty to enforce it, similar to if a person was put under a civil protective order and then violated that protective order. There would be criminal ramifications for that in the exact same way.
Okay, so essentially, if somebody goes into court on a standard of good faith belief, gets an order from the court, and refuses to turn over their firearms based on a good faith belief standard, sounds to me like they're then going to get a knock on the door for violating that order and have their firearms seized. So in effect, that good faith belief standard turns into a warrant for the seizure of their firearms.
If you don't comply with a court order, I guess you would be correct. But, again, it would be a court order that there would have to be a finding by the judge. It would have to be served upon the individual, and then that individual would have to consciously violate the order prior to the 14 days within which a hearing would have to be scheduled. But again, what the division is recommending is that if it were the decision of this body that is something that is appropriate, that would be a way similar to what we've done in the past, what this body has done in the past with civil protective orders, that it would be a framework that would be feasible.
Yeah, it sounds like an awful low standard to me. Later in your testimony, your written testimony, you suggest that that instead of having a definite period, not to exceed 1 year, under which the person subject to the warrant is without their firearms, you suggest an indefinite period until the person proves that the risk has abated. So it would be, the onus, the burden of proof would be on the person who's had their firearms seized, as opposed to being on the state?
The division has submitted testimony in previous years on this particular issue, and the division's recommendation in order to effectively enforce these would be to require at the beginning, when firearms are taken, that the state have the burden of proving by clear and convincing evidence that the person poses a danger to themselves or others, and that they possess those firearms. Upon those being seized, the division does recommend that at that point, the burden be placed on the person whose firearms have been seized to prove by a mere preponderance of the evidence that they do not pose a danger to themselves or others at that point, and that the firearms should be returned.
Okay, so it says indefinitely. Let's say 5 years later, the person goes into court and says, I want an opportunity to prove that I am not a risk of any type, and I want to get my firearms back. At that point, where are those firearms?
Those firearms would be kept at whichever police department had originally seized them, or if prior to a seizure under one of the other orders, they were voluntarily turned over to someone who, pursuant to statute, is acceptable to receive them, then they would be in that person's care.
So the police will hold on to them indefinitely?
If they're the ones who seized them and they were in possession of them, yes.
Okay. My understanding was that the seized firearms are typically destroyed within a year. Is that not the case?
They wouldn't be destroyed without a court order, and they couldn't be given a court order unless there was some legal reason to order their destruction.
Okay, so under current statute, they will be held indefinitely.
Yes, there are, I can think of several instances where items that have been seized as evidence in criminal cases have been kept for long periods of time. So it's not uncommon, I would say.
All right, thank you. Thank you, Mr. Chairman.
Thank you, Representative. Representative Howard.
Thank you, Mr. Chairman. Good morning, Mr. Lawler. How are you, sir? Can you hear me?
Yes.
Okay. Before I ask you any questions, I just want to be clear to you. I have conducted in excess of 1,000 firearms investigations related to firearms permits, what we call as persons posing risk, what you're talking about, protective restraining orders and compliance things. So I'm fairly familiar with the process, and I want to be sure that my colleagues on this committee understand all these processes that were just discussed. So if I could have a minute of your time to do that.
Sure.
What you just said was when my colleague, Representative Davitsky, said the guns would be destroyed, you said that they wouldn't be destroyed without a court order. Did I hear that correctly?
Yes.
So I also handle property, and on numerous occasions, we've destroyed firearms without a court order, because what happens is people get a protective or restraining order against them that doesn't order their firearms destroyed. It says they're ineligible to possess them.
Correct.
And then they have to turn those firearms in. And when they do, they sign a form that says that they have 1 year to transfer those to an FFL or have the order dropped and become eligible and get them back. And if not, they get destroyed without a court order. Isn't that true?
Well, I'm not familiar with the form that you're stating. I would have to research what the legal basis is for the form for your particular police department that indicates that. So, you know,
It's not necessarily a form from this police department, Mr. Lawler. It says in the state statutes that when you become ineligible because of a protective order restraining order, and you are ordered to turn over your firearms, if you don't become eligible to possess them within a year or transfer them to an FFL in the case of protective or restraining order, and that's a little different with a risk warrant, but protective or restraining order, then they get destroyed without a court order. That's in the statute. Would you agree?
If that's in the statute, then you'd be correct. And obviously that would be something that if it were a concern to this committee and it was a concern to the legislature, then obviously that is something that I would recommend be incorporated into whatever language would be coming out of the committee and voted upon, so that that particular statute would be incorporated in whatever way the legislature sees fit.
Okay. The other thing is, so we talked a little bit about civil orders of protection, and we commonly refer to those as ex parte restraining orders. You're familiar with those processes that you referenced?
Mm-hmm.
So what, if I heard you correctly, what you were essentially testifying to today was that when an abused spouse, for example, comes into a court and on good faith that they feel endangered, they fill out an affidavit without the abuser having any say. And by the way, I agree with this process. And the victim files this affidavit. A judge says yes, they're a danger. They issue the ex parte restraining order. There's a hearing in the process, but in the meantime, the respondent of that ex parte restraining order has lost the right to bear arms and has to turn them in. Otherwise, they're guilty of a crime because they're illegally in possession of firearms. Is that correct?
That's correct.
Okay. And what you're basically saying is that the legislation, as you're talking about it today, would essentially take that same process for persons posing risks.
Risk to themselves or others who they believe possess firearms. Yes.
Okay. But there's a big difference between the two, right? Because in order to get an ex parte restraining order, say my wife wanted to get an ex parte restraining order against me, she can't get that on good faith belief that I'm a danger to myself. she's got to get that in good faith belief that I'm a danger to her and or our children, correct?
Yes.
Right. So, and if we do what we're talking about here, we're taking it one step further, that somebody can go to a court with a good faith belief, have my firearms, my personal property seized from me based solely upon my danger to myself. Is that right?
I believe to yourself or others would be the standard, yes. So.
Correct, but the danger to yourself is other run parallel because they're the same in what we're comparing. What I want my colleagues to understand is that they aren't exactly the same premise, because in one case, you're saying, okay, we're gonna do these things on good faith belief to protect other people, and in this case, you're gonna good faith belief to protect themselves. And right now, as I understand the laws and have applied them, having drafted many of these imminent risk warrants, what the police have to establish is probable cause to believe that this person posed imminent risk themselves or others by possession of firearms, correct?
Yes.
And then within 14 days, that the state then has to prove at a hearing based upon clear and convincing evidence, a higher standard, that that person in fact poses an imminent risk, and therein lies the due process as it sits today.
Correct.
Right. And under the new way, we wouldn't establish probable cause. We would be the good faith belief, which is of course a much lower standard.
We would continue to have the probable cause standard for the warrants that you have obviously great familiarity with, and this would be a separate determination, and obviously less intrusive because the government wouldn't be allowed to come in and search your home and take any weapons.
Well, not until a reasonable amount of time has passed, and then you refuse to do it, and then they get an arrest warrant for you, et cetera, right?
I mean, if what is under the law would obviously assumes that people would comply with a legal order that is constitutionally sufficient and has been passed by our legislature. So yes, if you wanted to violate the law, then something more would happen to you, and I think that happens in every statute that we have, right? The failure to, if you don't come to court when you're told to come to court, you get charged with failure to appear.
Right.
So, I mean, those things happen. Yes, there would be ramifications, and the division is just recommending this as an alternative to what has been proposed as a way that would be legal and in my estimation, based on having done these for a long time, that if this is the goal of the legislature, this would be an effective way to do it.
Thank you. I think we can agree that if people would just simply follow the laws, then neither you nor I would have a job. That's pretty right. So we have to have a process to address that for sure. The other thing I don't
want to give it short shrift. I mean, I think that the reason that we're here is that there have been shown to be some gaps in the system, just like any human system, where we can look back and think that perhaps there's a better way of doing things that would avoid some of the horrible tragedies that I'm sure we'll hear later on during the day. And I think that it's incumbent upon us that if we are presented with those types of issues, that we as law enforcement professionals attempt to offer an alternative that may address that problem. So I think that's just what we're trying to do here. But obviously, all of that is up to you.
And that brings me to my next point, Ms. Lawler. So you did reference, I believe, very loosely, and I respect the fact that we have to do that without detail for everybody's protection, that there may have been an incident in the state of Connecticut where somebody was in imminent risk, reported to the police, and the police didn't do due diligence, and something bad happened. Did I basically understand?
I believe that's the alley. That is what those individuals are concerned about. I'm not familiar with the case myself, not having prosecuted it. I'm not aware of the underlying events, but I am aware of their concerns, and I'm aware of the case generally.
All right. So I guess my only point to that, you maybe you don't know the answer. I was going to ask if the police had done what they were supposed to do based on that complaint, would it have resulted in what we currently know as an imminent risk warrant being signed based on the circumstances? And if you don't know, you don't know because you don't know the details, and that's fine.
I would apologize. I don't know the details.
No, that's okay. You can't know the details of every case in the state. That's unreasonable. I respect that completely, Mr. Lawler. But the point that I would like to make there is this legislature should not be charged with making laws because police officers aren't doing their job right. That's what we have police chiefs for, we have mayors for, that's what we have police commissions for. And if officers are getting information that somebody's in imminent risk and not taking it seriously, then that ought to be addressed. But to simply put legislation in for that, and I have one final question for you. I assume in your capacity, you've signed probably several, maybe thousands of search warrants to seize property in your life. Is that fair?
Thousands.
Yes, I'll bet. And when you sign those search,
Right. Much to my wife's chagrin.
yes, I'm sorry if I interrupted you. I think I have a different connection. I apologize.
No,
So when you do that, the officer has, before you can seize anybody's property in this state or this country, the officer has to establish probable cause, right?
that is correct.
Right. Can you think of any other time where, or any other circumstance in this state where somebody can have their own personal property seized from them based upon a good faith belief of someone who may not even know them?
Well, there's a lot of variables in that question. You know, again, I would suggest that, you know, the collateral consequences of a civil restraining order that you're talking about, that we've talked about already here this morning, has that as a collateral consequence in the area that we're talking about, where if that is granted, then you have an issue with the weapons.
Sure. And I guess I understand that there, by extension, that would apply in that particular instance, but really that order based on a good faith belief is to restrict the ability of an abuser to harm a victim. So that order could actually remove someone from their home. That could, you know, tell them they can't go to certain places where that victim may work. There's a lot of things in that order, but specific to an order that simply takes somebody's property away, can you think of any other time that order specifically does that based upon anything less than probable cause?
Since I'm a criminal lawyer and I try and avoid all other types of law to the extent possible in my capacity, you know, in criminal law, I wouldn't be able to, I can't think.
Thank you, Mr. Lawler. And I do appreciate the fact that you were here today and willing to indulge me in those questions as I simply try to just clarify any confusion for my colleagues who may not be lawyers or may not work in this particular field. So I thank you for the time. And Mr. Chairman, I thank you for the opportunity to do that as well.
Thank you, Representative Howard. Senator Champagne.
Thank you. Mr. Lawler, I just want to follow up on the good faith belief. I want to know how easy is this for somebody to go and make a complaint to take the firearm? Let's start with who can do this? Who can make this good faith belief complaint?
I think that should be an appropriate decision of the legislature as far as who exactly and what the definitions should be for who would be appropriate to be able to make this type of a complaint.
If this law passes kind of the way it is, could it be anybody?
I don't know if it could be anybody. The law as currently drafted has certain types of individuals with knowledge of that particular person. You know, it's family members, medical professionals, you know, those types of intimate partners. Those seem to be the types of people who the law envisions would have access to the courts for this particular issue.
Okay. And so if they go in and they say, you know what, I heard him, you know, 3 weeks ago say that he might hurt himself. Would that fall under good faith belief? Would that be enough?
I really wouldn't want to guess as to what one snippet of a person's overall testimony would be. Obviously, good faith belief, you know, at some level would be that the judge has to believe that the person is not lying and making it up, and that they have a good faith belief. You know, again, similar to what we have in a restraining order situation where a person comes in and says, this is why I'm afraid of my spouse. Those are the types of decisions that judges have to make based on the facts presented to them, the law as it's defined, what the statutes and the case law describe as what a good faith belief is, what the demeanor of the individuals are that are placed under oath before the judge in that type of a hearing. I think all of those things would factor into whether or not a person has that good faith belief. And again, I want to draw the distinction between that and probable cause, which is a term of art in the criminal justice system, has a very different meaning and a different definition, and is something that the average person wouldn't understand. And I think it's unfair to place that burden upon non-legal professionals. And it's more
You mean probable cause on the
yes,
individual?
warrant situation as it's currently drafted.
Mhm.
You basically have to swear in the form that you have probable cause to believe that this is a factor, but I don't think regular civilians would really know what that means. They would be swearing if they're afraid.
Okay. So the judge has to determine if the person's lying or not making it up,
It's a good faith belief.
using the good faith belief. That's a pretty low bar. I mean, we wouldn't arrest anybody on that. We wouldn't. I don't think of anything else that we would lower the bar to that standard. And that's concerning. That's concerning to me, because there's a lot of times where the people that you mentioned are in some sort of dispute with somebody. Have you ever heard of a case where somebody's coming in for a protective order or anything like that, where it was made up?
Yes.
Mhm.
Where there's allegations that it's made up. I've never.
Okay. And in the trial, now you took a judge who said, I think this person is telling the truth. No other evidence, no probable cause. I think they are. Now I'm sitting at trial, and now that I'm going to speak, and basically it's just he said, she said, and I've already decided that I'm going to take one side already. So how do I determine that? During this hearing that, maybe this person's more believable than the other person. And am I wrong in saying this? It's a he said, she said, or he said, or she said, she said, you know what I'm saying?
Yeah, I do understand the premise. It is a different standard than probable cause. That is certainly clear. This is an initial finding subject to an additional hearing 14 days out with a different standard.
But a penalty's already taken place.
An initial order has taken place where a person.
Right. A penalty has happened already. You have stripped somebody of their rights on possibly just a verbal comment and without any backup or standard except good faith belief. And then the judge has to say, I do believe or I don't believe.
I would just refer you to our current temporary civil protective orders or restraining orders, as they're referred to, for a similar standard, which has one of the ramifications being this. And people are today being held to a standard similar to this in that context, where one of the ramifications of a judge making a similar determination is a similar outcome. So,
but I just feel that lowering the bar creates problems. If that's the case, if somebody comes in, well, why don't we just bring them to court? Ask the person, come to court tomorrow. Before they seize the firearms. I understand there may be consequences on the other side, but automatically saying that, with this low bar that we're just going to automatically take action and remove somebody's constitutional right, Second Amendment, with such a low bar, this wouldn't be a standard anywhere else.
Again, I think that's an appropriate discussion for legislators to have. The division is here indicating that if it is the will of the legislature to have a system such as this, that this would be a way that we believe would be able to accomplish that goal.
going to continue to listen, but you know, so far and I'm not being convinced here. You know, I like the concept, but I don't like the mechanisms.
Thank you, Senator Champagne. Senator Sampson.
Good morning, Mr. Chairman, and good morning, Mr. Lawler. Nice to see you.
Good morning, Senator.
So just listening to the conversation this morning, it just brought a few more questions to my mind. The first thing I might want to ask, you made a reference that that I just want to make sure I understood it clearly, which is that if something passes the legislature, it's deemed to be constitutional. I just like to have a confirmation from you that that's not necessarily the case.
If I said something that caused you to believe that, I would say no. You know, that is obviously the legislature could pass something that would be in violation of the Constitution as interpreted by either our courts or the United States Supreme Court.
Right. Yeah, no, I appreciate you saying that too, because a lot of times today I have a feeling there is going to be references made to the current ex parte restraining order process. In fact, you've referenced it a couple of times yourself. And I would argue that law is also unconstitutional. I argued it when it passed into law back in 15 or 16. And I'm pretty certain that if it ever reached a high enough court, that's a challenge that would be successful based on the due process argument, which is like the key component in almost all the testimony that we've received in opposition. But I want to talk about this good faith belief thing, same as everyone else, because I guess my concern is this, is that we live in a very polarized and politically charged society. Would you acknowledge that there may be a sizable portion of our population, and by sizable, I mean 20%, 30%, maybe more, that would agree that any person possessing a firearm might be a danger to themselves or others?
I don't know if I could answer that. I don't know. Haven't seen a poll on that in the USA Today.
Well, Mr. Lawler, I suggest sticking around for the testimony today, because I think it's going to become quite clear from the people that come testify that they believe, a lot of them do, the people that will be supporting this legislation. I would say that the majority of them are coming simply because they believe that no one should have the right to own or possess a firearm, not for any particular reason other than the fact that they just disagree with private gun ownership. So would this language in this proposal preclude someone from making a complaint against someone else simply because they believe that their neighbor owning a firearm poses a risk to them?
I don't think that would rise to the level of a good faith belief of danger to themselves.
Well, I suppose that begs the question, what is a good faith belief then? I mean, people believe in all sorts of things. You know, there's people that believe masks work for COVID, and there's people that say that they don't. There's people that believe in one religion versus another. And I don't, you know, I have a great respect for my colleagues that I serve with on the entire political spectrum. But I happen to know that there are colleagues of mine that their good faith belief is that private gun ownership is something that should not exist. I just wanted you to acknowledge that there's a portion of the population that believes that. And we're putting something into statute that says that that's a good enough reason to take someone else's firearms.
I think there are strong feelings on both sides of this particular issue, just as a person who observes it from the outside. You know, I'm a law enforcement officer. That's not you know, my focus. But you know, as a law enforcement officer, you know, I observed, and you know, there are 220 Superior Court judges in the state of Connecticut, all of which have to appear before this committee and delineate what their decision-making style is and what they use to make decisions that impact people in a variety of ways. And their job is to take the rules and their decision-making authority and make those decisions based on the laws that are passed by out of this committee and passed by the legislature. So, you know, there are judges who have to make these difficult decisions. And I'm not paying short shrift to your comment that these are very significant decisions. And I think that judges understand that and would take guidance from previous court decisions as to what this standard means and do their best to implement it in a way that does not unduly deny people their constitutional rights.
Well, I can appreciate that. I just don't understand why we need to change the current standard that we have, which requires the due process of law. Just, going back to a few years ago when we did the legislation on the one-sided ex parte TROs where firearms could be taken. I pointed out to several examples of cases where those restraining orders were granted. There was a Bridgeport man who applied for a restraining order and it ultimately was granted. I don't know what other circumstances were in it, but he wanted to prevent his future in-laws from coming to the wedding. There was a Monroe man who applied for a restraining order claiming his wife and mother were poisoning his contact lens solution, and it was granted. There was another guy who said that his dog was speaking to him in tongues. I don't want to reduce the bar of when someone's constitutional right can be taken from them, as well as their personal property. And sometimes in the case of firearms, it can be very valuable personal property, to a claim by another person, which may or may not be valid. And essentially that's what this legislation does. Would you say, Mr. Lawler, that this essentially, I don't know, it's hard for me to understand. I'm not a lawyer, number one. So sometimes I'm at a loss in this committee on what a legal context is, but I try and use my knowledge of our Constitution and common sense to try and get to the bottom of some of these things. Are we creating a crime in this legislation? And the crime is that someone else thinks you pose an imminent danger to yourself or others. And the reason why I ask it and put it in those terms is because, as Senator Champagne said, we are already imposing a penalty before any decision has been made about whether a crime has been committed. This must be the creation of a new crime. Would you characterize it that way?
No.
So if that's the case, then how can we be imposing a restriction on someone's freedoms or taking their personal property?
I don't understand the question.
Well, it seems to me that in our system of laws and justice, ever since the dawn of Western civilization, people are accused of crimes, but they're not punished until after the crime has been adjudicated. In this case, we are effectively punishing someone. And so to me, that means that we are establishing a new crime. You don't see it that way?
No, I believe that the statute would be civil in nature and would require, it isn't talking about putting anybody in jail for being a danger to themselves or others. That's a crime.
Well, respectfully, I'm sorry, I didn't mean to cut you off.
Civilly, until another determination is made, and that being based on a foundation of due process within a framework that has already been established on the civil side that meets these goals if the legislature deems it appropriate. So
is it your testimony that the taking of personal property or the restriction of one's right to defend themselves is less important than taking their personal freedom, like their ability to move freely by being put in prison?
I'm not going to equate one thing to another thing. The statutory framework that we've suggested, which we believe meets the intent of what this current bill is proposing, would be a framework that would be legal in the state of Connecticut and would effectuate, I think, the intent of what's proposed here.
I appreciate that. And again, I'm not trying to conflict with you, personally here in any way, shape, or form, but I believe you did just say that you said, well, it's not like we're putting someone in prison. And
It's not a
to
crime.
me,
It's not a crime.
right. Well, again, so if that's the case and it's not a crime, I guess, and I don't want to go back and forth on this, and I'm sure a lot of people have to ask a lot of questions, but if it's not a crime, then in my opinion, there should be no penalty either. And this is the purpose of due process in our state and federal constitution. So that's my final
asset
question.
forfeiture too. We take people, the asset forfeiture, which has been modified to a great degree over the last several years, the
Right,
government.
I'm responsible for that, Kevin. That was my proposal.
Senator, for a second, I'm just gonna, because it's happened a couple of times and I'm trying to give some leeway, but could we try not to overtalk each other in the exchange so that it's clear for everyone who's listening?
I apologize.
My fault, of course. I'm sorry. I'm excited and delighted to have this opportunity to be engaged in this conversation. So I guess my final question is, what do you say to the many, many people who are contacting me and writing testimony to this committee that I think are making a pretty clear and straightforward argument that this bill does not provide for due process as constitutionally prescribed?
I would say to them that I believe it does, based on some of the temporary restraining order, civil protective order legislation that has passed before. And again, I understand that this is a political issue and that there are folks who believe it's an overstep. I believe that's a political issue that should be discussed amongst yourselves and with your colleagues, and that there should be a vote on it. And if people believe that it is unconstitutional, that they would have their avenues to have that heard in a different form.
Yeah. Thank you for that answer. But again, I would make the same argument about the existing law. So can we just get to the bottom of how this satisfies due process, which, the 14th and the 5th Amendment both say no person shall be deprived of life, liberty, or property without due process of law. And in this case, we're certainly depriving someone of liberty and of property. And due process is described as, you're innocent until proven guilty. And clearly, in this case, you said there's no crime because there's no proven guilty. And so I don't get it. We're punishing someone for a crime that is not a crime, and due process hasn't been met. So that's all I would like you to do. I mean, you're a major proponent of this legislation, so I would like to understand how we satisfy the due process requirement of the state, other than to say just the current other unconstitutional law is proof, because it's not.
Senator Sampson, let me be clear. The Division of Criminal Justice has proposed this language in support of any particular position. This was presented as a potential issue that affects the Division of Criminal Justice, that the state's attorneys, Chief State's Attorney Colangelo, myself, and others intimately involved in these types of decisions attempted to present a workable format that, if it were the will of the legislature to effectuate something like this, that we would recommend that it be done in this particular fashion. That, we're not here advocating for anything other than we are discussing and providing advice to all of you who have to make these decisions, given our expertise in the area.
Forgive me that I didn't have a chance to read your testimony. I went online this morning to look at the testimony that's been uploaded. I didn't find it there. It may be, I just didn't see it. But my impression from your conversation with Representative Dubitsky is that you were here supporting this legislation. So forgive me if I'm mistaken. I've got no further questions, Mr. Chairman. Thank you.
Thank you. Representative Rabimbis.
Thank you, Mr. Chairman, and good morning, Mr. Lawler. Thank you for being here and providing your testimony. I'll certainly try not to be duplicative, but I think your last statement actually to Senator Sampson is kind of what I wanted to highlight, in the sense of that this is something that is important, obviously, to the Division of Criminal Justice in conjunction with several others, as you indicated. that kind of was a think tank of how to address these situations. And I believe in your testimony, and correct me if I'm wrong, you had highlighted the situation that had taken place in Bridgeport Police Department of an officer who certainly someone filed a complaint, so felt that they did not carry on the duties of the investigation. Before I dive into that a little bit further, can you highlight or share with us other incidents throughout the state of Connecticut that also led to this proposal?
No, I can't. I think that that's one that, as this was presented to us during the course of this session, that I was made personally aware of. Unfortunately, now that I'm working up in Rocky Hill, I'm not in court every day like I used to be when I was the state's attorney in Sonny Milford. So I haven't had the opportunity to be in the field and talk to some of the other prosecutors who are out there doing this type of work to find out about some of those other case examples. But, I think understanding the concerns raised in that one particular case and understanding the frailties of the human system that we all deal with, we can contemplate other situations where circumstances like this would arise.
And I certainly appreciate your candor and honesty in that regard, because I think it's important that even as legislators, whenever we raise or propose legislation, we try to get to what is the root of the problem that we're trying to address. And then we want to make sure that it's something that actually is an issue that can't be resolved with the current system that we have in place before proposing additional options. I mean, we've heard, and certainly we're not blind to the fact that many times having more tools in the tool chest, we hear that a lot and things of that nature, but we also have to weigh that on the unintended consequences, negative consequences that might be faced by a lot of law-abiding citizens throughout the state of Connecticut, never minimizing the certain deficiencies that may exist in particular departments and families who are terribly impacted as a result of that. So diving a little bit into the Bridgeport Police Department and understanding that even I have heard on several occasions, several investigations that may not have been handled the way that it should have been. And certainly there's been, issues and charges with the police chief that's a public record not too long ago, having read those articles. And I'm not, intimate on the details of that as well. But certainly it seems like there's a lot of things that maybe to dive into regarding the police department itself. When this issue was brought to your attention, this particular situation with the family, do you know how it has been internally handled after the complaint was filed?
I know that that matter is currently pending in the Bridgeport State's Attorney's Office, and that State's Attorney Cordino, who is new to the job there, I believe that this case occurred prior to his appointment as state's attorney, and then State's Attorney Schmieder was the state's attorney for that district. But I believe State's Attorney Cordino, in his capacity as state's attorney, has reviewed that matter and currently is reviewing that matter as a part of that underlying prosecution.
And thank you. And just for clarity on my part, when you say review that matter, review how the police department, specifically the officer, the police chief, any superiors handle the situation?
Well, I think in his role as the chief law enforcement officer in the Fairfield Judicial District, that would come under his purview. And that is, when I was the state's attorney in Milford, those were the kinds of things where you would have a discussion with the leadership of a particular department. I had one particular case along those lines that led to the tragic death of a woman by the name of Shingal Racine in the West Haven Police Department, where there were what I believe to be significant gaps in their response to her pleas for help due to language barriers, due to indifference, and many other things. As part of my role as the chief law enforcement officer, I interviewed everybody involved in that case. I developed a report. I submitted a report to the victim's advocate and to the police as well. pointing out those areas. So, that is something that we can do. I wouldn't want to comment on behalf of State's Attorney Cordino on the efforts that he's made to look into that situation, other than I know that he's very aware of it, that he has had discussions, that he has reached out on numerous occasions, including very recently with Ms. Lawler, no relation, and has discussed that.
Okay, thank you. And I appreciate that because I see it two ways. I believe I had heard earlier that the family is going to be speaking before us, and it sounds like they've certainly have gone through hell and back, and I would hate to have to subject them to these types of questions. But I also want to make sure that they're getting their issue addressed appropriately. And many times we have proposals before us that may or may not make it out of either the committee or the chambers. And I never like to leave families with hopes of having things resolved through the legislature if it's not going to be resolved because of the fact that many things don't happen to make it out. But I want to make sure that their issues are being properly addressed, not only in their situation, but certainly if that police department is not doing what they need to be doing, that's being further looked into if it hasn't already. And again, obviously being a representative of the Division of Criminal Justice and being important enough that to bring this proposal before us, I just hope that no matter what happens with this proposal, that this family and other families are being appropriately responded to. If in fact there are issues, because again, it sounds, and I don't know the details, that certainly these are allegations thus far, and maybe they've already been validated. But I think that that's important, especially in fact of the fact that this is bringing out a very thought out written proposal before us. So thank you for your testimony here today.
Thank you, Representative.
Thank you. If there's no further questions to the committee, I have a couple that.
Sorry, Mr. Chair, I'm trying to figure out, I have a couple questions if I may.
Okay, Representative O'Day.
Sorry to interrupt, Mr. Chairman, I appreciate it, and I will try and figure out my Zoom better, raising my hand. Mr. Lawler, thank you so much for your testimony and your service to the state of Connecticut. Truly, I know you've been asked a lot of pointed questions and you're doing your best to answer them, and we all greatly appreciate that. I just wanted to summarize kind of your testimony as I understand it. Basically, we're expanding who can apply for this risk warrant from a state's attorney or assistant state's attorney and 2 police officers to family or household members, correct, generally speaking.
Now, our revised, our recommendation here would be to keep the warrant requirement to just prosecutors and police, and that the opportunity for the others in the list as delineated in the legislation, that their opportunity to be heard be in a different forum, which would be the civil risk protection order under a separate scheme that would be similar in concept to the civil protection.
Got it. And the process going from lines 100 to 111, as I understand it, assume hypothetically a girlfriend or intimate partner, as described in line 132, makes a complaint and they have a good faith belief, which has been discussed here, that, that for example, I'm a risk to myself or others. They get the order, my firearms are taken after a hearing that happens initially, correct?
You would, if the person presented the appropriate paperwork in court, that they then presented evidence in court to the judge under the standards outlined in the statute, that a judge would then issue an order that you were not to possess or obtain new firearms. So this would not be like the warrant where a judge would provide an order to a law enforcement officer to go and get any weapons at a particular location or possessed by a particular individual. That order that you are not allowed to possess or obtain new weapons will be served by an indifferent, like a marshal, similar to the way a temporary restraining order is served now. And then a hearing would be held within 14 days, where the state would have to prove by clear and convincing evidence that that you pose a danger to yourself or others and that you possess those weapons. In that 14-day period, you would have to give up your weapons as prescribed by the law.
And so the good faith belief standard is for the initial form that's filled out that the state's attorney is going to develop. And then the hearing is within 14 days.
We're not involved in that. It's a civil protective order. That would be something that would be developed by the.
Gotcha. So then if, let's say at the hearing within 14 days, as I understand it, and looking at lines 100 to 111, I lose that hearing. For the sake of argument, it's me, or discussion, it's me, and I then have to wait 180 days before I can get another hearing. And then if I lose that, I then have to wait another 180 days after the denial. So that brings us to over a year, if my math is correct.
Correct.
And okay, so and I think I understood your testimony to questioning from Representative Howard that the state's attorney's office is amenable to addressing the concerns that Officer or Representative Howard brought up about the property being destroyed after a year by police departments. And I'm hopeful that we can work together to make sure that doesn't happen. And the state's attorney's office, you all will help us with that, as I understand it, at least based on what I've heard.
I think that would be appropriate if the committee felt that it was appropriate for us to assist in drafting language to that effect.
And then there's on lines 152 to 158, the chief court administrator shall develop and make available to the public in hard copy and electronically on the internet a form that enables a person to apply. That was what you're discussing. It's not the state's attorney's office, it's the chief court administrator, correct?
Yes, and again, I would liken this again to the temporary restraining order or the civil protective order system that we have now, where we issue criminal protective orders in criminal court, different standard, different rules. People approach the civil clerk's office for TROs all the time. We have nothing to do with that.
Understood. Thank you very much, Mr. Chairman, for your indulgence, and thank you, Mr. Lawley, for your testimony here today.
Thank you.
Representative Blumenthal.
Thank you, Mr. Chair, and thank you, Attorney Lawler, for your testimony and your service to the state. I'll try to be brief, as my colleagues have covered a lot of important ground. I just wanted to address a couple of issues that have been raised in some of the questions earlier. There were some questions about it being potentially problematic that this statute would create a procedure that might be resolved based on credibility determinations or conflicting testimony, colloquially referred to as he said, she said, or he said, he said. Would it be fair to say that criminal cases are proved beyond a reasonable doubt based on credibility determinations?
Certainly.
So we're not treading new ground in a civil procedure if potentially, an ERPO could be issued based on a credibility determination with conflicting testimony from two parties.
I'd agree in concept to that, but I think to be fair, it's kind of the opposite side of the coin from my testimony earlier, where I would hesitate to just say that based on this one particular thing, this would be the result. I think any case like this, as as a lawyer, the merits of a decision aren't based on only one thing, but on a whole host of factors that are very hard to delineate, but that judges struggle and do their best with in light of case law, in light of the guidance provided in the statute, to do what they believe is the right thing in a particular case. So I would agree that those types of determinations would play a role similar to the role that any other type of evidence presented in a case would play, and that whole kind of stew is what a decision would be made on, and not just one individual thing.
And I agree with that completely. That's very fair to say. And I guess my point is merely that, there are cases with a higher level of burden of proof that are resolved on those determinations. And it sounds like you would agree with that.
I would agree that there are certainly criminal cases where credibility of witnesses plays a very key role.
Okay. And I appreciated your testimony earlier with Senator Sampson's questions about whether this was, we were creating a crime or not. I don't mean to put you on the spot, but could you explain as briefly as possible, what kind of qualifies something as a crime versus not under our law? What makes something criminal penalty versus civil penalty?
Criminal penalty, the easiest explanation is there's the possibility of incarceration. Right? We have everything from a C misdemeanor all the way up to an A felony. This is not requiring any incarceration, and as our constitutional law clearly delineates, due process that's required based on the amount of process that's due increases with the sanction that the government intends to impose, with the highest due process required for criminal offenses and less for less serious matters. You don't get a jury trial on a speeding ticket. You don't get a public defender for a speeding ticket because that's not required for something where the state is being less intrusive. Now, I understand that people feel very strongly about this particular issue and whether or not this constitutes a limited invasion of people's rights. Again, that is a different discussion, but for purposes of constitutional law, we know that if it's a criminal sanction, the amount of process that is due is greater. You get a public defender, you get a jury trial, you get mandatory appeals. Those types of things kick in when the government is attempting to take your liberty with the law that's passed. This is not one of those.
Thank you, Attorney Lawler. And I think you mentioned something very important, which is that the question under due process is not only whether there's a due process right, but what process is due and when it is due. And I guess I would just ask under, I'm sure because you just essentially quoted from it, I'm sure you're well aware of the standard the Supreme Court has laid out in Eldridge versus Matthews. I'm going to ask a question that would take you outside of the criminal sphere into the civil due process sphere. So I understand if you don't feel comfortable asking it or answering it, but I would just ask if you are aware of a U.S. Supreme Court precedent that exists that has found that many property deprivations can happen based on an ex parte process, including garnishing of wages, seizure of secure private property, the denial of disability benefits. Are you aware of cases like that in the U.S. Supreme Court that have found those sorts of deprivations, those sorts of civil property deprivations, procedurally appropriate under the Due Process Clause of the 5th and 14th Amendments and under an ex parte process?
Right. I slept through a lot of civil procedures, so I don't know if it was a while ago. But I am aware of those general rules. They do equate to the rules we have in criminal law where we stick our toes on the civil side, which is asset forfeiture. The rules for asset forfeiture are different as far as what due process is required when we're going after a drug dealer's car as opposed to their person. So those types of things are different, but and they have been changed to a great degree to afford more due process, particularly here in Connecticut. But I am generally aware of the rules that you're talking about on the civil side. But again, that's why I became a prosecutor.
Yeah, I understand that completely. And so I didn't mean to put you on the spot too much. Just a few very brief questions. We were talking, or you were talking with some of my colleagues earlier about terms like good faith belief and probable cause. Would it be fair to say that in the law, those terms are terms of art? They have specific meaning that courts understand?
Correct. Particularly probable cause has been, is something that has definitive meaning under the criminal law. And again, that's why we point out that in the current iteration of this bill, that imposing a knowledge of what that really means on civilians who may be trying to present these types of things in court, where the judge knows what they need to look for, and the person who's writing out that affidavit or trying to present evidence in court doesn't understand that, is not something that we think would be appropriate.
All right. Well, thank you very much, Attorney Lawler. I really appreciate you being here. I think, I understand my colleagues' concerns, but I think, based on at least my knowledge of U.S. Supreme Court precedent, we're not treading new ground under the due process clause of either the 5th or 14th Amendments or protections in our state constitution. I appreciate your testimony. I appreciate all the questions. Thank you, Attorney Lawler, and thank you, Mr. Chair.
Thank you, Representative. Attorney Lawler, just a couple quick questions before I let you go, because we do want to get on to the rest of our agenda here. But as I understand your testimony, and I don't mean to mischaracterize it, but it's your testimony that both the statute is currently the bill as currently drafted and your proposal to break it out into two separate processes, one for law enforcement, one for for certain household members, that both of those proposals have sufficient due process protection built into them in your mind?
I think that they have sufficient due process protections. Again, the method of presenting by civilians in court under the framework of a statute designed for law enforcement, I think would be problematic. So yeah, I think it would have due process. I believe it would, but I think it would be a better way.
Okay. So your concern is not due process protection with the bill as currently written, but you think there's a more, so to speak, workable or user-friendly way to draft the household member application portion of this proposal?
I think that yes, the household member application portion where they are required to, under oath to state that they have probable cause and that they are then responsible for presenting evidence in court themselves under that standard would lead to some of the unintended consequences, I think, that our written testimony provides.
And I think there certainly was some pointed questioning on this, but I just want to be clear, and the record's clear, that the underlying bill or even the legislature's desire to raise this bill this year, that was not a proposal that came from the Division of Criminal Justice. That was not one of the list of, when you guys come in at the beginning of the year to the Judiciary Committee and say, hey, here's the things we.
Correct. This is not our bill. We did not write this. We suggested these as issues where we believe there may be a concern, and as we do on a host of bills, we suggest language which, if the legislature believed that this was a worthy goal, that this might be a better way to reach that objective. I would note, I think I testified earlier that we have proposed the change in the burden to return firearms in previous sessions from the person, from the government proving or the state proving that you do not pose a risk to the individual, having that burden by a preponderance of the evidence. So that is something that we have advocated for in the past, and we included in our testimony here, but this is not our bill.
So the Division of Criminal Justice has sought certain revisions or changes to the current risk warrant statute. Do you know whether there have been any major or significant revisions to the risk warrant statute since it was originally enacted by this legislature back in the late 90s?
I'm trying to think, Representative Stafford, and I can't think of any.
Okay.
Off the top of my head.
Okay. Do you know, since this legislation was enacted in the late 90s, and I believe Connecticut was the first to enact a statute like this, how many other states in the nation have enacted something similar?
I think it's like 35, if not more.
Okay. And is it your understanding that a number of those allow household members some opportunity to petition the court outside of the law enforcement context for the revocation of firearms?
I have not done any research in that area. So I really
Okay.
answer that question.
All right, great. Just last point on that. I know there was some discussion of a case. You brought up a case in Bridgeport. Do you know whether that's the only reason this legislation was proposed, or that you just know that in that instance, folks have raised that issue as perhaps a change in the statute could have addressed that?
I think as we have made proposals in this area or commented on other legislation, that precede that case, I don't think it's the only reason, but I would be, I wouldn't want to fashion a guess on that, other than that I know that in conjunction with our testimony here, I've been made aware of that particular.
Let me ask you, shifting gears, I want to ask you just one quick question on the other bill before us, which I believe you submitted testimony opposed to, which is the TASER bill. That bill, you may not have it in front of you, but do you recall what the effect of Section 3 of that bill was?
Yes, Section 3. Criminal possession of a firearm. Yes, it would take the electronic defense weapons out of that statute, so that a person who was legally prevented from possessing a firearm under those circumstances from also possessing an electronic defense weapon. So those people, they couldn't own a gun, but they could possess an electronic defense weapon without it constituting a crime.
So someone who is convicted of a felony, say rape, kidnapping, stalking, who is legally prevented from owning a firearm in Connecticut, if this bill were to pass, that individual would be allowed to own a TASER.
That's correct.
Okay. And as this bill is currently written, that individual would not have to pass a background check, would they?
That's correct.
Okay. So as currently construed, this bill, am I correct in saying that someone who was convicted of a violent felony could lawfully obtain, possess, and even use a TASER without any sort of registration of that TASER with the state of Connecticut, or without passing any of our state's background check laws?
I believe that would be correct. I believe that the state, or what the division indicated in our testimony, is that if that were passed, that we believe that there should be some sort of a permit requirement, whether it's the same, rise to the same level as a handgun permit. That would not be our purview, but that there should be some permit requirement for them to allow these to be possessed. And that certainly we would object very strongly to those types of electronic defense weapons being taken out of the criminal possession statute because of their ability to be misused in like an offensive manner by people who have proven through their previous actions that they are more dangerous if they were allowed to legally possess something like that.
Got it. Thank you. Representative Dubitsky, briefly for the second time.
Thank you, Mr. Chairman. I just wanted to follow up on the chairman's questioning. Is it legal for a person who has been convicted of a violent felony to own a crowbar?
A crowbar? Yes.
Okay. Is it legal for them to own a kitchen knife?
Yes.
Okay. Is it legal for them to own a baseball bat?
Yes, those would all be considered dangerous instruments, which the law defines as items that have a benign use, but under the circumstances in which they're used, they are used in a way that could harm another person. So the tire iron you use to change a tire, but if you used it to bash your wife's head in, it would be a dangerous instrument. I can think of no reason for the electronic defense weapon other than to impose pain on another person. So whether it's appropriately used or not would be different than I think the innocuous items that you list that could be used in a different way.
Okay, but a electronic defense weapon by definition is a defensive weapon.
Well, that's what they call it, but you know, you could say the same thing about any number of things. You know, it's only used for defense. You know, I mean, nuclear weapons are said to only be used for defense, but that wouldn't stop anybody from pressing a button and obliterating the city on the other side of the world.
Okay, but a crowbar or a baseball bat or a kitchen knife can all be used offensively too.
Correct.
And very often are.
Sometimes, yeah.
And
so have other purposes.
Each of those are used offensively considerably more often than electronic defense weapons in the state and the country, are they not?
At this point, yes, I think because most places ban them outright.
Most places do what?
Well, certainly here in Connecticut, currently they're banned outright.
Baseball bats are banned outright?
I'm sorry, the electronic weapon.
Okay.
Other things would be more because they're not banned, and so they would be used more than an electronic defense weapon, which currently is banned.
Well, in most of the country, tasers are not banned, correct?
Well, then I would stand corrected on that.
Okay, and in most of the country, bludgeons and knives are used considerably more often offensively than are tasers, aren't they?
I couldn't comment on what is done outside. It sounds like it probably will be accurate.
Okay. And crowbars and baseball bats and kitchen knives are not licensed in any way.
Well, I wouldn't say that. You're not allowed to have that type of item like a bat or a police nightstick or other certain types of weapons in a motor vehicle. You know, that would one of those weapons would fall under the parameters of a weapon in a motor vehicle. Knives above a certain length are regulated. And obviously, if you used any of those types of instruments in an attack, that would be prohibited as well.
Respectfully, that wasn't my question. My question was, they're not licensed in any way, are they?
Correct.
And their mere possession, for example, in your home, isn't regulated in any fashion. Is it?
No.
Thank you. Thank you, Mr. Chairman.
Thank you. And thank you, Deputy Chief State's Attorney Lawler, for being with us. We appreciate you spending the morning with us.
Thank you very much, and enjoy the rest of your Friday and the rest of the hearing.
Next up will be Frank Rossello. Is Frank Rossello with us?
Mr. Chairman, he is not here.
Okay. We will next go to Jeremy Stein.
Good morning, everyone. Senator Winfield, Representative Staffstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. I'm testifying in support of HB 6355 to improve risk warrants, a life-saving law that has been utilized in Connecticut for more than 20 years now and has been the foundation for similar laws in 19 states and the District of Columbia. The original law, known as the risk warrant in Connecticut and also referred to as the Extreme Risk Protection Order, or ERPO, around the country, was enacted in response to the March 7, 1998 lottery mass shooting, where a disgruntled employee went on a killing spree with a handgun, ultimately shooting and killing 4 senior lottery officials before committing suicide with that same gun. The shooter had a history of mental illness, issues, and previous suicide attempts, and possessed a Glock 9mm pistol. Had this law been in place in 1998, 5 more people would be alive today. Although this law was originally enacted to prevent another mass shooting, it has been widely studied and recognized as an effective means to prevent suicide by gun and is responsible for saving countless lives. This law has been utilized in over 2,000 cases in Connecticut to date. Had this law been enacted in 1989, my uncle, David Stein, might be alive today, and we could have prevented him from taking his own life with his firearm. My uncle was 61 years old when he was diagnosed with early onset dementia. He also suffered from depression. He had just been to the doctor's office and received the bad news. We knew he had firearms, which he believed he needed living in rural Maryland, despite evidence to the contrary. His wife and family, my cousin, did not believe there was any way to remove the guns from his possession. Had guns been removed, even for one day, he would have cooled down, he would have gotten help, and not committed a very impulsive and irreversible act of taking his own life. And that's what we're talking about here, saving lives. Numerous studies have concluded this law works. The analysis by many experts over the years have said that the risk warrants, they reach individuals who are at a dangerously elevated risk of suicide. They prevent additional suicide deaths by intervening in crises. They provide safe periods for subjects to obtain much needed treatment services. And they save lives by shifting suicide attempt methods from less lethal means. The Duke study, Yale study concluded that every 10 to 20 orders issued, 1 life is saved. A more recent 2018 study looked at Connecticut, Indiana's firearm seizure laws and says that this was associated with a 13.7% reduction in suicides by firearm. This warrant procedure provides due process as guaranteed by the 5th and 14th Amendment to the U.S. Constitution. The act of obtaining a court order before a neutral judge or the Superior Court of Connecticut ensures its due process under law. A gun owner is provided necessary constitutional protections by being afforded a hearing with an attorney if they choose, just like any other court proceeding. This law has been upheld by the Connecticut courts and courts around the country and has never been deemed to deny a gun owner's due process. This is also not an infringement under the Second Amendment. Any arguments that suggest otherwise should be disregarded. This order is only issued under the most extreme circumstances where harm is imminent and no other reasonable alternative is available to prevent harm. I am happy to answer any further questions about this. Just like any other court proceedings, there's going to be factual determinations. This law is effective. It can be improved in more ways.
Thank you, Mr. Stein. We do have some questions for you. Representative Fishbein.
Thank you, Mr. Chairman. Good morning, Mr. Stein. Did you submit written testimony? I didn't see that in the system.
I did email written testimony. I did not notice. I noticed that it wasn't on the website. I know when I submitted testimony both for the appropriations hearings and for the public safety committees that there was some delay, but I will work on making sure that my written testimony is on the website, but I do not see it on there right now.
Okay, and I think there's some glitches with this. You know, we're all trying to get used to this virtual world. You know, the individual before you, had submitted, but it came up under his agency's name, and we got to work out those glitches. But it may.
Yeah, I also, just as a note, I understand from the clerk there were about 26 people that were trying to also testify today that for some reason were unable to. So I appreciate your addressing that as well. I really do.
Okay, thank you. So I understand the underlying need or want for the legislation is to save lives, perhaps prevent individuals from doing harm to themselves as well as doing harm to others. I was looking at a lot of the backup last night, and the statistics about suicide. A lot of people suffocate themselves. Unfortunately, carbon monoxide poisoning. I noticed that we're only dealing with guns here. If the intent is to protect people from killing themselves, why wouldn't we be taking away, key fobs and those kinds of things to prevent those alternative means of doing harm? Why are we focused on guns here?
Well, I think that when we talk about guns, I mean, I don't think I know. When we talk about guns and we talk about suicide, the means matter, meaning the method in which people use some way to attempt suicide or ultimately complete suicide really matters. And when we look at guns being used in attempted suicide, studies show that people are 80% and higher successful in completing suicide. But when they use any other means to attempt suicide, that rate drops to somewhere around 20%. So we know that the gun and the access to the gun makes a highly volatile situation almost always lethal. And so that is why we are concentrating on the gun.
Okay, I'll work on digesting that. But moving to homicides, which is the other aspect of this, protect others from this individual. I note that as of 2018, the statistics in this country are comparing knives to rifles or long guns. It's about 6 times more knives than rifles. So once again, why just guns if we're looking to protect people? Why not go after knives as well? I'm just trying to get, I used to be anti-gun, just so that you understand it. And I try to balance those things here in the legislature. And, it appears to me that we're just focused on guns. Are we really caring about those potential homicides? So if you could explain once again why guns, if at least comparing rifles or long guns to knives, it's about 6 times more.
Well, once again, I mean, first, I'd like to point out this is not a anti-gun, pro-gun thing. This is about a law that is trying to remove guns from a situation where someone is at imminent risk to harm themselves or others, and in which, and this is important to note, and in which there is no other reasonable alternative to prevent that. And I think it's important that this committee understands that it's not just someone coming forward and saying, well, let's remove the guns because we don't like it. This is a situation where a judge is going to hear and make a determination of first probable cause and then clear and convincing evidence that somebody poses an imminent risk to themselves or others, and in which there is no other alternative. So that is what this law is focusing on. And as I said earlier, it is focused on both suicide, but also on shootings. To talk about knives, I mean, of course, we want to prevent all kinds of harm and death in Connecticut and elsewhere in the country. We have a lot of laws that criminalize using weapons against someone to harm someone else or possessing certain weapons, and we do regulate that. But once again, the suicide and mass shooting and homicide issue is a very much a gun problem. And when we talk about the suicides in Connecticut, knives are not high on that list. It is guns that like I said, are almost always lethal. And when we're talking about inner city violence, guns I think are the second leading cause of death among Black teens.
And you mentioned the judge would employ probable cause. You were here for the exchange before with Mr. Lawler. We were talking about good faith belief.
Correct.
So where does the probable cause get employed in your understanding of the procedure here?
Yes, so my understanding is that when the petitioner, whether it's the police or a family member, and we are looking to, or at least the law is looking to expand it, the law to allow family members and certain physicians and others to be able to petition the court directly. My understanding is that, at least the way the law is currently written, is that upon application, the court will then make a determination of probable cause before an order is issued. So I did hear what Mr. Lawler was talking about. I don't see in the law where that is mentioned, that lower standard. But I also think it's important to note that we are asking for a procedure that has worked over the last 20 years. We're looking to expand it if I don't think we're touching the probable cause determination, and then within 14 days there's going to be an even higher standard, which is that the court must find by clear and convincing evidence for that order to stay in place, which is a very high standard. And then if the gun owner wants the gun back after that 180 days, then I believe the standard is only preponderance of the evidence.
Now, you had mentioned that a family member under this proposed legislation would be able to petition the court. When you say family, this law, this permission extends to a son or a daughter-in-law, a brother or sister-in-law, no matter their connection to the individual. It doesn't have to be somebody who lives with them or has even been to the home. You would concur with that. And I'm specifically, just to orient you, lines 123 through 139.
Once again, I think that this is something that is going to be heard by a judge. This is something that is going to be heard on a case-by-case basis. And there does need to be a determination by that court that this person is in imminent risk of harming themselves or others with a firearm, and that there is no other reasonable alternative to prevent that. So I do think that when you have a parent or grandparent or mother-in-law, yes, that is the way the law is currently being proposed. But I think it is important to note that just because you are a relative to someone in that manner doesn't mean you automatically get an order. You still have to meet a burden of proof in which you have to prove to the court, certain things, that the person's in imminent risk of harm to themselves or others. So I don't think that who is allowed to petition the court is as important as the the burden of proof that is required to issue such an order. And I do think that someone who isn't in law, but that has intimate knowledge of somebody's mental state, or maybe have overheard something. And I think it's also important to note that right now, under the current statute, anyone can petition the police, like anyone. And I was actually present for a hearing, I think it was in 2019, in which someone's coworkers had overheard a man say that if he had been given a certain assignment, he was going to make Sandy Hook look like a joke, and that he was going to commit another mass shooting. His coworkers took this very seriously. They confiscated about 14 weapons, including various assault weapons. And then the man was afforded a hearing, and he had an attorney standing next to him to try to show the court that he wasn't at imminent risk to harm himself. So ultimately, the court did find that he was, and they confiscated his weapons, and probably saved a lot of lives in the process.
And in that situation, sir, the current system worked. Those individuals contacted the police inquired of the individual, they conducted an investigation, they asked a judge to order an at-risk warrant. The judge did. There was a hearing. The judge sustained the order, and potentially lives were saved. But we're not here on that today. We're here on changing that, expanding that, allowing other individuals on a lower standard, because an officer who was doing the investigation, in fact, I believe under the current statute, it can't be a single officer, it has to be 2 police officers or a state's attorney. They have to assert probable cause, they know of the standard, in their papers. Whereas an individual is contemplated by this new procedure or additional procedure is not held to that standard that the 2 police officers or the state's attorney are held, correct?
No, I don't think, well, look, that's a lot of questions. So correct, I do think that in that case, the law did work. So I do agree with you on that. Yes, we are looking to expand the law. As far as the burden of proof, I don't think that it is correct that it is a lower standard to be met by citizens that aren't police or state's attorneys. I believe that the way that the law is drafted is that the court still has to make a determination of probable cause before an order is issued. So I don't think that the standard is lowered at all. But nonetheless, the standard could be raised by the legislature, where it is more the procedure than the burden of proof that we're talking about here. And if the legislature feels that the burden of proof should be higher, then the legislature has the right to do that. What we're talking about expanding also is not just that portion of it. What we're really talking about is one of the features which we learned as a direct result of that hearing was that the court can only issue an order for a year, right? And so in that circumstance, after that expiration period of that order, right, after that year, the gun owner would automatically get their guns back, regardless of any type of hearing or showing that this person may or may not be still at risk to harm themselves or others. So you take that same scenario where someone's saying he's going to commit the next Sandy Hook and kill a lot of people, including children, and then a year later, he may still want to do that, and we're just going to give the guns back to someone that may have a severe mental health disorder, or may still be threatening to commit harm, or may harm himself. And one of the things that we are asking this law to change is that there just be a determination by the court that this person is no longer at risk to themselves or others before firearms are returned, or before this person is allowed to possess firearms, which is upheld by many courts, including the Supreme Court, which says that the state has an absolute right to be able to regulate who has firearms and to prevent firearms from being in the hands of dangerous people.
So, sir, what prevents law enforcement from, prior to the expiration of the at-risk warrant, inquiring of individuals that previously attested to or perhaps testified as to the infirmities of the individual, their risk to public or to themselves, and reapplying for an at-risk warrant? What portion of the law prevents that activity?
I think the portion of the law that prevents them is the portion of the law that says that this warrant can only be issued if somebody currently possesses a firearm. So the way that the risk warrant is written is that this applies, in order for the court to issue this, I believe that the court must make a determination that someone is in possession of a firearm. And so if they are not in possession of a firearm, then the court technically cannot issue an order preventing someone from getting a firearm in this situation, which is another reason why the law should be expanded. The courts should have the discretion to issue this order in exactly the circumstances that you describe, Representative Fishbein, so that the court could issue the order to prevent someone from obtaining firearms where they don't currently possess it, and in which they may have the ability to possess firearms.
So would you, because that shifts the onus to the complainant who
Correct.
originally made, would you be in favor of that? Because the way this is drafted, you're putting the onus on one petitioning to get back.
I think that the way that the law is drafted is that the burden would be on the gun owner. And that has been upheld around the country in risk warrant type laws as well as others. I believe that is the state's attorney's preference. When we spoke to the state's attorney's office, their opinion is that is the best way to enforce this law is to put that burden on the gun owner, the person who wants to get their guns back. The legislature could, if they wanted to shift that burden, put that burden on the state. But I think the most important thing is that there is a determination by a court, one way or the other, before the guns are automatically just returned to someone who may still be at risk to kill themselves or others.
Can you just, I know you said that this system of putting the burden on the gun owner has been upheld by courts, I would have to assume, in other states. Can you just give me like a state or a site? Because I'm unaware of that. I thought this was...
Yeah, Indiana, if you look at Indiana, Indiana has a law that, in fact, in Indiana's case, in the state of Indiana, I believe that the way that the law is written is that the law is in effect, that the order to remove the guns is in effect until the court orders otherwise, and that the police shall retain the weapon. And then I believe even their law says that after 5 years, the court can order the weapon to be destroyed if they don't hear from the petitioner. The case, our law has been upheld, if I can find it. I believe it's Hope versus State, which is a case that you can look at.
Yeah, I'm aware of that case.
And that has upheld our laws and has stated very clearly that this law is constitutionally sound, that it is protected under the Second Amendment, that it does not infringe on anyone's rights, and that under the Heller decision that these risk warrants can be enacted by states.
Yeah, but that's a different issue than what we're talking about.
Yeah, I think Indiana, and I'm not sure, I don't have a site, but I think if you are going to look at state law, Indiana would probably be your best bet.
And in Indiana, they allow third parties to petition for these kinds of warrants, at-risk warrants?
I believe so.
Now, bringing us back to the good faith, that gatekeeper function, to be able as a third party to apply for one of these things. I want to give you a scenario. So a few months ago, I represented a woman who she had unfortunately been beat up by her boyfriend. He was arrested.
I'm sorry, you represented, I couldn't hear you, Representative Fishbein.
I'm sorry. She was unfortunately beat up by her boyfriend, and he was arrested. He got a criminal protective order against him, keeping him away from her. And of course, as a result of the criminal protective order, any firearms that were in his possession, he would have had to surrender. Well, the next day he went to family court, and he got a family violence restraining order against her. Court found probable cause. And as a result of that, her firearms were taken away. She was defenseless. Now, she had a hearing on that within 14 days. It was about 2 weeks later. But in that period of time, she was held. She was defenseless from this gentleman who had actually beaten her up. Under this system, as is proposed, he would have been able to petition for that at-risk warrant at a lower standard than we presently have for our family violence restraining orders. So that would be the process. Good faith belief would allow him to petition. So how do I wrap my arms around that? You know, it was tough to get, it wasn't that tough to get the restraining order vacated because he made everything up. But I would want to be able to go after him for making that stuff up. Here, good faith belief, you're not going to be swearing to an affidavit other than you have good faith belief. So how do I wrap my arms around that lower standard?
So once again, Representative Fishbein, I don't think that the standard is lower. I think that the law as written and as proposed states that the court is going to make a determination of probable cause, so that the standard is exactly the same as what it is now. And I think that the other part of your question is that, look, as Representative, not Representative Lawler, but as Mr. Lawler said, not his brother, the other Lawler, people lie in court all the time. People are going to lie before you in this hearing. I'm sure you've heard people lie right before you. But we have laws in place to prevent that kind of lying in a courtroom or in a sworn statement or giving a police report. And those laws are giving a false statement, which is, I believe, a misdemeanor in the state of Connecticut, as well as perjury. If you lie before a judge, if you are sworn to lie, sworn in and you lie before a judge, that is perjury. And I believe in Connecticut that is a Class D felony, which is punishable by 5 years in jail. So it shouldn't be taken lightly that people lie before a judge or a police officer, or even before this tribunal. I think that that we need to make sure that people are protected from that kind of mistreatment. But we do have laws in place to protect that, and those have been in place for every law that we have on the books. I don't think one isolated circumstance should prevent us from the other hundreds of cases of people who are killed every year at the hands of a domestic abuser with firearms, because that's the simple truth, is that most people, if you add a firearm into the mix with domestic abusers, that is going to make a volatile situation almost lethal, which is the same thing with suicide. if you add a firearm into the mix of suicide, it is almost always going to end in death. And the point of this law is to remove firearms from that situation. And we also have separate laws for domestic violence. But the idea is get the gun out of the hands of someone who's going to kill people immediately with due process protections. Because if we don't act, lives will be lost.
And when you speak about due process, the procedure here usually is that the respondent doesn't know that this order is being sought against them, correct?
I think in most cases the respondent does know, because once again what we're dealing with is a standard of no other alternative, reasonable alternative is available. So in all of the cases that I have heard about, there is always an attempt to remove the guns without court intervention. In other words, especially with family members, it's the pleading with the family member and saying, please, you have dementia, give up your guns, or the police are going to come and take your guns away unless you give them to a friend or your gun club or something like else. So other reasonable alternatives have been exhausted, and that is one of the standards that the court finds. Now, I think what you're talking about is the ex parte portion of this, which is that the police currently can go to the court without the gun owner being present, and the court hears the evidence without the ability of the gun owner being able to present their own evidence. Is that what you're referring to, Representative Fishbein?
Yeah, in fact, there is no evidence presented, sir, when the petition is originally sought. It's a piece of paper.
Well, that is evidence. I mean, they also aren't.
Well, evidence, no, nothing. It is not evidence, sir, unless it's cross-examinable. So it's an affidavit. It's a document. It is of some support that a judge should have reliance upon it. But as you, sir, indicated, people lie. And your remedy for that lying is criminal charges. And you would agree with me that I, as an individual, cannot bring criminal charges. I have to have the assistance of the police or state's attorney's office, correct?
Or the court can sua sponte issue an order of contempt.
Well, that's not a criminal proceeding, sir. So,
well, there's criminal and there's civil contempt.
Yes. So there has to be an order in order for there to be a contempt. So if somebody has lied on an affidavit, the court can refer it to the state's attorney's affidavit for possible investigation. I've had those cases. Or the respondent can go to the police and make a complaint, but that's discretionary. I've had that where I represented a police officer who the wife made allegations against him that were totally unfounded. But under that scenario, sir, when somebody lies, makes up stuff to attain an at-risk warrant, criminal proceedings require a third party, correct?
In order for criminal proceedings to be brought, the state's attorney or the police would have to initiate.
But this legislation for the issuance of the at-risk warrant to begin with would not require the police or a state's attorney, correct?
Well, this is not a criminal proceeding. This is not the same thing. This is there's no crime attached to this. And I think, to go back to your point about the police discretion, you're absolutely right. In those situations, the police and or the state's attorney's office would have discretion to decide whether or not to bring a criminal charge, under your scenario. And I think that is exactly what the expansion of this law is talking about, is that there are scenarios, and I think you're going to hear from Jen Lawler, who is going to talk directly about that discretion. And I think that is the idea of this law, is that that we want to give citizens access to the court directly, and still the court would make a legal determination. It's not just a citizen filing an affidavit and you get an order. There would be a legal determination by a court, and the court can hear evidence in that case, can hear testimony from a person if they choose. But I think the idea is that there are people who either don't trust the police's discretion, think that the discretion of the police might be wrong, or there are people that just don't want to go to the police. There are communities where people are not comfortable with going to the police. And I think in those scenarios, and this is something that has been expanded in 19 states and the District of Columbia, and the way that it has been expanded around the country is typically this civil route where citizens are allowed to petition the court directly without having to go to the police or state's attorney. Now that's not to say that they shouldn't go to the police or state's attorney. I mean, I think to your point, it is important to have investigation into these matters. But the idea is to expand the law, and as Representative Rabimba said, have another tool in the toolbox.
I thank you, and thank you, Mr. Chairman, for the opportunity.
Thank you. Representative Blumenthal.
Thank you, Mr. Chair, and thank you, Attorney Stein, for being here with us today. Appreciate all your work as well as your testimony, and I will, again, try to be brief. You spoke earlier about other states that have similar laws to the ones that have been proposed today. Would it be fair to say that all the provisions in the bill before us today exist in some other state?
Yes, the only aspect that I think may not exist in the state is the triggering of a hearing that we're proposing in Connecticut. I believe because in Indiana, I think is the closest state that has something similar. In Indiana, the order is good until the judge issues otherwise. So in other words, that law, that order, that seizure remains in effect. And we're looking to change our law to be more similar to that, because ours has a 1-year expiration period. So we could change it to that type of law also, to say like the order exists until the court issues otherwise. But because we have that 1-year expiration period, we're looking to expand that so the court has greater discretion in which they can order it, under what circumstances the court can order it, how long they can order it for, and under what circumstances would a gun owner get their guns back.
Okay, so would it be fair to say that that provision you were talking about is more protective of the person's gun rights or less protective than the Indiana law?
I think it is more protective of the gun owner's rights, because it allows the gun owner to petition the court after 180 days, but also under the proposed law, under the language, I believe that the standard of proof is lowered for the gun owner, and so they only have to meet a preponderance of the evidence standard as opposed to a clear and convincing evidence. So it actually would be a lower standard for the gun owner to get their guns back after it's already been removed.
Okay, and all these provisions that exist elsewhere that are in this bill that exist in other states, have any of them ever been found to be unconstitutional in the Second Amendment or any other provision of the Constitution?
No, this law has been upheld by the high courts of Connecticut, and has been upheld, and it has never been deemed in any state around the country to be unconstitutional, either under the Second Amendment, the Fifth Amendment, or the 14th Amendment.
So would it be fair to say that while we were a leader, if not the leader, on extreme risk protection order statutes, when we promulgated this one, that, you know, we're playing a little bit of catch up here and trying to get ours back to the state of the art?
Exactly. And this law was written more than 20 years ago for a very specific set of circumstances, and it has been used in a way that has been saving lives. And like I said, this has been used over 2,000 times. And if you consider that for every 10 times it's been used, a life has been saved, that's a lot of lives saved. This is a very effective law. And other states have taken our law and used this as a foundation to create their laws and to make it better. And one of those areas that we think it's been improved on is the under what circumstances can this be issued, and for how long the order should last, and whether or not family members or physicians or other people should be able to directly access the court. So yes, it is time to look at this law and to improve it, and to make sure that we make appropriate changes that are going to save more lives. That's really what this is all about. It's about making sure that we save as many lives as we can. And I think that Connecticut has once again proven that we are a leader on this issue, and that we will continue to be a leader on this issue.
All right. Well, thank you, Attorney Stein, for your testimony today. Thank you, Mr. Chair.
Thank you. Attorney Stein, just super quick. You keep mentioning the Indiana law. Out of curiosity, do you recall the governor of Indiana who signed that into law?
I don't.
All right.
Do you?
I believe it was then Governor Pence, but Representative Dubitsky.
Thank you, Mr. Chairman, and thank you, Mr. Stein, for coming in. First off, I wanted to talk to you about the standard. You had said that you believe that the standard remains the same and it's still probable cause. Right now, under the current law, a complaint can be issued by any state's attorney or assistant state's attorney or any two police officers. Is it fair to say that each of those people has been trained in what probable cause means?
Well, I mean, that's a very broad question. I cannot speak to what kind of training a police officer has or what kind of training a prosecutor has in a given situation. I would assume, and I would hope, that the police and the prosecutors are trained on what probable cause is, just as every attorney is trained on what probable cause is. But that standard probable cause is something that is taken on a case-by-case basis, and is a factual determination. It is, as I think Representative Blumenthal said earlier, it's a term of art.
Well, but it's a legal term, and those particular individuals are charged with the task of determining whether probable cause exists, right?
It is ultimately the court that is tasked with whether or not probable cause exists. But yes, I mean, I think where you're getting at is that police every day have to make those probable cause determinations when they are making arrests.
Well, it's actually those individuals who are charged under the law, because they shall not make a complaint unless they have conducted an independent investigation and determined that such probable cause exists and that there is no reasonable alternative available. That's the current law. So it's their determination of probable cause as to whether or not a complaint gets issued, right?
Are you talking about the complaint, or are you talking about the initial application, or are you talking about the actual order that's issued by the court?
I'm talking about the complaint that is submitted to the court.
Yes, they must believe that they have probable cause in order to submit the affidavit, but ultimately it will be the court that makes a finding that they have met their burden before any type of order shall be issued, and that is the protection that we have available in our court system, not only with this law, but with many other laws that we have.
Okay, so at the moment, these professionals, the state's attorney, the assistant state's attorney, or police officers are required to conduct an investigation and with their training, determine whether or not probable cause exists and there is no reasonable alternative.
That's
the
correct.
current law.
That's correct.
Okay, and under this bill, we eliminate all that and we say any household member or family member can submit a complaint without the investigation and without a determination of probable cause.
No, that's not correct. So I understand. I think I understand your question, but I think I need to clarify. The order can't be issued until a judge determines that there is probable cause. So regardless of what a police officer or a state's attorney may think, it is ultimately the court that is responsible for making the determination, a legal determination, that probable cause has been found.
I'm not talking
that still would apply if a family member applies for this warrant, fills out an affidavit. There would not be the same investigation by the police or the state's attorneys by law, but that does not mean that it can't still happen.
Respectfully, Mr. Stein, you're talking around my question. My question is with regard to submitting the complaint, not with regard to the order, with regard to submitting the complaint. Right now, a complaint may not be submitted unless the state's attorney, assistant state's attorney, or police officer conduct an investigation and determine that there is probable cause to believe that probable cause exists and that there's no reasonable alternative. So before a complaint can be submitted to the court, those things need to be established to that standard. And under this bill, in order to submit a complaint, those would no longer be applicable.
It would no longer be applicable to people other than state's attorneys and police officers.
Right. So now we have a family member or a household member that can submit a complaint without probable cause and without an investigation and without there being no reasonable alternatives available.
They would be able to submit a complaint, correct?
Right. And the Division of Criminal Justice has interpreted the language of this statute to mean that because those individuals, the family or household members, are typically not trained in what probable cause means, they interpret it to be a good faith belief. So the court would be issuing an order based on whether or not this person has a good faith belief that a person poses an imminent risk of personal injury to himself or herself or others.
I don't think that's correct, and I think I think you're with all due respect, Representative Dubitsky, I think you're misreading the law.
I'm reading it exactly the way
Gentlemen, I'm going to step in. I've given some leeway, but we're again talking over each other, which is making it hard for the transcript. I would also remind both of you that we have a number of folks signed up to testify today. We do want to get to hear from the rest of the public. And Representative, I would just submit that I don't know that it's fair to ask this witness to comment on or characterize the testimony of a previous witness. With that, Representative Dubitsky, you have the floor, sir.
Thank you, Mr. Chairman. Are you familiar with the suicide statistics in Canada?
Which statistics are you referring to?
I'm referring to the statistics where when firearms were banned essentially in Canada, suicide skyrocketed by other means. Are you familiar with that?
No, I'm not.
You may want to educate yourself on that. I think that's it for now. Thank you, Mr. Chairman.
Thank you. Further questions from the committee? If not, Mr. Stein, thank you for being with us.
Thank you very
Next
much.
up will be Representative Steinberg. Representative Steinberg, are you still with us? All right, we are going to skip him and come back. Next up, we will have TJ Elgin. TJ Elgin with us? All right, we're going to play a little ready golf here. Jason Levy. Jason Levy. Mr. Levy, I see you. Go ahead, sir. You have the, if you can unmute yourself, you have 3 minutes. You have the floor.
Hi, yes, thank you. Just to state for the record, my name is Jonathan Walsh. Jason Levy is unable to make it and ceded his time to me. So I'd like to speak directly.
Sir, I gotta stop you. We can't get into that because of the record and the transcript. We're not jumping around. We've told other folks they cannot do that in this committee.
I was unaware of that.
Yeah, I'm gonna put you on mute. We'll have the administrator reach out to you and we can try to slot you in back towards the end. All right.
Great, thank you.
All right. Next up, then I have Irene
Scribilo.
Ms.
I'll
Scribilo,
spare you a little with that name.
Yes.
Members of the Judiciary Committee, my name's Irene Scribilo. I live in New Milford, Connecticut. I'm speaking today in support of HB 6355, an act concerning risk protection orders. You've all heard the statistics that red flag laws are on the books in 18 states and in Washington, D.C. In 12 of those states, family members can directly petition the court. Currently, family members approach the law enforcement in at least 40% of these cases seeking firearm seizure orders. Residents and medical professionals need to be able to go directly to the court, and this will translate into lives saved. Many will say, oh, the government's infringing on my rights. This is not really the whole picture. These are mothers, sisters, wives, and brothers, and loved ones who are seeking to stay safe and keep loved ones from self-harm. They're the ones asking for protection. This law has been shown to lower the incidence of firearm suicide and gun violence. It's especially necessary now in this time of isolation and increased mental stressors. Some people testifying may bring up Gary Willis in Maryland in 2019 as protection order gone bad. Few will mention that he threatened his brother's wife, his brother, he lived with his mother, he threatened her, and other family members with violence. According to police reports, the night he was shot, Willis reeked of alcohol and reached for a gun after police officers had come to his door to speak to him. It looked like he was going to shoot them, basically from their report. I'd also like to talk about Mark Rutkowski of that same year. The Pasadena man was charged in early September 2019 with making a threat of mass violence against his workplace. When officers served a red flag order at his house, they found 146 guns, including assault-style rifles. Rutkowski lived with his 83-year-old father. I know someone who took his own life. He had tried to kill himself on several occasions, and as Jeremy mentioned, a gun is what did it. He was on antidepressants and he owned several guns. He had two little boys. I mean, they're older now. but he had 2 boys and a wife. His wife knew there was a problem. His doctor was concerned, yet they could not intervene. His life could have been saved. Please vote yes on 6355 and save a life. Thank you.
Thank you, ma'am. Representative Davitsky, do you have a question?
Thank you, Mr. Chairman. And thank you for coming in. I think we can all agree that the goal of all of our statutes is to protect people and save lives. But I think one of the things that you may be missing is that women, mothers, daughters, abused spouses often try to protect themselves with firearms. And let me ask you, if this bill passes and a man who has been beating and abusing his spouse is being kept from her because she is now armed herself against him, would this bill not make it now easy for him to just go into court and get a court order to remove her firearm and to disarm him and allow him to get at her where she had been previously protecting herself?
I actually know of women who have been in this situation, and no, they did not arm themselves with guns. What they did was they went through the legal process. As you said, we have laws in place, they have safe shelter, things worked out. You know, what you're saying is a hypothetical that, you know, if you have kids in the house having guns, it's probably not a great idea. I probably know how you feel about that, but I feel pretty strongly about that too. All I know is there was a 7-year-old little boy who went to his father's funeral. He couldn't see his father in the casket because half his head was missing. That could have been prevented. And that's what we're trying to stop here.
Okay, but we have had risk warrant bills up before, and we have had dozens and dozens of women come and testify, abused women, people who have been beaten, women who have been beaten within an inch of their lives and have armed themselves to protect themselves from their abusers. And under this bill, it would make it very simple for their abuser to just go into court without any police investigation and get an order to disarm their abused spouse.
Aren't you concerned that you're putting these?
I'm sorry, we are going to hear that
hold on.
testimony.
Representative, let me interrupt, ma'am. You gotta let him finish his question.
Okay.
But Representative, if again, we've got a long hearing ahead of us. If we could get to the question and try to limit the commentary, or that would be appreciated. Thank you.
Thank you, Mr. Chairman. When you are talking about saving lives, aren't the lives of the abused women that are being disarmed and made vulnerable, aren't they important too?
Are you done? I think it's a little disturbing that you're urging battered women to arm themselves. They have alternatives. You should be steering them towards more helpful situations that can help them get to safety. That's my only comment to you, sir.
Okay, well, I'm sorry that's your only comment, but thank you very much, Mr. Chairman. Thank you for
I'm
coming
sorry
in.
too.
Thank you. Representative Papalek-Tomato, are you good?
Yeah, just a quick comment. I just wanted to say I actually do have this situation now with a client. It's not a hypothetical for us who do practice in this area of family law. Wife has a gun, and husband is getting very close to, well, you don't know what he's going to do, right? And unfortunately, a piece of paper, as I tell my clients, a piece of paper is not going to save you. I agree, ma'am, and I thank you for your testimony that the legal process is the way to go. But in the moment, if somebody, a husband comes in the door attacking the wife, that's what she has. The legal process at that point isn't going to help her. So, I mean, if that's something we can work on, but I just want to let you know these are real situations, unfortunately, that actually do occur. And but again, I thank you for your testimony.
Am I allowed to comment on that, or?
I welcome it.
Go ahead, ma'am.
By the same token, what about the woman who's trying to shield her children? I actually know someone who shielded her children from a violent husband, and she was shot. She was shot in the hand. Her father was shot in the elbow, and this all happened in front of her child. I mean, you can turn that around. There's so many different ways. As Jeremy mentioned, Mr. Stein mentioned, there's a process, and hopefully if it's a violent individual trying to take guns away from, an innocent woman, hopefully the judge will stop that. I'm not a lawyer. I don't pretend to be, but there are things in place. I just don't think that arming people is necessarily the answer. I know I might be on the minority here, but that's how I feel, and that's my stance.
Thank you.
Done.
Thank you both. Representative Bimbis.
Thank you, Mr. Chairman, and I'll try to make it brief. Ma'am, I certainly appreciate your testimony, and I'm not exactly sure that the questions that were posed by Representative Dubinsky was necessarily advocating that women bear arms, but certainly there are women who choose to bear arms, and I think that's what we're trying to take into consideration when we're looking at developing a new proposal that essentially, whether you're a woman or a man, would certainly put into question their ability to rightfully bear arms if there are false accusations made. I believe you had made in your testimony reference to statistics of the number of states who have similar language that's being proposed here now. Is that correct? And could you repeat that?
The red flag laws on the books in 18 states. Again, I'm not an expert. You can ask, I think Mr. Perlow is going to be testifying later. You can refer that question to him. I'm just a citizen speaking my mind.
Okay, and I'll be happy to refer that question to him, but I'm referring it to you because you're the one who had it in your testimony.
Well, I don't have that. If you give me 20 minutes, I can Google it and find it.
No, that's
Sorry.
fine. I certainly don't want to ask you to do any additional work. Just wanted to make sure that you had the opportunity to back that information, because what I was going to follow up, and I'll ask the question, and you may not know it. Are you familiar with the current laws that we have on the books regarding risk warrants in the state of Connecticut?
Not personally, but vaguely. Again, I'm not a lawyer. I haven't been involved in this. All I know is I know a couple of people that have been affected by gun violence, specifically gun suicide. That's why I'm here.
And I want to thank you for taking the time and the opportunity, certainly as a citizen, to come and share your thoughts and your beliefs on what you know to be certainly the information that you have. So thank you. Thank you, Mr. Chairman.
Thank you. And thank you, ma'am, for being with us. I appreciate your testimony.
Okay, thank you, sir.
Representative Steinberg is next.
Thank you, Mr. Chair, and thank all members of the committee for taking up this legislation today. I apologize in that I was in another committee meeting and did not have the opportunity to hear the testimony and the back and forth that occurred with those who've already spoken with you. I'm here to testify in favor of both the bills before you today, but particularly to focus on the 6355, the risk protection order of warrants. I've been in the legislature long enough to remember very distinctly the day that not only we all lived through the difficult times of Sandy Hook, but the really landmark moment for this legislature in this state when we passed some of the strongest sensible gun reform laws in the entire country, and we're a leader. And I submit that the bills you have before you today are very much in that tradition. This committee has been extremely deliberate about the bills it's brought forward every year subsequently to continue to address some of the concerns we have about the use of guns in our state. And particularly with regard to this bill, which is a logical and necessary extension of legislation that we have passed recently to deal with a very difficult circumstance whereby individuals are put in a very challenging position vis-a-vis others. And I'm really here just to testify to say that many of us in the legislature are extremely gratified by the hard work this committee is doing and the challenges faced in trying to extend legislation such that it deals with perhaps unlikely or only occasional circumstances. But in those circumstances, that lives are at stake and that it is worthy of this committee and the entire legislature to do all within its power to assure that we avoid circumstances where lives may be lost, accidents or bad events may occur. And that I just wanted an opportunity to express my support and to suggest that the work you are doing this year and every year have been critical to the safety of the people of the state of Connecticut. Thank you, Mr. Chair.
Thank you, Representative, and certainly we always appreciate having you before the Judiciary Committee, particularly when you come here to flatter us. So any questions from the committee? Seeing none, thanks for being with us, Representative Steinberg.
Thank you, Mr. Chair.
Is TJ Elgin with us? Mr. Elgin, TJ Elgin. We've tried a couple times. Last call for Mr. Elgin. If not, we will go on to Walt Cupson. Mr. Cupson, you have the floor, sir. Mr. Cupson?
Sorry about that. I forgot to unmute. So my name is Dr. Walt Cupson.
Your video's turned off if you want to turn it back on. There we go. All right, we got video and audio now.
All right, thank you very much. My name is Dr. Walt Cupson, and I'd like to testify in support of House Bill 6491, the act concerning non-lethal electronic defense weapons. There are many people who would like to be able to carry a firearm, and some that don't wish to carry a firearm, and this gives them an excellent ability to defend themselves without it. And all I need to do is just reference the Supreme Court case Catano versus Massachusetts, where it found that laws restricting non-lethal electronic defense weapons were unconstitutional, that the Second Amendment does extend to all tools and instruments that can be used for self-defense. And you know, I didn't hear all of the testimony earlier from Deputy Chief State's Attorney Lawler, but there was a comment about how or an insinuation that tasers didn't have any legitimate purpose. And I would ask, well, then why do police officers carry tasers? I'm also testifying in opposition to House Bill 6355. And I could go on for well more than 3 minutes as to all the reasons why I feel this quote so-called enhanced red flag law is egregious. And I would point you in the direction, all of you, both those who support this bill and those who oppose this bill, to reference United States Senate Judiciary Committee, the full committee hearing on red flag laws that occurred in March of 2019, and the written testimony of David Koppel to talk about all the flaws in the arguments for these red flag laws. So for instance, the claim of 10 to 20 prevented suicides for each ERPO that was issued. Well, some of the studies show that that, especially in Connecticut, any reduction in firearm suicides was actually offset by an increase in non-firearm suicides. In fact, there were several other methods that were found to be just as likely to result in death: asphyxiation, hanging, et cetera, et cetera. And these studies also pointed out the fact that they included any attempt at suicide, even if it was not lethal. So the numbers are quite flawed. That's just one aspect of how I think this bill should absolutely be opposed. The ERPO law that we currently have is already working, okay? And something like 32% of the confiscation orders in Connecticut were overturned. That's not a small number, and that's data from Connecticut in 2014. So when you look at the number of people who could be saved versus the number of people that are found to not be deserving of an ERPO, that to me is a number that's not conscionable.
Thank you, sir. We're at the 3-minute mark, and I do believe there's questions for you. Representative Dubitzky.
Thank you, Mr. Chair, and thank you, Doctor, for coming in. Could you tell us, you said that there are people who would like to be able to defend themselves but don't want to carry a firearm. Can you expound on that and tell us why somebody would want to carry something other than a firearm to protect themselves?
Sure. Now, I don't personally, in all transparency, I don't know anyone, obviously in Connecticut, who carries a stun gun. But when you think about it, someone who has someone who's smaller, okay, someone I'm imagining, a person who is not comfortable with the sound or the idea of carrying a firearm, and so a stun gun like pepper spray or any other method of self-defense could be utilized. That person may decide that they don't ever want to potentially kill anyone, but they still want the ability to defend themselves. Someone who, say, has one hand, okay, a veteran, an amputee, someone in a wheelchair. I think you can go on and on to consider all those people who would want to have the ability to defend themselves, but either can't or would choose not to use a firearm.
Okay, well, thank you. Now, with regard to the changes to the risk warrant statute, you'd say you could go on forever. Well, we certainly don't have time for that. But if you didn't have time in your first 3 minutes to give a little synopsis as to why you believe that expanding this to allow any family member or household member without probable cause and without an investigation, I'd love to hear it.
Right. So, I was really amazed at the exhaustive list of people who could file a petition, including, spurned spouses, spurned ex-partners. It just read as a laundry list of potential abuses. And that's fine if those folks have a legitimate concern, but you're removing the police from the investigation. I mean, to me, that's unconscionable that you wouldn't have a independent party to look into probable cause and to conduct an investigation. My fear is all it would take would be one word from a spurned partner to the judge who's going on one side of without any evidence. That to me really surprises me and disheartens me.
Well, thank you very much. I appreciate your time, and thank you for the good work you do. Thank you, Mr.
Thank you.
Thank you. Seeing no further questions, thank you for being with us, sir.
Thank you. Have a good day.
Next up will be Paul Bartolomeo.
Bartolomeo.
Bartolomeo. Sorry about that.
It's Irish.
I can tell.
Good morning, sir. I'm Paul Bartamioli, private citizen out of Litchfield, Connecticut. I am supporting 6491. I won't go into reasons that have already been stated. There's no sense rehashing what people have already said. I am opposed to 6355. And the reason for that opposition has to do with the tactic of swatting, in which people will call the police and create a situation or a false situation of danger, and the police show up expecting problems. And it turned out that it was actually somebody getting even with someone. Given today's hyper-partisan atmosphere, the abuse of this law would be off the hook. People, for no reason other than the fact that, well, as one previous person said, she didn't particularly care for firearms. Well, I live next door to her and I do like firearms. She gets mad at me for whatever reason and calls the police, or, you know, and files this order. This takes away due process. This makes me, as a firearm owner, guilty with no proof of it. You know, I have to prove my innocence, and that's not the way this system works. I just feel that 6355 takes a working law, a law that's been in effect for 21 years and has worked by its own advocates say it has worked. Well, if it's working, why would you want to change it? And that to me says it's politically motivated. Thank you for your time.
Thank you, sir. Sir, just for the record, where in the bill are you reading that this would allow a neighbor to file a petition against their neighbor if they're not related to each other or otherwise defined as a household member?
All right, I honestly cannot. I will honestly tell you that I don't recall seeing that in the bill, but you've opened up the list of who can do this. You've taken it out of the realm of getting a court order. It's basically, I can make an anonymous phone call. I mean, and I just don't see that as being conducive to good law.
Okay. I don't want to argue with you, but
okay.
I guess I don't see anywhere in the bill where it allows an anonymous phone call or a neighbor to file a complaint against a neighbor. But if I'm reading that wrong and you can point me to a line item, I'm happy to hear it.
Well, as I said, I probably am in error on that. I was just looking at this list of expanded people. All right, you say a neighbor. I'm living next door to my ex-wife. She's my neighbor. She also qualifies under the expanded law, or vice versa. You know, you're living next to you and you file a complaint against your ex-wife.
Okay. All right. Are there other questions in the committee? Seeing none, thanks for being with us, sir.
Thank you, sir.
Next up will be Gerald Richard.
Can you hear me? Thank you, Mr. Chairman and members of the committee. I want to testify that I oppose.
Hey, sir, I'm gonna interrupt you real quick. We're having trouble with your audio. If you could maybe get a little closer to the computer screen, or
is that better?
That's better, yeah.
All right. Let me try again. Okay. I oppose 6355 concerning orders and warrants. I think this bill is disrespectful to Connecticut responsible law-abiding gun owners. The bill violates due process, presumption of innocence, let alone Second Amendment rights. I don't think the legislature.
You know what, sir? I'm sorry. Maybe it's just me, but I can't hear a word you're saying.
I'm not sure.
I think when you speak, when you try to read, it's not picking up. So if you want to just summarize if you've submitted written testimony, then we have that. If you want to just summarize it, but just look into the camera if you can.
Okay, all right, let's try that. I think we already have specified there are already bills in place. The existing corruption order law works well. There are opportunities for medical personnel to detain people who they think are unstable or not safe. I think
Yeah.
this bill is really more of a.
Sir, I'm sorry. I hate to keep doing this to you, but did you submit written testimony?
Yes, I did.
Okay, all right. We have your written testimony. You know what? Somebody was saying maybe try shutting off your video real quick and see if that helps. Try it now.
Can you hear me better?
A little bit. Yep.
All right. Well, I'll just try to be brief and summarize. I think the bill doesn't. It's not an effective bill. It really focuses on gun safety. It really says nothing about required medical intervention. Then there's the problem that's been discussed about constitutional laws. Bills of this type, I call really a non-confiscational bill. There's no supporting their efficacy. I think the more effective bill can be crafted when you have the police being involved in the petition process,
Okay.
strong dating partners or old relationships. There has to be a guarantee of the person's rights to due process and innocence. There should be a remedy for false petitions, since perjury is seldom prosecuted in this state. I also think we have to be careful about the seizure and the warrants that can be issued from this bill. Maryland issued, they had their gun confiscation bill in 2018. Soon thereafter, a man was killed when the police tried to seize his firearms.
Sir, I'm gonna interrupt you again. I'm sorry. I think it's the device. We have your written testimony. The best I could make out, you're testifying in opposition to the bill, and the committee will be sure to review your written testimony. But we're gonna move on to the next
All right.
I appreciate you trying to be with us today. Next up will be Richard Blau.
It's Baylog.
Baylog, sorry.
Good afternoon, ladies and gentlemen of the Judiciary Committee and fellow citizens in the state of Connecticut. I'm here to, I'm against both bills that are on the, that we're discussing today. In regards to Bill 6355, it's basically a red flag bill. I don't know if anybody's heard of that, but that's what it is. This bill cannot become law because it's unconstitutional. I know someone spoke that said that he thinks it is constitutional, and maybe a lot of people presume that it is. But what we're doing here is we're dwindling away at our Second Amendment rights. I think there's too much leeway for people who have a vendetta against a respondent to accuse the respondent of being a dangerous, and next thing you know, you have half a dozen policemen banging on your door, trying to confiscate all your weapons and ammo without any testimony from the respondent. It could put people's lives in danger by doing that. People get very testy when it comes to someone trying to take away their arms. And a lot of rights, sorry, I lost my place. It could be people's lives in danger when you try to take their Second Amendment rights away from them. I and a lot of other law-abiding gun owners would call that tyranny, and there's nothing legal about this bill. I would expect, if brought before the Supreme Court, that it would be turned down quickly. Now, as far as Bill 6491 is concerned, the bill makes no sense as to why it should be illegal. Electronic defense weapons really rarely kill. They are the deterrent so victims have time to flee. Example, would you rather have a woman with a stun gun escape rape, or would you rather have a woman without an electric device be raped? These devices save the lives of people that are too weak or to defend themselves or do not feel comfortable carrying a lethal weapon. They should be sold to adults only, I'll admit that, but not banned. Thank you for listening to me.
Thank you, sir. Questions from the committee? Seeing none, thanks for being with us. Chairman Winfield?
Yes, next we'll hear from, Representative Dubisky, do you have a question? You're on mute, Representative.
I do, Mr. Chairman. I have a question for
Mr. Bailog.
Mr. Bailog, yes.
You may proceed, still here.
Thank you. Thank you, Mr. Bailog, for coming in. I know that I hear that you are opposed to the bill with regard to stun guns. I just wanted to ask you if you understood that the bill actually legalizes them as opposed to bans them. Would your opinion of the bill be different?
To legalize stun guns, yeah, my opinion would be different, definitely.
Okay, because just for your information, that is what the bill is for.
I'm sorry. I guess I didn't read it too closely. I was too concerned with the other bill. I'm sorry.
That's okay. Have you submitted written testimony?
I have not.
Okay, well, it might be a good idea if you've got something written to submit it, but you may want to take a look at that stun gun bill before submitting your testimony.
I will. Thank you very much for pointing that out to me.
Thank you, Mr. Chairman. Mr. Chairman, I believe you're muted.
Thank you. We all do it, I guess. Thank you, Representative Dubisky and Mr. Bailog for joining us today. We'll next hear from Sarah Raskin. Is Sarah Raskin in the room?
Hi, yes, I am. Thank you very much.
You
can hear me. You can hear me okay?
We hear you just fine.
Great. Senator Winfield, Representative Staffstrom, and the members of the Judiciary Committee. I live in West Hartford, Connecticut. I'm also a licensed psychologist in the state of Connecticut, and I'm here to testify in support of HB 6355, an act concerning risk protection orders. I'm proud that Connecticut has an extreme risk protection order, and I know well that often someone who is considering suicide can feel differently the next day. And the problem with having access to lethal means is that often that next day never comes. Suicide attempts are often impulsive acts driven by transient life crises. Most attempts are not fatal, and most people who attempt suicide do not go on to die in a future suicide. Whether a suicide attempt is fatal depends on the lethality of the method used, and unfortunately, firearms are extremely lethal. The United States has a very high rate of suicide by firearm. In 2018, 24,432 suicides by firearm occurred in the United States. When I'm working with someone who's experiencing suicidal thoughts, of course, I would ask if they had firearms in the home. And I'm grateful that so far, none of my clients has ever used one on themselves. But I know that that day could come at any time. And in fact, I have had a client come into my office with a firearm with the purpose of threatening his wife that we were doing counseling with. Recent research has suggested that Connecticut's law has reduced suicide rates, and other research, of course, suggests that more needs to be done. Access to lethal means such as firearms has been shown to dramatically increase the likelihood that a suicide will be completed. And this is especially true when people have reduced judgment or increased impulsive behavior, for instance, someone who has experienced trauma. I believe that it is time to strengthen the law so that more gun deaths can be prevented. And in particular, it should be a requirement that the person is no longer deemed to be at risk of harming themselves before the firearm is returned. Allowing others to petition the court directly, as 12 other states already do, will provide an alternative means to initiate the process for people who may be reluctant to involve law enforcement. I ask that you favorably report HB 6355 out of committee. Thank you very much for your consideration.
Thank you very much for your testimony. Are there comments or questions from members of the committee? I do not see any. Thank you very much for joining us today and offering your testimony. Next, we'll hear from Holly Sullivan, to be followed by Jennifer Kraft and Peter Estrada. Ms. Sullivan, you have the floor.
Thank you. Can you hear me okay?
I do.
Great. Dear distinguished members of the Judiciary Committee, thank you for being here today, albeit at home, but still present. And I truly appreciate you taking the time to hear the voices of the people of Connecticut. My name is Holly Sullivan, and I am the president of the Connecticut Citizens Defense League. I would like to express my sincere desire that this committee move forward with HB 6491. As a single mother, I'm extremely cognizant of my responsibility to protect not only myself, but my 7-year-old daughter. I work full time, and it leaves me juggling errands often in the evening. I'm often assisting my daughter getting buckled into her booster seat in a parking lot of a grocery store, Target, etc. Having been raised with firearms, I made the decision years ago that I wanted to be trained and to properly carry a firearm responsibly. However, I've had conversations with many women who expressed to me that they just are not ready or do not wish to have this responsibility. And I understand and respect this. Owning a firearm is not for everybody. However, these same women have also expressed frustration that they have few tools available to them as an alternative outside of their home. In our state, a woman can secure a permit which grants them the means to take lethal force if needed. However, women in this state have no avenue to protect themselves with non-lethal force outside of the home, and that doesn't make sense. Further, there are many instances in which a woman like myself may not have the ability to carry a firearm due to the circumstances of the day. I work in Brookfield, about 10 minutes from the New York State border. If I need to run an errand or do business over the state line, my firearm absolutely cannot come with me. Most women in this country do have the means to protect themselves with non-lethal electronic devices, including states like New York, California, and New Jersey. We are the minority in this. So I do hope that this committee will support a truly common sense proposal for the safety of women in our state. I'm also here today to strongly urge you to reject HB 6355. The passage of this bill will undoubtedly have severe implications for genuinely good people in this state. I'm sure you're going to hear a lot about due process, but I want to ask you to consider the impact that this bill will have on mental health in our state. I have on several occasions spoken with women gun owners who are afraid to get basic mental health in our state. I have on several occasions spoken with women gun owners who have issues such as a very basic thing, such as eating disorders, postpartum blues, or going through marriage counseling. They're at no risk to themselves or others. However, there is certainly stigma and confusion that they will have their firearms taken away from them and they won't be able to defend themselves. And I've dispersed this misconception and assured them that currently, with no threat of harm to themselves or others, outpatient counseling would not be an issue. However, under this bill, I'm concerned that more women will avoid seeking basic mental health over the concern that they might be disarmed unfairly, seeking the advice of just a social worker. And I'm curious if the legislature is going to be enforcing some sort of education around that.
Ms. Sullivan, your time is expired. If you could summarize.
Yes, I'm just simply going to say that women gun owners in our state must feel comfortable seeking access to mental health, and I would implore this legislature to do so. This bill is contradictory to accomplishing that. Thank you.
Thank you. Are there comments or questions from members of the committee? Representative O'Day.
Thank you very much, Mr. Chair. Thank you, Ms. Sullivan, for your testimony. Just briefly, I know we have your written testimony. I'm sorry I haven't had a chance to go through all of it. We've gotten a lot of it. Is there any way that you'd prefer that the legislation be fixed, or do you just would rather it stay the way it is?
Well, I think that there's evidence that the bill that is in place is working. And we've spoken to that already. And if there are processes that need to be improved in the way that the actual execution of that happens, then so be it. But I think one of the concerns here is that legislation continues to get passed, but we don't always go back and look at legislation that's been passed behind us and say, is this working? When I think about mental health, and that's one of the conversations that we always have around the gun issue, you know, I constantly say, how can we talk about mental health? And SB 1160, which called for a three-pronged approach to actually fund mental health help, still hasn't been done. So my concern is if we pass more legislation, it is not fixing the problem. There is legislation out there already. Whether it needs to be corrected in how it's being executed, then so be it. But the passage of another piece of paper is not going to stop any bad guy. It's not going to stop anybody from violating a restraining order. That's just not what this does. So I guess my position on this is that we already have the statute. And I believe that if it was better revised or enforced, then that's the way to go. However, I don't think that the passage of new legislation is the answer here.
Thank you very much. One of the things that I'm concerned about is the fact that this could be used by a spouse to try and take away the weapons that the spouse would use for defense. But I will yield my time, and thank you very much, Mr. Chairman. And thank you, Ms. Sullivan, for your testimony.
Thank you.
Thank you, Representative O'Day. Representative Howell.
Thank you, Mr. Chairman. Good afternoon, Ms. Sullivan. Thank you for being here today and testifying on this important issue. You did touch on restraining orders, and obviously that's come up a couple of times today and whatnot. Under the current legislation, if a spouse is concerned about the mental well-being of her, say her husband, if it's a woman, and she contacts the police to initiate the process as it is now, the police are obviously going to become involved immediately. Would you say that's correct?
Yes, it is. There is an avenue for that. Correct.
Right. So, and the second thing is, as this is proposed, the spouse who is concerned about her husband's mental health can go to the judge on her own and seek, we'll call it a piece of paper for lack of legal term, to get his guns taken away.
Sure, his or hers goes all ways.
Correct. And you know, you can certainly go both ways. I agree. My concern, I'm asking if you share it. In my experience with domestic violence, a lot of things play a part in it. Substance abuse and mental health at the top of the list. My concern is that when a spouse goes to the court to get this order against, say, her husband or wife, as the case may be, and the husband or wife is contacted by the police to get these guns, that the spouse can become very upset, and the police were not there from the beginning to advise her on domestic violence advocacy, ways to contact for help, and a lot of the programs and the safety measures that the officers put in place when they respond to it as it sits. Do you share that concern?
Absolutely. And, you know, so in my professional career, I work in human resources. I have a master's degree in human resources, and I've been in the field for more than 10 years. So while it's not domestic abuse, I certainly deal with some very difficult, challenging situations where people, whether they've had a disagreement in the office or it's, they've certainly had situations where issues at home follow them into the workplace. And I've dealt with a lot of these different things professionally. And I think it's really important that we do recognize that people are emotional sometimes. And then there's also three sides to every situation. So you've got, you know, perhaps the two individuals that are involved, and then you've got the outside perspective of, for example, a police officer, right? So you might have one heated spouse and another heated spouse, and then you've kind of got that person who understands the law, understands what processes need to be followed. And not for anything, a lot of resources have gone into law enforcement in past years to work on de-escalation. And they're really good at that. And I think we need to not forget that there are individuals out there that are trained to de-escalate people and have a community presence as a helping presence. And to take them out of the equation, I think is actually making that situation worse. I can't tell you, how many times, I've had situations where the police have visited my workplace and I'm in awe of what they're able to accomplish to be able to get somebody to say, to calm down a little bit and kind of understand the facts the way that they see them. And to take them out of it, I don't think that that's doing anybody any good. And I certainly understand that calling the police is not a pleasant experience. Nobody likes to do it. But they have a role to play in our communities. And I think as we strengthen community relations with police officers, we shouldn't neglect that.
So you're the president of CCDL and you're here testifying in opposition to this bill. Is it fair to assume that you feel that this bill is an attack on gun rights?
I think it's an overreach. Whether, when we talk about gun rights, I've been doing this a while. I think you kind of, at some point in time, kind of check your emotional feelings towards it. You might have a persuasion one way or another, but then you look at the law. And when I look at the law, I say, well, gosh, is it okay for somebody to show up at my house at 2 a.m. or 4 a.m. or 7 a.m. and I haven't had a say in that situation? I'm a divorced woman. Never a pleasant experience. So I can certainly tell you that I've experienced what it's like to be on one side of a situation where you're just somebody who might be defined as your spouse for a year while you're going through that process as somebody to whom you are estranged. I'm not saying that was ever that's necessarily a violent thing, but I certainly can understand how a man, a woman, anybody in that kind of situation, by the definition of this bill, somebody who I'm in the process of divorcing is still my spouse. And I think we need to be really aware of what life is like in 2021. Family relationships are not perfect. And by the definition simply of that role, I don't think that grants the ability for somebody to just come up and take my property that I might need for self-defense because an accusation was made.
Well, you bring up an interesting point, and I'm glad that you did that, because the retaliatory end of this without the police being involved from the beginning is a concern. I also think that that the ex parte process that we had that we touched on earlier is relevant and it's important to this conversation. I think it's worth noting that as this legislation sits, we're allowing a spouse to or any person really to go to a judge to have someone's firearms taken away because of mental health, but yet the police still have to be involved under our current statutes to get that person to go to the hospital to get the help that they need. So we're not even, we're doing it on this guise of mental health, but we're ignoring a process by which we can get the individual the help that they need. And I think we're also ignoring the fact that Connecticut statistics show that with great there's a fair comparison in the amount of people that choose to take their lives by ligature and by firearms. So it's interesting to me that the CCDL is here because we're only focused on one of those, and I don't see any legislation coming forward that allows a spouse to go to a court on some good faith idea and say, well, I want all my husband or my wife's ties, belts, electrical wires, ropes, and any ligatures taken away. So I'm glad that you're here today. I thank you for your testimony, and Mr. Chairman, I thank you for the time.
Thank you, Representative Howard. Representative O'Day, is your hand still up or is it up again for a second time?
No, it's not up. I apologize.
Okay.
Sorry.
Just wanted to check.
Thank you.
I do not see any other hands. So in that case, I want to thank you, Ms. Sullivan, for joining us today.
Thank you for your time.
Thank you. Next, we have Jennifer Kraft, followed by Peter Estrada. I do not see Ms. Kraft. So we will move to Mr. Estrada. Mr. Estrada, you have 3 minutes. You're unmuted, but I cannot hear you. Still no. I don't hear you. Mr. Estrada, why don't you work on that? I'm going to move to the next person and come back to you after him. So we have Tom Maloney, who I don't think I see, and Patrick Farley, who I do see. So Mr. Farley, if you'd unmute, you will have your 3 minutes.
Thank you very much, Senator Winfield and Representatives, Stafstrom, Ranking Members Kissel, Fishbein, and distinguished members of the Judiciary Committee. My name is Patrick Farley. I'm from West Hartford, and I'm a supporter of Connecticut Against Gun Violence. I'm a retired insurance agent and a concerned citizen. I'm wanting to decrease and prevent gun violence and believe that that's a necessary endeavor in Connecticut and throughout the country. I'm testifying in favor of HB 6355, an act concerning risk protection orders. I have a family member who has attempted suicide, thankfully unsuccessfully. I'm also thankful that there were no guns in that home. However, I believe if there was a gun available, the outcome of his attempt would or could have been different. So for this reason, I'm supporting HB 6355, whereby access to firearms will be blocked to those intent on harming themselves. I ask that you favorably report HB 6355 out of committee so that the General Assembly can vote to strengthen our extreme risk protection law so that it works harder to prevent firearm suicide and homicide. And I thank you for your consideration.
Thank you, Mr. Farley, and thank you for sharing your testimony and your story. Are there comments or questions from members of the committee? I do not see any. That being the case, I want to thank you again for joining us today. Mr. Souza, could you mute, please? Thank you. So, Mr. Estrada, I'd like to see if your audio issue has gotten cleared up. Mr. Estrada, are you there still? Okay. Can you try to unmute now? I will come back to you after the next person if you're not. Okay, we're going to come back to you, Mr. Estrada. I'm also told that Mr. Maloney is on, but hasn't been switched yet. So we're going to come back to him as well. Is Joan Curson here?
Yes.
Ms. Curson, you may
Yes.
testify. You have 3 minutes.
Thank you. Senators, representatives, who were members of the Judiciary Committee. My name is Joanne Carson. I'm from Norwalk, and I support Connecticut Against Gun Violence. I'm testifying in favor of HB 6355. In 2019, only 2 risk warrants were issued in Connecticut for individuals who posed a credible threat of a mass shooting. One of them was my son, Brandon Wagshall. He was arrested at his father's house in August 2019, shortly after the Dayton and El Paso massacres. The police and FBI took 4 high-capacity gun magazines, tactical equipment, 120 rounds of ammunition, and body armor. When arrested, Brandon stated it was his intention to build a high-capacity firearm. He told me that he was 90% done with building the firearm. He was charged with illegal possession of gun magazines, which he bought legally in New Hampshire and brought back. He was arrested again in February 2020 for assaulting his father. He's currently in jail on $500,000 bond, awaiting disposition of the 7 felony charges against him. To give you some background, Brandon had been suspended from public school constantly, mostly due to threats of violence or violence itself. We had cases with DCF, DDS, the juvenile courts, everybody. everybody knew my son. In 2013, he was expelled from the second high school he went to, a special ed high school for at-risk youth. And when that happened, I went into court armed with a letter from his treating psychiatrist that he needed a residential placement. What the court did was they transferred custody of my son from me to my ex-husband, the gun enthusiast. This was the last failure of the system for Brandon as a juvenile. The system failed him so many times. It failed him, it failed me, and it failed all of you. In March 2018, I heard a loud banging in my house. It was Brandon trashing everything. He also tried to set a fire. When I confronted him, he packed up his stuff and went to his father's. I called the police and he was arrested. In my victim statement, I said I wanted to make sure he never had access to firearms. The case was dismissed, and by this time, my ex-husband had guns. I ask that you favorably report HB 6355 out of committee so the General Assembly can vote to strengthen our ERPO laws and work harder to prevent firearm suicides, homicides, and mass shootings. In the case of Brandon Wagshall, the law worked. We have proof this law works. Thank you for your consideration.
Thank you, and thank you for testifying and for sharing your very personal story. Are there comments or questions from members of the committee for Ms. Kierson? I do not see any. I want to thank you again for taking your time to come and testify before us.
Thank you.
Have a great day.
You too.
Mr. Estrada, have you gotten your audio taken care of?
I think so. Can you hear me?
I think you have. I think you have. You get your 3 minutes.
There to click on. I wasn't sure which was which. But anyway, thank you, everyone, for the opportunity to speak this afternoon. My name is Peter Estrada. I'm a representative also of Connecticut Citizens Defense League. I'm the Urban Engagement Coordinator. My role with the organization is to reach out to the minority community, the Black and Hispanic Latino community, to talk about their gun rights. One of the things I wanted to talk about today is support for HB 6491, and that's the bill to allow people to use a pretty much a stun gun, right? And the reason I'm in favor of this bill is because, as probably many of you know, the rise in hate crime in the Asian community, the rise in the targeting of the transgender community. Sometimes these individuals might need a tool to defend themselves if they're being targeted, right? So if you're not aware, if you haven't never been through the permitting process here in the state of Connecticut, it's a lengthy one, right? So if I did want to protect myself, if I was a member of that community that feel I'm being targeted, what can I do? How can I protect myself other than calling the police? Because obviously the police come in after the fact when a crime is committed. So in order to get a permit here, if I wanted to choose a firearm, it'll take months. And if I feel I'm being targeted, threatened, stalked, if it was a female or whatever the case may be, what tool do they have? What capabilities, what can they use to defend themselves? And having the opportunity to use maybe a stun gun or something like that to be able to protect themselves would be a good thing, right? Because not everyone, again, even though other people have said it, you may not want to choose to use a firearm as a means to self-defense, but stun gun could be a way, right, of trying to protect yourself. So that's one of the reasons I am in favor of this bill, and I would hope that you would maybe take the time to consider supporting this bill just for those reasons, and of course other reasons. But again, it doesn't always have to be a firearm. People should have an opportunity to defend themselves by any means, and obviously legal means. And I'm also opposed to the other bill, and for a couple other reasons. My concern with the bill is the cost. The cost if I am falsely accused of for whatever reason that I have to go before a judge, and now after 14 days and have to state my case as to why I should get my firearms returned, right? I have to get a lawyer. Who's going to pay for that? That has to come out of my pocket. What if it is a spouse or someone that maybe we're having a falling out and they do want to target me and kind of hurt me in that way because they know I have a firearm, right? And one of the other things is, what happens if a judge just decides to not, let's say they did think I was not a threat, but decided to, on the safe side, let me hold the firearms a little longer, right? How do we know the judge is not going to prolong?
Mr. Estrada?
Yes.
Your 3 minutes have elapsed. If you could summarize, we'd appreciate it. Thank you.
So overall, it's just what safeguards are the representatives here going to put in place in case if someone was falsely accused, the judge did feel and finally did decide to return the firearms, making sure the police do not destroy those firearms. If that does happen, will you be compensated? And one last thing is the permitting process. If I'm cleared, my permit was revoked or suspended, whatever it is, the term they use, if I have to reapply, that's a question on the application process. Has your permit ever been suspended or revoked? And could the issuing authority, the town, now use that as a reason to then deny me in the future to issue a new permit? So I would ask, if this is something you're really going to do, take the time to think this out, put some safeguards for also the person that was maybe falsely accused to be able to actually get their permit back as well.
Thank you very much, Mr. Estrada. Thank you. Thank you. Are there comments or questions from members of the committee? I do not see any. So, Mr. Estrada, thank you, and thank you for sticking in there through your audio troubles to testify before us. We'll next hear from Tom Maloney. Mr. Maloney, if you'd unmute, you have your 3 minutes.
Hi, thank you. Good afternoon, Senator Winfield, Representative Staffstrom, distinguished members of the Judiciary Committee. I have submitted written testimony, but I'll summarize here. I support HB 6491 to allow those who would choose to defend themselves with non-lethal electronic devices. In light of the Caetano v. Massachusetts, this seems like an easy decision. Others have spoken to this extensively, so I'm going to move on to my opposition to HB 6355. Everyone on both sides of this discussion agrees that firearms should not be in the hands of those proven to truly be a danger to themselves or others. To suggest that gun owners somehow want to ignore these types of threats is preposterous. We all agree there's a place for red flag laws if done properly. And this bill seems to do almost everything wrong. Dr. Walt Cupson briefly mentioned it, but in 2018, the Conference of Chief Justices asked the Uniform Law Commission to form a study committee and draft a model red flag law. The panel consisted of a wide range of expertise and political views. David B. Capo, who the doctor mentioned, an adjunct professor of law, participated in that study and subsequently provided testimony to a Senate Judiciary Committee hearing on red flag laws. I'd really urge everyone on this committee to try and get a copy of that testimony and read it. It really was good. He's not anti-red flag. He was just pointing out what needs to be done to protect all parties. Notable highlights of that testimony focused on ex parte red flag laws like we're discussing today. 5 of the 7 key tenets of due process were notably absent, and those are notice, opportunity to make an oral presentation, opportunity to present evidence, cross-examination in response to evidence, and right to counsel. Equally concerning is bypassing law enforcement and their investigatory role and relegating them to the end stage, which is seizure. If the first time your interaction with law enforcement is the middle of the night when they're knocking at the door, I feel like, the process has failed. Recognizing current trends in the community's view of policing, the idea of leaving the entirety of evidence to come solely from an accuser with no investigation greatly increases the probability that these ERPOs will be granted in error. We know in Connecticut, 32% of the warrants are already vacated. And by lowering that standard further to basically just be a good faith belief of imminent risk by one party with no chance of anyone presenting any corroborating evidence, it's frankly reckless because, and again, you go right to escalating the situation with law enforcement involvement at that point. So that's my testimony. I hope you'll consider opposing 6355. Available for questions.
Thank you very much, Mr. Maloney. Are there comments or questions from members of the committee? I do not see any. That being the case, Mr. Maloney, thank you very much for joining us today.
Thank you for the opportunity.
You're welcome. Thank you. We will next hear from, sorry, I lost my place for a second. Mr. Sousa, you're there. I see you. Please unmute and you have your 3 minutes.
Okay. Good day, members of the Judiciary Committee. I'm Richard from East Hartford, signed today, March 5th, 2021. I support HB 6491, and I oppose 5, and I'd like to address HB 6355.
Mr. Sousa, you're breaking.
We live now in a country. Yes, ma'am. Can you hear me?
Breaking up. You're breaking up a little bit. Perhaps if you turned off your camera, it'd be smoother.
Turned off my camera.
Yes, it sometimes gives you a little more bandwidth.
Can you hear me better?
Yes.
Okay. Okay. We live now in a country where there's two types of people. Those who still acknowledge that the United States Constitution is the supreme law of the land, as Article 6 declares, and to which each colony, territory, and possession had to swear fealty to before being allowed to become a state, and other people in both federal and state government who believe that the supreme law is whatever their political party can get voted through their legislatures. I remember when President George W. Bush signed the Patriot Act, and when a member of Congress asked Bush, why wasn't he concerned with an act that so thoroughly eviscerated our Bill of Rights, he replied, the Constitution is nothing but a goddamn piece of paper. It's lucky for him that I wasn't there, or I might have slapped that little smirk off his face. Members of my family have fought, died, and killed to preserve that document and our liberties. And now in Connecticut, we're entering the next phase, the age of the rat, the age of the informer, the age of the whispering campaigns. Guilty until proven innocent. To hell with the Fifth Amendment and due process. Now probable cause will be enough. The government will seize your arms permanently based on the petition of just about anyone you've had contact with in your whole life. And you'll have no right to a court hearing beforehand to face your accuser. And you'll have to pay thousands for a lawyer to sue the court that issued the order to get your firearms back for a crime that has not been committed. It makes me want to weep when I think what my uncles went through pushing the Nazis back into Germany and sweeping the Japanese off islands in the Pacific, when I see a state government trying to shred the liberties that they fought so hard to preserve. I understand now more than ever that personal firearms guarantee personal freedom. As Thomas Paine said, the duty of every patriot is to protect his country from its government. That's the end of my testimony.
Thank you, Mr. Sousa. Are there comments or questions from members of the committee? I do not see any. I want to thank you again, Mr. Sousa, for joining us today, and I hope you have a great rest of the day. Next, we have Michael Eanes, who I do not see, and Heather Coletti. Is Ms. Coletti in?
Yes, I am. Thank you, sir. Can you hear me?
Okay, you have your 3 minutes. I do hear you.
Okay, thank you, Mr. Chairman and the members of the committee. Today, I'm here to testify in hopes that you will oppose House Bill 6355 and support House Bill 6491. I did write a testimony and sent it in. However, I'm not one for reading what I wrote, so I'm just going to talk. because most everybody has said everything. The one thing I want to focus on, and I'd like you to think about, I'm just a normal person. I live in Connecticut. I'm a mom of 6 kids. I've been divorced. I've been widowed. And I've been through a lot, as most of us have in our ages. But the one thing I'd like you to really think about is the fact of making more laws instead of enforcing the laws we already have. I know it's been said gently, but we need to, you all, thankfully, because I couldn't do your job, you all took an oath to uphold the Constitution. And so we have to look back at the basic Constitution and the Bill of Rights and focus on that. And when, you know, Holly, Mrs. Sullivan, or Miss Sullivan said, we get emotional. We do. That's just our humanly rights. That's what we do. But we have to stop and think about what is right. And I'd like you all to just remember, we have to hold people accountable for what they do, whether it be a police officer, whether it be a judge, whether it be a representative from the Senate or our own, you know, anybody, our town. We have to hold them accountable, not keep changing laws for that one person who, God forbid, did something horrible. And they do. And that's what we hear about all the time. We hear about these one person or two. Stop thinking about them. This is what happens in schools. And I'll have to tell you that my son, who is now 11, but when I took him out of public school this was one of the reasons. He was in class and his friend, I don't know, Johnny, let's say, was using an iPad because he didn't want to take his test. Well, my son, who's a good student, had to take his test. He didn't have a choice, but because he didn't make a stink, he wasn't the bad kid, he didn't get to use the iPad. So he came home to me and said, Mom, why can't I have an iPad instead of doing a test? It's that one kid, that one person that we're focusing on instead of all the other people who do the right thing or use their equipment the way it's supposed to be used. The tasers, or whatever you want to call them, electronic defense weapons, right? They're there for a reason. And what is an arm, right? You could argue, what is their right to bear arms?
Ms. Coletti?
Yes, is my time up already?
It is, and if you could summarize, I appreciate it. It goes fast.
Just quickly, just think about what you promised to do when people voted you in. And do we need to make more laws or just focus on enforcing the existing laws? That's my point, and I appreciate your time.
Thank you. We appreciate your time too. And I have to tell you, I once sat on your side and I was stunned by how fast the 3 minutes goes as well. There is a
sounds like when everybody else is speaking, it takes forever, but
there is a question or comment from Representative Howard.
Okay.
Thank you, Mr. Chairman. Ms. Coletti, thank you for being here today. I'm intrigued because you're a school teacher, correct?
I teach online to students in China, actually.
Okay, because I've had teachers tell me who have obtained pistol permits that if any of their coworkers knew they had a pistol permit, that they wouldn't even eat lunch with them.
It's incredible. I did work in a school as well, and I couldn't say my views if I was nobody would listen. No, you couldn't let anybody know your views.
Ms. Coletti, I'm a police officer. I've been a police officer for a long time. I have 2 sons. They're 11 and 9. 11 and 10. When my youngest son was in kindergarten, he was playing with his fellow classmates at 5 years old. And many of them were pretending to go to work for the day. The doctor's son said he was going to put on his stethoscope, and, everybody said what they were doing. But my son said, well, I'm going to grab my badge and my gun and I'm headed to work. He came home that day crying because he got kept in from recess and got in trouble for saying what he did.
Yep.
And I think to hold a 5-year-old to that sort of standard, to upset him because he said what his daddy did every day, was the most atrocious thing that I had ever seen an educator do. I was absolutely infuriated. I make my kids mind to the nth degree. I am constantly complimented by their teachers that their manners and their conduct, and to punish a child because he simply was proud of what his dad did and didn't know that gun was a 4-letter word in his school was really, really disheartening. So I just wanted to comment and praise you for the courage to come here today as a teacher and say the things that you did. So I want to thank you for that.
I appreciate that. And I do have to also say I have twin 11-year-olds. One of them is absolutely in love with state police, and he'll sit outside watching police go by, and the police even stop to say hi to him and give him high fives and stuff like that. So we love the police, and thank you for your service as well.
Thank you.
Thank you, Representative. Representative Beach.
Yes, I just wanted to say, Ms. Coletti, I really appreciate you coming out here and expressing how you feel and being so positive in regards to these two laws that we're looking at, or two bills, I should say, that we're looking at. We really appreciate the fact that you're willing to step out there, especially with the atmosphere in a school system, the way it is. The negativity around firearms and tasers and all of that stuff is just, it's not okay. So I have to really thank you for coming out and speaking your mind.
Thank you. I also want to say that if it's okay for me to comment, I'd like to say that
absolutely.
This online thing is almost as good as the DMV now, because we don't have to drive all the way to Hartford. It's great.
Thank you, Ms. Colati, and thank you, Representative Beach. I do not see anyone else with a comment or a question. So, Ms. Colati, I want to thank you for staying with us and testifying today, and I hope you have a really good rest of the day.
Thank you very much.
You're welcome. We next have Craig Henry, who I haven't seen, Valerie Horsley, who I haven't seen, and Haley, looks like Zawolinsky. And I believe I did see Ms. Zawolinsky. So Ms. Zawolinsky, you have your 3 minutes.
All right, thank you. Greetings to Senator Winfield, Representative Staffstrom, ranking members Kizel and Fishman, and distinguished members of the Judiciary Committee, excuse me. My name is Haley Zawolinsky, and I am from Waterford, Connecticut, and I am a supporter of Connecticut Against Gun Violence. I am a senior at the University of Connecticut and a member of Connecticut Against Gun Violence Youth Council. I'm testifying in favor of HB 6355, an act concerning risk protection orders. When I was learning to drive, my father turned to me and said, "Treat this vehicle as if it's a loaded shotgun. Both have the power to kill yourself and others in a moment's notice, so you need to be responsible." Every time I get behind the wheel, I am reminded that my choices and actions have the potential to take innocent lives, and it is on me to help keep those around me safe. To have a gun, an individual takes on an incredible responsibility because one shot has the potential to end a life and cause a ripple effect of collateral damages. I'm not challenging the constitutional right to bear arms. I'm asking you to consider the responsibility that accompanies owning a firearm. While we are respecting the interests of one population, and in this case, it's gun owners, we cannot neglect the interests of the population that feels as though their lives or other lives are at risk. We cannot cherry pick the populations we choose to protect and serve. It is time to listen to our citizens, listen to our victims, hear their concerns, and take measurable actions to resolve conflicts. I ask that you report HB 6355 out of committee so the General Assembly can vote to strengthen our extreme risk protection law so that it works harder to prevent firearm, suicide, and homicide. Thank you for your consideration and your time.
Thank you, Ms. Zawolinsky. Let me see. Are there comments or questions from members of the committee? I do not see any, so I want to thank you very much for joining us. We next have Robert Starr, followed by Nicholas Payne and Christopher Vitale. Is Mr. Starr here? I see you. You must unmute so you can have your 3 minutes.
Okay, can you hear me now?
I hear you.
Thank you. Okay, honorable members of the Judiciary Committee, my name is Robert Starr. I live in Torrington. I'm testifying today to oppose HB 6355 and to support HB 6491. My opposition to HB 6355 is based on my view that it does not contain enough protection of due process. It's my view that perceived threats or dangers should not be handled without at least a minimal investigation by law enforcement. My support of HB 6491 comes from my belief that when a citizen encounters a serious threat to their life or safety, it is preferable that they are allowed a non-lethal response that has at least a chance of being effective. Thank you for hearing my testimony.
Thank you, Mr. Starr. Are there comments or questions from members of the committee? I do not see any, but I want to thank you for taking some time to, oh, you caught one. Representative Dubitsky.
Thank you, Mr. Chairman, and thank you, Mr. Starr, for coming in. Mr. Starr, you and I have known each other for a while, and I hope you don't mind my saying that you have a mobility problem. Is that right?
I do.
Okay. With regard to the ability to carry a defensive device, would it in some way help you protect yourself as a person of limited mobility to have the option to carry a non-lethal device with you?
I believe so. You know, I don't have a very good ability to retreat from threats, so it would be nice to be able to deal with things in a non-lethal fashion.
Okay. All right. Well, I appreciate it. I appreciate your coming. Well, you're appearing via Zoom today, and thank you for your testimony. And thank you, Mr. Chairman.
Thank you, Representative Dubitsky. And seeing no others, I'll just say to you again, thank you for joining us and offering your testimony today. Next, we have Nicholas Payne, followed by Christopher Vitale, followed by Janet Rice. Mr. Payne, are you present?
I am present.
You have 3 minutes.
Testimony in support of HB 6355, an act concerning risk protection orders. Senator Winfield, Representative Staffstrom, Ranking Member Kissel and Fishbein, and distinguished members of the Judiciary Committee. I am from New Milford and a supporter of Connecticut against gun violence. My interest in these issues is because our daughter Rebecca was shot dead by a crack dealer who got the wrong address in Boston in 2008. First, the idea of allowing the public to directly petition for an extreme risk protection order rather than through the police in the first instance is also a good one, because some say that 70% of police work involves mental health, but to deal with mental health matters is likely not what motivates those who wish to join the police force. However, there appears to be a point of view that considers the extreme risk protection order redundant and pointless, since there are so many ways to commit suicide other than by a gun. And I will say to this, that's the difference between could and would. Yes, you could use a rope, but would you? That's the question. And the difference between could and would is the value of this law. I ask that you favorably report HB 6355 out of committee, so that the General Assembly can vote to strengthen our extreme risk protection law, so that it works harder to prevent firearm suicide and homicide. Thank you for your consideration. And again, my name is Nicholas Payne, Milford.
Thank you very much, Mr. Payne. Representative Dubitsky, is your hand still up from last time, or is it is? Okay. Are there comments or questions from other members of the committee? I do not see any, but I want to thank you very much for taking some of your time to come and testify here before us this afternoon. Thank you very much. Have a great day.
Thanks very much.
Christopher Bytel, followed by Janet Rice, and then Jonathan Perlow. Mr. Bytel, you have the floor in 3 minutes.
Thank you. Hi, we've established my name is Chris Patel. I'm from Middletown, Connecticut. I'm testifying today in support of HB 6491, an act concerning non-lethal electronic defense weapons, and I'm here to testify in opposition to HB 6355, an act concerning risk protection orders or warrants. As far as 6491 concerning non-lethal electronic defense weapons, this is a bill that just makes sense by following judicial principle. As Dr. Walt Cupson before me had mentioned, I won't get into too much detail, but the U.S. Supreme Court ruled in Catano versus Massachusetts that the Second Amendment does apply not just to firearms, but also things specifically like electronic defense weapons. They referenced the Heller case, saying that stun guns are not unusual, they are something in common use, and they are not uniquely dangerous. As far as HB 6355, this is a really problematic bill that I've read. I've seen definitely, I've been around the last few years and testifying in the Judiciary Committee, and I've seen some doozies, but this one is really concerning. On face value, I understand the idea of there's somebody that's going to do something bad. Let's stop them from doing something bad. Everybody can get behind that. Unfortunately, that's just not the case here. It's become incredibly cliche, but it's truer now more than ever, and especially with this bill, the road to hell is indeed paved with good intentions. The U.S. Constitution declares certain inalienable rights that specifically limit the government's authority and power over individual people's lives. Among these is the right to due process. In my opinion, the current firearms seizure law in Connecticut violates that. I find it very unconstitutional in that there is no hearing before things are seized by people. At least with the way it is now, the police are involved. As said earlier, there is a degree of probable cause by a trained police officer, two trained police officers that have to, put together rationale, if you will, to a judge to execute one of these firearm seizures. The way it is now, I can't think of any better way to abuse the system than having household members or medical professionals, but specifically like people in people's family. We've heard people talk about divorces and breakups and abusive relationships. People don't want to admit it sometimes, but in this world, there are monsters that walk among us, and there are people that are looking to do real harm and manipulate the system. And I've heard a lot about victims today and protect victims. I can't think of any other way to create more victims and really harm the citizens of this great state than take away really their way to defend themselves by going around their constitutional rights. As it is, 33% of risk warrant confiscations are overturned at the first hearing. To me, that's outrageous. That means that a third of the time it wasn't even called for. It's a scary bill. The idea, after this whole national conversation we've been having this past year, the idea we're going to encourage, the idea in the middle of the night, you hear a knock at the door and we're banging at the door at 2 a.m. and the cops are coming in and looking for things. And I don't know, to me, I just think that that's a recipe for disaster. So
Mr.
as I said, I'm wrapping up right now. I was just gonna say, I hope you oppose 6355 and act concerning risk protection warrants, support HB 6491, not concerning non-lethal electronic defense weapons. And that's all I have. And if you have any questions, I'd be happy to answer.
Thank you, Mr. Patel. Are there comments or questions from members of the committee for Mr. Patel? I do not see any. I want to thank you, Mr. Patel, for coming and sharing your perspective with us today. I hope you have a great rest of the day.
Thank you, sir, and you as well.
Thank you. Next, we'll hear from Janet Rice, followed by Jonathan Perlow, followed by Brooke Cheney, and followed by Melissa Kane. Janet Rice, you have the floor and 3 minutes.
Thank you, Senator Winfield, Representative Stafstrom, and distinguished members of the Judiciary Committee. My name is Janet Rice. I am from Bloomfield by way of Hartford. I am the Community Outreach Coordinator for Connecticut Against Gun Violence, and I am also a gun violence survivor. In October 2012, my only child was taken from me by gun violence. In August 2005, my nephew Gerald took his own life in front of his twin brother, his older sister, and his then 4-month-old daughter, who was asleep on his sister's bed. He was depressed and didn't know how to deal with it. If I knew then what I know now, maybe, just maybe, a 15-year-old girl would have her daddy today. Allowing family members to petition the court directly, as 12 other states do, provides an alternative means of initiating the process for people who are reluctant to involve law enforcement at the onset because they fear law enforcement or fear because they are fear of law enforcement or are concerned about stigmatizing the gun owner as a criminal. I ask that you favorably report HB 6355 out of committee so that the General Assembly can vote to strengthen our extreme risk protection law so that it works harder to prevent firearm suicide as well as homicides. Thank you for your cooperation. And thank you for allowing me to speak today.
Thank you very much, Ms. Rice. Sorry for your loss, but thank you for sharing your story with us. Are there comments or questions from members of the committee? I do not see any, but I would like to thank you again for joining us and offering your testimony, and I hope you enjoy the rest of your day.
Thank you.
Next, we have Jonathan Perlow, who I do not see, followed by Brooke Cheney, who I do see, and then she will be followed by Melissa Kane. Good afternoon, Brooke. How are you?
I am good, sir. Thank you.
Good to see you. You may testify.
Why, thank you. Co-chairs Winfield and Staffstrom, Vice Chair Castle, Vice Chair Blumenthal, and all members, all esteemed members of the Judiciary Committee. My name is Brooke Cheney. I'm a mom, I'm a firearms instructor, and a competitor. I'm also a mental health advocate. For the past 3 years, I've been advocating for suicide prevention. This year, I have a new shirt on because I am also the leader of Connecticut State Leader for the DC Project, which is a group of women who want to put a better face on gun owners in America. I come here to you today in opposition of 6355. Like you, I've heard most all of the same objections. Mine is absolutely around mental health, due to the fact that suicide prevention is really what we need to be focusing on. I did submit my testimony, and I apologize, it is late, so I'm going to read a little bit of it. My understanding is that doctors are a possible expansion on the list. As a gun owner who works to help break the stigma around mental health, this is not a step in the correct direction. Education is what I wish we were talking about, not more legislation. The legislation makes it harder to break the stigma around getting help for gun owners, just as Holly Sullivan had mentioned earlier today. Since two out of every 3 gun deaths is a suicide, this change in legislation has a possibility of actually increasing deaths versus preventing them. My heart breaks for any loss of life by a gun. I would also like us to be discussing ways to actually prevent violence as well at all levels, not just gun violence. There's copious studies that I've read about stopping violence by the CDC, FBI, DOJ, Department of Education, and more. I bring them up to you year after year in hopes that we will be here discussing the hard work that needs to be done, not just the simple swipe of a pen that turns law-abiding gun owners into unwanted targets and criminals. I respectfully thank you for your time. And if you would like to see some of the studies I'm referring to, I've actually put them on a website called Save Thousands, Not Just One. And that, sir, is my testimony.
Thank you very much, Brooke, for your testimony. Let me check. Are there comments or questions from members of the committee? I do not see any, but thank you for joining us today and joining us again as you have in the past. I hope you get to enjoy the rest of the day.
Thank you, Senator Winfield, and keep up those workouts. You're doing a great job.
Thank you. I am told that Jonathan Perlow has joined us, so the order will be Jonathan Perlow, Melissa Kane, and then Ray Bevis. Mr. Perlow?
Thank you. Sorry for that technical glitch. Hello, Senator Winfield, Representative Staffstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Jonathan Perlow. I'm Director of Communications for Connecticut Against Gun Violence. I'm testifying in support of HB 6355, an act concerning risk protection orders to strengthen our current extreme risk protection order law. As you're aware, Connecticut was the first state in the nation to pass an IRPA law back in 1999. It offers a means of last resort with due process protections to temporarily remove firearms from individuals judged to be at risk of imminent harm to themselves or others. My testimony focuses on the provision in the bill that requires a demonstration that the respondent no longer possesses immediate or imminent risk of personal injury to themselves or others before his or her firearms are returned. IRPAs have been passed in 19 states and DC because even though individuals may legally possess guns, they can still be dangerous to themselves or others. The measures in place that keep firearms out of the hands of dangerous people, especially criminal background checks, operate at a point in time when a firearm is purchased. These measures can't detect dangers that family members, friends, medical professionals, coworkers, and others can sense, which may develop long after firearms were purchased. In Connecticut, upon finding of clear and convincing evidence, a judge can order the removal of firearms for up to a year. However, at the expiration of the protection order, there's no affirmative process to ensure the respondent is no longer at risk of violence. While it's possible and certainly hopeful that whatever factors led to the risk have been addressed, most likely through treatment, there's no guarantee of that, nor that the treatment has significantly mitigated the risk. Therefore, in my opinion, it's simply common sense that before returning lethal weapons to someone who was previously judged to be at risk of imminent acts of violence, we want a judge with appropriate due process protections to determine that it is safe to return the firearms. Assertions we've heard today by opponents of the bill that IRPA laws violate due process and Second Amendment rights have no merit. According to a 2019 Congressional Research Service report, no court has found that any ex parte or final IRPA law violates any aspect of the United States Constitution. As well, there's no evidence that I am aware of in Connecticut or elsewhere that the process is routinely used to harass gun owners as opponents fear. In Connecticut, judges are required to have clear and convincing evidence to issue final risk protection orders. And just like any court hearing, a person who falsely testifies under oath would be guilty of committing a perjury, which is a crime. So I ask you that you favorably report the bill out of committee, and I thank you for your time today.
Thank you, Mr. Perlow. Are there comments or questions for members of the committee? Representative Howard.
Thank you, Mr. Chairman. Mr. Perlow, thank you for your testimony. Just the last thing that you said was that when somebody submits testimony under oath, makes a false statement, that's a crime. Would that be what your position would be as the safeguard to prevent, somebody gaining one of these orders, not correctly using that information?
Well, I think there's two safeguards. The most important safeguard is it's the judge who issues the extreme risk protection order, not the the complainant or the person entering the order. So I mean, making the complaint. So that's the first protection, is a judge is using criteria to determine the outcome. And the second one is the risk of committing perjury. And I think for many people, the thought of spending 5 years in jail potentially, in order to harass somebody is probably not a very palatable outcome.
Thank you for that. So let's talk about the judges just briefly. So that's one of the safeguards. If I told you that we had a juvenile court judge who testified here at a renomination hearing who was unfamiliar with how long a police officer could hold on to a juvenile before he'd be released, would you think that'd be believable or unbelievable?
I'm sorry, could you repeat the question?
Yes, certainly. Would you expect that a juvenile court judge would know the laws regarding how long a police officer could hold on to a juvenile who's committed an offense?
I would expect them to know the laws, yes.
Right, so if I told you that we had a juvenile court judge who testified before us who didn't even know that, would that be believable or unbelievable?
Well, coming from you, I trust that if you assert that it is believable.
Okay, certainly unexpected though, right?
Correct.
Okay, well, it did happen. So that's one issue. The other thing is, are you aware of individual states' attorneys' positions in certain districts regarding arresting people for making false statements in certain aspects of that law?
I don't have knowledge of that one way or the
So
other.
for example, if I were to tell you that as a police investigator, I investigated a complaint that was made under oath of a sexual assault, and we had very, very clear evidence that that complaint was false, and I told you that the state's attorney's office took a position that in an effort to not deter people from coming in, they did not want to charge that person with a false statement. Would you take my word on that?
As well as I know you, I would take your word on that.
Because that's a fact too. So my concern that I'm getting at, Mr. Perlow, why I thank you for your testimony, is it's just a fact that unfortunately judges are charged with a lot of things, and they don't always follow all these as one might hope or expect. So to lean on that as a safeguard, as we've seen in this committee with the story I told you, is a little troubling to some folks. And I can tell you from experience that a lot of times our state's attorney's office takes a position that if somebody makes a statement like that and it's proven to be false and that person is arrested, it may deter other people from coming forward with maybe questionable facts, and they don't want that. And when what you say as those two safeguards, while it may sound excellent, and I would agree with you, I submit to you, sir, in practical application, I believe that they fall short in my experience. And that's my concern, and I hope you can understand that.
I understand that, and I guess, there's always problems with the system, but we don't not pass laws because there's some other problem. We have to solve those problems, and I'm here today to try to solve this problem. So, and I appreciate your concerns.
I apologize as we use this technology. I thank you for that, and I thank you for your courteousness in this dialogue. And Mr. Chairman, as always, I thank you for the time.
Thank you.
Thank you, Representative Howard. I see Representative Fiorello has a comment or question.
Thank you, Mr. Chair. I just wanted to say hi to Mr. Perlow, who is a neighbor in Greenwich, and we have worked together in the past on voting issues. I don't have a comment, but I'm very grateful for his testimony. It's nice to see you, Jonathan. Thank you.
Good to see you, Representative Fiorello, and congratulations on your election.
Thank you. Good to see you.
Thank you, Representative Fiorello. And I do not see any other comments or questions, no hands raised. So Mr. Perlow, thank you for joining us, and have a great rest of the day.
Thank you so much. Appreciate it.
Next, we'll hear from Melissa Kane, followed by Ray Bevis, and then I see Tara Volpe is after that. Is Melissa? I believe I saw Melissa Kane.
Yes,
You have 3 minutes.
Thank you. Good afternoon, Senator Winfield, Representative Staffstrom, ranking members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Melissa Kane. I'm from Westport, and I'm chairman of the board of Connecticut Against Gun Violence. I am testifying in support of HB 6355, an act concerning risk protection orders. CAGV's executive director, Jeremy Stein, members of the staff of CAGV, and numerous members of the public have testified to the specific reasons how and why our current risk warrant law needs to be strengthened as proposed in HB 6355. For me, it comes down to common sense. We have a law that is good and was an early model for others. We can make it better. Under current law, the subject of a risk protection order is able to retrieve his or her firearms upon the expiration of the warrant without any burden of proof that they no longer represent a risk of harm to themselves or others. That doesn't make sense. Public safety is clearly in jeopardy if firearms are returned to someone from whom they were temporarily removed because they posed a risk of imminent harm without finding out if that risk no longer exists. Instead, when the protection order expires, it must be a requirement that the respondent prove by a preponderance of the evidence at a court hearing, as HB 6355 specifies, that they're no longer a risk of violence before firearms are returned. That's just common sense, and Connecticut has an opportunity to lead the way here. As we've seen, ERPA laws in general are an extraordinarily important legal tool, because even though someone may legally be able to possess guns, they can still be a danger to themselves or others. Background checks are a point-in-time measure that can't detect dangers that family members, friends, and coworkers can sense. An FBI study of the pre-attack behaviors of active shooters found that the average shooter displayed 4 to 5 observable and concerning behaviors over time. And studies show that 80% of people considering suicide give some advance warning of their intentions. The risk warrant, as a last resort temporary removal measure with due process protections, is an effective tool for reducing gun violence. However, because firearm suicide accounts for up to 2/3 of gun deaths and is the second leading cause of suicide in Connecticut, there is truly an urgent need to strengthen our ERPA law in the ways laid out by HB 6355. Expanding the warrant to preclude a person who poses a risk to themselves or others from purchasing firearms, and making sure that firearms aren't unintentionally returned to a dangerous person. Again, it's simple. Someone who possesses a demonstrable threat to themselves or others should not be able to purchase a firearm or have access to a firearm. I ask that you favorably report HB 6355 out of committee. We need a better tool at our disposal to prevent firearm suicide and homicide. We need the changes to HB 6355 that it puts in place in order to save more lives. Thank you so much for your consideration.
Thank you, Ms. Kane. Are there comments or questions from members of the committee? Representative Dubinsky.
Thank you, Mr. Chairman. And thank you for coming in, Ms. Kane. You said that the use of firearms is the second leading cause of suicide in Connecticut. What's the first?
I don't have that data with me. I just know that firearms are the first. Excuse me, the second. Apologize.
Okay, so there's a way that people kill themselves more often than with firearms in Connecticut.
That it would seem, yes.
But you don't know what it is.
I believe it's car accidents, but I don't have the data with me. But I'm pretty sure that's not suicide, but I know that that's a leading cause of death in Connecticut as opposed to suicide death.
Okay. In order for an abused woman who's been battered to effectively protect herself with a firearm, she needs to pose an imminent risk to her batterer, doesn't she?
Could you repeat that?
In order for a battered woman, a woman who's been beaten by her spouse or her significant other and is in fear of her life, the only way that she can effectively protect herself with a firearm is by posing an imminent risk to that batterer. Isn't that right? Otherwise, she's not able to effectively defend herself with that firearm. She must pose an imminent risk to him.
Well, I would argue that that batterer poses an imminent risk to her if they have a firearm. And
exactly, that's why she's
right.
got a firearm to defend herself.
I believe that more often than not, when there is a firearm involved in domestic violence, a woman is killed. So I believe it's the batterer that poses the risk with the firearm.
Okay, but if the woman's got a firearm, woman is highly trained. She knows how to handle a firearm.
That's an assumption.
She's been beaten.
One second, Representative. Sorry. 1 second. I would just suggest to Ms. Kane to let Representative Dubinsky ask the question.
I apologize. I'm sorry.
Okay, I'll start again. Thank you, Mr. Chairman. So a woman is trained with a firearm, knows how to use it, has been over the course of perhaps months or years been beaten by a spouse or a significant other or somebody, and she is now armed herself and attempting to protect herself from this batterer. She has to pose a risk to him. She has to pose an imminent threat to this person with that firearm in order to protect herself with that firearm. Is that not true?
Well, again, I would argue that the risk is posed to her. So I'm not sure I'm understanding your argument. If there's a risk posed to her, and she's battered and someone poses a risk to her, she would hopefully be able to have that risk removed through our ERPA law.
Representative Davidsky, I'm going to suggest that you've gone around 3 times with this question, and perhaps there's no new ground to tread here, but I'll give you a little bit more tether on that one.
Well, I appreciate it, Mr. Chairman. Ms. Kane appears to be deliberately avoiding my question, but I'll try one more time.
Representative, please do not we don't know. She may not be able to answer your question. Please ask the question, respond, wait for an answer.
I will ask one more time. If a woman is attempting to protect herself, does she need to pose a threat to her attacker?
I'm not sure I can answer the question. I suppose anyone who is defending themselves would be, could perform some sort of action where they are harming another. Yeah, that makes sense.
And if a woman chooses to protect herself with a firearm,
right,
she would need to be able to use that firearm in a threatening manner to that attacker.
Yes, I see where you're going with this, and I'm sorry, I didn't understand what you were saying before. I think that if a woman chooses to protect herself with a firearm, which has not necessarily been proven to be effective, that it could be characterized as a potential to harm her batterer. Yes.
So that batterer, now having been exposed to a threat, risk of imminent personal injury to himself,
right,
now can go into court and say, this woman poses an imminent threat to me. And he can say that without lying, because she does pose a threat to him, but it's a legitimate threat.
Well, true, but I think that the court has to find that there's no other reasonable alternative before removing her gun. That's my understanding. I suppose the other alternative would be to put her in jail.
Where do you see that in the bill?
That's what's been testified to here today, that there is no, that this is a last resort. Our risk warrant law is a last resort. Removing someone's firearm is a last resort.
Okay, so in your opinion, it should be a last resort.
Yes.
Okay, so in your opinion, there should be no other alternative.
I'm sorry, I don't understand how that follows. I think there should be if there's another alternative, it should be used.
Okay,
so, I'm sorry. Yes, there should. Right. If a firearm needs to be removed, it is because there is no other alternative. Yes.
Okay. So under current law, there must be a showing of probable cause and a showing that there is no reasonable alternative available. Is that your understanding?
That's my understanding, yes.
Okay. Now, do you understand that under this bill, that's no longer the case?
No, I do not understand that under this bill, that's no longer the case.
Well, let me ask you this. Under the current bill, under the current law, it's an attorney, a state's attorney, a state's attorney, an assistant state's attorney, or police officers that have to certify that they have conducted an independent investigation and determined that there is probable cause and that there is no reasonable alternative available. Okay, is that your understanding of current law?
That's my understanding, yes.
Okay, under this bill, under this bill, a family member or household member can file the complaint without doing that investigation and without determining that probable cause exists and that no reasonable alternatives are available. So under this bill, those protections that you just said should be in are no longer applicable when a family member or a household member files the complaint.
That's not my understanding. My understanding is that it's up to the court to decide what a reasonable alternative is. The court is ultimately making the decision.
Can you point me to any portion of existing law or this bill that indicates that that would be the case if this were passed?
I can't point to a specific line, but I can point to the fact that that is the understanding of the bill, that we trust our court system. That is part of the process. That's why there is a hearing before a court to determine that.
Okay, so
in both the existing bill and with the changes of HB 6355. Nothing changes. The court is still the determinant.
And it's your understanding that under this bill, the court cannot accept the complaint unless there is no reasonable alternative?
That is my understanding.
Okay. Well, I would suggest to you that your understanding is incorrect and that you should read the bill again, because that's not what it says. Thank you, Mr. Chairman, and I appreciate your time, Ms. Kane.
Thank you.
Thank you, Representative Dubisky. Are there comments or questions from others? Ms. Kane, just so I know, you have a legal background?
I do not. No, I am not a lawyer. I'm not an expert.
So so your commentary on imminent risk, how are you qualified to answer that question?
As someone who has read the law, read the bill, and has a rudimentary understanding of the law that is currently in place, but I am not an expert, and I do not have any expertise in this.
And I'm not trying to challenge you. I'm just trying to place your responses to Representative Dubisky and determine how they should be.
I'm really not. I'm not qualified, as I'm not an attorney, to judge. This is from my understanding as a layperson.
I get that. And again, because my concern is that what was suggested by that exchange is that the woman is necessarily an imminent threat to the person who would be the person who had physically abused her. And I think the woman's actions are dependent upon the actions of the abuser, which takes away the imminence in that case. So I think that it's important that we know what your background is as you respond to that.
Thank you. Thank you. That was what I was somewhat trying to say when I was talking about the fact that she was actually at risk by her abuser. But I don't have the legal terminology.
That is appreciated. Comments or questions from other members of the committee? I do not see any. Thank you for joining us today. I hope you have a great rest of the afternoon.
Thank you so much.
All right. Let's see. I just want to check something real quick. I'm sorry. We have Ray Bevis, who is here. Mr. Bevis, you may testify. And I'm trying to find out. I see Valerie Horsley. I think I may have skipped her. I'm going to check. If so, she'll be next. Mr. Bevis.
All right. Thank you. My name is Ray Bevis. I'm from Wolcott. I'm here in opposition to 6355, an act concerning risk protection orders or warrants. And I'm here supporting 6491, an act concerning non-lethal electronic defense weapons. So I just want to say that we've heard many claims tonight or today. I'm used to being here at late at night. So many claims today that our current laws have prevented suicides and mass shootings. So I think that's evidence that our current law is sufficient in meeting the needs of our residents. Furthermore, I do have great concerns that an unintended consequence of 6355, if passed, will increase firearm-related suicides. As we saw in one such measure in the passage of Public Act 13-3, which applied restrictions on the issuing and retention of firearms for people who had voluntarily sought mental health treatment, admitted health treatment. One of the provisions in 13-3 required that firearms owners temporarily surrender their firearms and permits for a waiting period before being able to retain them again. Law enforcement officers were not exempt from these requirements, and in the wake of several police officer suicides, law enforcement officers and law enforcement groups cited that statute as having been a deterrent on seeking mental health treatment out of fear of losing the right to carry firearms. In 2018 and 2019, the Connecticut General Assembly, committees in the Connecticut General Assembly acknowledged this fear and raised bills to address police officer suicide for nearly the 7,000 police officers in the state, while ignoring the other 300,000 permitted firearms in Connecticut. By adding mental health or by adding medical professionals to the list of petitioners who could go directly to the courts to petition for an ERPO without the investigation, I believe law enforcement officers and firearms owners will even be further deterred from seeking outpatient mental health treatment. I think this stigmatizes mental health in firearms owners and police officers. I also am opposed to the removing of the transfer of a third party on lines 116 through 117 of the bill. We have to remember that some firearms are actually family heirlooms that have been in possessions for families for 70 to 80 years and not only have monetary value, but even greater sentimental value. And we risk the chance of them being destroyed. I also want to support HB 6355, or I'm sorry, 6491. Through my years of advocacy, I've been contacted by many women actually who chose to protect themselves with firearms. And mainly a lot of these women have been avid hikers or joggers. And when I ask why they want a firearm, they tell me they want to carry in a forest, state forest, or a state park. And I advise them that unfortunately you can't do that. And the next question is well, what about a stun gun?
Mr. Beavis, we're past the 3-minute mark, so I just need you to wrap it up, please.
All right, thank you, Representative Stastrom. So that concludes my testimony. Thank you.
Thank you, sir. Representative Dubitzky. Representative Dubitzky, you're on mute.
Sorry. Thank you, Mr. Chairman, and thank you, Mr. Beavis, for coming in. In the short time you had, you briefly mentioned lines 116 and 117 and the change in this bill that's represented there. Could you just explain what that change represents and why you would oppose it?
So what that change represents is currently under current law, someone that has an ERPO issued against them can transfer their firearms to a third party, provided that third party is qualified and is permitted to have a firearm, and provided they go through desk, get an authorization. Under this bill that removes that, so it only gives the ERPO, the person that has the ERPO against them, two options: one, to remain in police custody, and as we know, police can destroy them after 12 months, or second, have them held by an FFL. And FFLs usually do charge storage fees and transfer fees. And my main concern is, like I said, we have a firearm in my collection that was my great grandfather's. Been in our family for almost 80 years. I would feel really horrible if that firearm got damaged in a police storage or evidence storage facility, or even just manhandled in the back of a police car and thrown into a pile of firearms. So I think that option still should remain. Obviously I oppose the entire bill, but I also specifically oppose that.
So, for example, if somebody issued if somebody went to court and had one of these warrants, one of these orders issued against them under current law, they could, for example, transfer their firearms to a parent or somebody else who was authorized under law to possess firearms. Is that right?
That is correct.
Okay, and under this bill, that would no longer be the case?
That is, yes, that's my understanding of lines 116 and 117.
Okay, now, do you have any idea why that would be in this bill?
I do not have any idea. I could make some assumptions, but I do not have facts.
Okay. Now, you have testified before this committee a number of times before on similar bills, and certainly the risk warrant issue. One of the things that you previously testified about was a situation that you had with regard to a risk warrant. If if you're willing, would you be able to recount that for us and relate it to how that situation would be affected by this bill?
Well, thank you for that question, Representative Dubitsky. And just to clarify, I actually had someone issue or seek and was granted a temporary restraining order against me. And this was an individual that I never met in my life. We had, at the time, my wife, who had children in common with an abuser, didn't like the fact that she was remarried. He actually went to the court and on behalf of his children seeked a temporary restraining order against me, saying that I was alleging that I was abusing the children. And I had to leave my home for 14 days. And after we went to the 14-day hearing, I had to get a lawyer, and my lawyer presented our case and said, Your Honor, they've never actually seen each other before. They never even met. And the case was ultimately dismissed. But I do have to say that my ex-wife's abuser had multiple restraining orders against him, and he violated, I believe it was 9 out of the 13 restraining orders we've had. And that's ultimately why our family chose to arm themselves and get our carry permits and to carry firearms, was because we realized that he was not going to honor this piece of paper.
Now, in your situation, it was your wife's ex-husband, is that right?
That's correct.
Okay. Now, if they had still been married under this bill, would that abuser have been able to go to court and seek an order removing your wife's firearms at that time?
Actually, I believe under this current bill, it would still be able to happen, because it says if they have a child in common. So if they had a child in common, which they did, he would be able to disarm her at any time. And let me tell you, he actually got, during our years of going through that process, he actually would seek restraining orders on her just so he would know where she would be, because she would have to show up to the court hearing and he'd be waiting for us in the parking lot when we got there. So we'd have to call in advance to have the marshals meet us outside and escort us in, because he used this restraining order as a tool just to make sure he knew where she was going to be, and he could try to catch her in the parking lot, or he'd follow us home. And this happened numerous times. It wasn't just once. He knew the system and he played the system.
So under the existing law, he was able to get you out of the house for 2 weeks. And under this bill, he potentially could be able to disarm your wife, and God knows what he could do at that point.
I would have to agree with that. And, I don't, if we both have firearms in both of our names in the same residence, I'm assuming all the firearms would be removed, just not my wife's.
Thank you very much. I appreciate it. Was there any other portion of this bill you wanted to comment on?
No, I think I covered all of the topics. So thank you.
Okay, well, thank you, Mr. Beavis, for coming in, and thank you, Mr. Chairman.
Thank you, Representative Dubisky. I see Representative Pavlik Amato has a comment or a question. Or did you already go?
No, I didn't go yet. Just one question,
Okay.
Mr. Chairman. Thank you. Mr. Beavis, I know somebody else had talked about being charged then with perjury in the case of filing any type of false request or complaint or for any type of restraining order and of course in court that is broader. Did that individual, was he ever charged or charged with making a false statement under oath?
Thank you for that question, Representative. And that's you actually bring up a good point, because that was something I said to my lawyer. Is I'm like, well, can't we have him arrested for making a false accusation? And my lawyer at the time kind of snickered and he says, that's not how it works. And I says, well, could we go after him civilly for my troubles of having to been removed out of my house for almost 2 weeks? And my lawyer's response was, the guy doesn't have a house, he doesn't have any assets, what is he going to pay you? He's like, it's going to cost you more money to go after him. But I was really upset, because I was anticipating that they would see the facts and they would actually arrest him and say, okay, well, there's actually an active restraining order against you for someone else that lives in the house, but that never happened.
Yeah, I have to say, I've been doing family law for many years now, and I have, when it comes to perjury and filing false complaints, I've never seen anybody be pursued for that. And I assure you, anybody who makes false claims, they don't know if there is a 5-year type of possible penalty. They're not looking up the law to even know that. But I've never come across that for the reasons you said. Having to get an attorney, that costs money. And I'm sure there are things that a judge can do, but it just isn't the practice in courts as we see it. And anybody who is in family court and otherwise knows this. So thank you for your testimony.
Thank you.
Thank you, Representative. Other comments or questions? So, Mr. Beavis, I want to thank you for joining us today, and have a great afternoon.
You too. Thank you, Senator Winfield.
So I'm going to clarify that we have 2 people who were in the queue that did not testify. So the order now will be Jason Levy, Valerie Horsley, Tara Volpe. Mr. Levy, are you here? Okay, well, let's see. Okay, there you are. You have to unmute. And you have 3 minutes.
Hi, yeah, so I just want to clarify, Jason Levy ceded his time to me and I was told I could go at the end. So I'm taking the ceded time from the very beginning,
Okay.
If that's acceptable.
Okay,
Great.
So thank you for that clarification. So then we will have you at the end,
Okay, that's fine.
you were told. So then we'll hear from Valerie Horsley, Tara Volpe, and then Michael Navaroli.
Hi, Judiciary Committee. Thank you for your service to Connecticut. My name is Valerie Horsley, and I'm a resident in Hamden, Connecticut. I'm here to testify in support of HB 6355, a bill that would strengthen our extreme risk protection order law. A few weeks ago, a friend and colleague of mine from New Haven called me. She is also a scientist by training, like myself, and she was very concerned about her stepson. He had lost his job, was out of work, and was dealing with severe depression from the pandemic and his life situation. And she was very concerned, because she knew that he had firearms at home, and she was worried that he might harm himself or someone else. She wanted to know what I thought she could do, because I know people that know the laws in Connecticut. Her story reminded me of a call that I got in the year 2000. I was 23 years old and my grandmother called me to tell me that my dad had taken his life. I had seen him 2 days earlier and did not realize how his bipolar disorder had impacted him. It turns out that he had gone to get medication a few weeks earlier, but it hadn't kicked in yet. He told his friends that he needed help, and he got help. But unfortunately, our current treatments for severe depression usually take weeks to lift the melancholy that folks find themselves in. In fact, 25 to 60% of bipolar patients will attempt suicide at least once in their lives, and between 4 and 19% in their lives. ERPOs would allow a temporary removal of guns from individuals at risk for imminent harm to themselves or others. This bill could help my friend or people like my father so they can get the help they need in order to get out of the depression and help them survive their mental illness. Please pass HB 6355 to strengthen our ability to protect those that may be at risk to themselves or others. Thank you.
Thank you, Valerie. Representative Dubitsky.
Thank you, Mr. Chairman. Thank you for coming in, Ms. Horsley. When your friend called you, did you advise her to call the police?
I don't see what the story about my friend is relevant to this situation.
You just told the story about.
Yeah.
You just told the story, so I'm asking you about it. If it isn't relevant, why did you bring it up?
I don't understand why I'm being questioned about what I did with my friend. I was explaining a situation where someone with firearms could have harmed himself or others, and how this type of law would help in that situation.
Okay, well, I'm probing you about that situation and inquiring as to whether or not the existing law would be sufficient to protect everybody without this bill. So
well,
that's why it's relevant.
With all due respect, Representative Dubitsky, I've watched you probe other public members on this call.
So here's what we're going to do. Representative, you're going to ask a question. She's going to answer the question. If she can't, we're going to move to the next question. We're not going to go back and forth, and we're not going to have a fight.
Thank you.
Representative, you may pose your question. Valerie, you can answer the question. Please continue.
Thank you, Mr. Chairman. Is there something under the existing law that you feel is insufficient to have protected the parties in the story you just recounted to the committee?
I'm not a lawyer nor a legislator, so I don't know how to answer your question.
Okay. If you're unaware of whether or not the existing law would have protected them, why is it that you want the law changed?
It is my right as a citizen in Connecticut to support legislation as a resident. That is why I'm here, and that is why I told the stories that I did today.
Okay. So as far as you know, the existing law would have been completely sufficient under those circumstances?
As I said before, I'm not a lawyer, nor am I a legislator. I am a citizen that is here to give public comment in this public hearing.
Okay. All right. Well, thank you for your comments. Thank you, Mr. Chairman.
Thank you, Representative Dubitsky. Other comments or questions from others? Representative Palm.
Thank you, Mr. Chair. Dr. Horsley, it's good to see you. I just wanted to thank you for your testimony and to ask you, as a scientist, evidence-based decisions are very important to you, I would imagine, yes?
Yes.
So when the evidence shows us that several hundred people a year take their lives because through firearms. Would you constitute that as something of a public health, if not crisis, certainly a concern based on the data?
Yes, and what I mentioned in that our current medical therapies for depression are not acute. They take weeks to be able to help folks. And in those weeks, we could be saving lives if we can protect them from danger like guns. And so, you know, I think this is a great tool to be able to help until scientists discover new medicines that can pull folks out of depression immediately. Right now, we can't do that. And that's why this is important to me.
Thank you, Doctor. Thank you, Mr. Chair.
Thank you.
Thank you, Representative. Are there further questions? Representative Howard.
Thank you, Mr. Chairman. Good afternoon, Dr. Horsley. How are you?
Hi, thank you.
So jumping back to my colleague's question about the data, do you know what the leading cause of manner, or I should say method of suicide is in our state?
I'm not a suicide expert. I'm just here to tell my story as a citizen.
All right, thank you. So I think that I'll tell you that I'm not a lawyer either. I'm a policeman who's had the unfortunate experience of investigating many suicides, far too many that I'd like to recall, and also the unfortunate experience of leading families down that path of grief. So I share your passion for the subject, believe me. My question is, you're testifying in support of this bill to prevent folks who suffer from depression from using firearms to take their lives. Is that correct?
Correct.
Okay. Would you support, and if I were to tell you, and hopefully you'll take my word for it, that the leading cause of suicide in the state of Connecticut, according to recent data, is actually strangulation, deaths by hanging. Would you support legislation that when somebody is a risk, that we take methods of out of their home of ligature? Would you support that legislation as well?
As a victim and survivor of suicide, I find it very disrespectful to me that you're talking about ways that people are killing themselves.
Well,
I'm going to say about that.
All right, Mr. Chairman.
I don't want to be interrogated by you.
Okay, Mr. Chairman, it's not my intent to upset anybody, so I'll stop my questioning there. Thank you, sir.
Thank you.
Thank you, ma'am.
Thank you, Representative Howard. I don't see any other questions. Dr. Horsley, thank you for joining us this afternoon. I hope your day improves. Enjoy the rest of your day. We will next hear from Tara Volpe, followed by Michael Navaroli and Alex Villamil. Ms. Volpe, you have the floor.
Thank you so much. Senator Winfield, Representative Staffstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Tara Volpe. I am the Director of Outreach for Connecticut Against Gun Violence. I'm testifying in favor of HB 6355, an act concerning risk protection orders. In my role with CAGV, I spent a considerable amount of time communicating with those impacted by various forms of gun violence. This includes those impacted by all forms of homicide, gun homicide, and gun suicide. In 2020, there were 212 gun deaths in Connecticut. I'm sorry, 212 gun deaths in Connecticut. 105 of those were gun suicides. These suicides occurred in 75 different towns and cities across the state, including Kent, Enfield, Stamford, Westport, Hartford, Brookfield, and many more. Most were white middle-aged men. Among them were current or former law enforcement officers. Others were veterans. They came from all walks of life and levels of income. Although extreme risk protection orders have value in reducing the potential for other gun crimes, including mass shootings, they're particularly helpful in reducing gun suicide. A Duke Yale UConn study shows us that for every 10 to 20 ERPOs served in Connecticut, at least one prevents a gun suicide. Additionally, in communicating with populations who prefer to minimize contact with police, many say having an alternative way to initiate an ERPO other than through the police may remove enough of a barrier that they would use this life-saving tool if necessary. This includes Black and Brown people and undocumented people. Removing barriers for all people to comfortably access an ERPO is the right and fair thing to do. On a personal note, when I was in college at home for a long weekend, I answered the phone around 9 o'clock, and it was my young nephew telling me that his parents were fighting and his father was threatening his mother, my sister, with a gun. This was in Vermont about 30 years ago. A lot happened after that call, but what didn't happen is my brother-in-law's firearms were not removed, and he did not have to show that he was emotionally or psychologically healthy enough to have those firearms. This was traumatic for all of us. My sister lived in fear of that man until her marriage ended years later and now suffers from post-traumatic stress disorder in part because of that. I grew up in gun country. Nearly every family I knew had at least one gun-owning hunter in their house. My father was a lifelong hunter. I have great respect for the sport of hunting and its connection to Vermont's heritage. I have enjoyed many meals due to my father's hunting skill, and I know he very much enjoyed his weekends at deer camp with his friends. My father was also a Vietnam vet, and when he was a young boy, his own mother was shot and killed by a hunter, his own father. I know from lived experience that firearms can put food on the table or destroy a family and cause lifelong trauma. Firearms come with huge responsibilities, not only for those who own them, but for those who live with them. Strengthening our current ERPO law in the ways described in this bill simply increases how we take care of not only vulnerable gun owners, but those around them during times of concern and stress. For these reasons, I ask you to vote in favor of HB 6355. Thank you.
Thank you, Ms. Volpe. Other comments or questions from members of the committee? Representative Blumenthal.
Thank you, Mr. Chair. Just wanted to say hi, Tara, and I really appreciate you being with us today and sharing those stories. They're very important to hear as we are making decisions on bills like this.
Thank you very much, Representative.
Thank you, Representative Blumenthal. Other comments or questions from members of the committee? Representative Paul.
Thank you, Mr. Chair. Ms. Volpe, hi, it's good to see you. I wanted to ask you a similar question to what I asked Dr. Horsley about whether or not you think that the preponderance of suicides caused by firearms is something that we should consider a health epidemic, or at the very least a concerning trend, especially given the stresses that people are under now. Are you seeing any evidence of increased risk of people who are suffering mental health issues?
I mean, you know, listen, this is we're all in a very stressful time. What I can tell you is that among firearm deaths in the state of Connecticut, the largest number is gun suicide. And so, you know, that is something that I think we need to give greater consideration to, and expanding how folks can access an ERPO, you know, and ensuring that, you know, folks who are uncomfortable contacting police, you know, all of these extra options, you know, it is reasonable to think that this would lend to the possibility of saving lives.
Thank you. Thank you very much for that, Tara. Thank you, Mr. Chair.
Thank you, Representative. Are there other comments or questions from members of the committee? I do not see any. Therefore, Tara, thank you for joining us again today. I hope you enjoy the rest of your day.
Thank you so much. Thanks for everything that you guys have done. Take care.
We will hear next from Michael Navaroli, and then Alex Villamil and John Harmon. Is Mr. Navaroli in? Mr. Navaroli. Okay, I thought you were in. Alex Villamil, I see you. Please unmute, and you have 3 minutes.
Thank you, Chairman Winfield. Senator Winfield, Representative Staffstrom, ranking members Kazel and Fishbein, and distinguished members of the Judiciary Committee. My name is Alex Villamil. I am from Sandy Hook. I'm a supporter of Connecticut Against Gun Violence. I've been a common sense gun legislation supporter, and I believe that HB 6355 being discussed today falls under that category. The reason for my testimony dates back to a late night call from my father in August of 1982. I was living in Washington, D.C. at the time, and I was asked by my father to come back to Connecticut. My older brother had been shot to death. My brother, Carlos Villamel, owned a limousine company in Stanford. And after some erratic behavior from an employee, my brother decided to let the employee go. The day after he was let go, the individual showed up at my brother's office and demanded his paycheck. My brother was in between meetings, so he asked the individual to come back later for his check. The person became irate, refused, and an argument ensued, culminating in his former employee pulling out a gun and shooting my brother 5 times in the back. Killing him on the spot. The airport law in our state was not enacted until 1999. I believe that's had such a law existed in 92. When my brother, excuse me. In 1992, if the law had existed in 92 when my brother was killed, it may have prevented the tragedy from occurring. The current provisions to bolster the law in HB 6355 would have made it easier for individuals who noticed erratic behavior from other individuals to bring it to the attention of the authorities and prevent such horrible events from happening. My brother's death could have been preventable had responsible laws been enacted at the time. So much grief could have been averted. My brother was 32 years old at the time. He had a wife, 2 young children, ages 4 and 9 months. His wife lost her husband. The kids grew up without a father. And I lost an older brother. Responsible legislation is a duty of her representatives, legislators such as yourselves, to provide in a civilized society in order to prevent such occurrences from happening. The man who shot my brother was mentally ill. Perhaps someone close in could have gone to a judge, as HB 6355 proposes, taking the gun away from him and perhaps got the mental help that he needed. A great deal of pain could have been averted. The irreparable harm committed against my brother, our family, the perpetrator, and even the perpetrator's family could have been headed off by the 1999 law and the current proposed provisions in HB 6355. I see this as a logical and preventative piece of legislation. Any concerns of due process are adequately addressed in the bill, in my opinion. Members of the judiciary, once the damage is done, when it comes to a loss of life, there's no way to nullify the harm. Preventing the occurrence through savvy and thoughtful legislation can prevent unnecessary deaths. I urge this committee to vote in favor of HB 6355. Thank you for your time, and my apologies for the emotion.
Thank you, Mr. Villamil. But certainly you don't have to apologize for the emotion. It's actually normal. Representative Howard.
Thank you, Mr. Chairman. Mr. Chairman, I have a brother, and at his wedding, when I gave a speech, I said that having a brother is God's way of giving me a best friend for life. I respect Mr. Villamil sharing his story here today, and I certainly understand the trouble with which he had to deliver it. I wanted to make sure, Mr. Villamil, that you didn't cut your testimony short, given the trouble you had at the beginning. And if you did, sir, I'll afford you time to touch on anything that you didn't have an opportunity to.
No, I pretty much covered everything, but I am willing to answer any questions that you may have for me. This is a very important issue, and as you can tell, even after 30 years, it still feels like it happened yesterday.
Yes, sir. I certainly understand and respect that, and I do not have any questions for you, but my fear was that you were fearing the clock and may have cut yourself short to catch it, and I wanted to make sure you had an opportunity to say everything that you wanted to say. And if you're all set, Mr. Chairman, I am too. Thank you.
Thank you. Thank you, Representative Howard. Thank you for that. Are there comments or questions from other members? I don't see any. I want to thank you. It was clear how difficult that was for you. And I want to thank you for coming and sharing with us today. It really shows how important the issue is to you. Thank you very much.
Thank you.
Michael Navaroli is in the room now, so we'll hear from Michael Navaroli, followed by John Harmon and Michelle Voigt. Mr. Navaroli, please unmute, and you have your 3 minutes.
Okay, good afternoon, Representative Winfield, Zabinski, and Kissel. I'm a lifelong resident of Connecticut, 74 years. I've witnessed a lot going on in the state. I can't say I agree with it all. There has been a lot of gun laws there put on the books that I don't think were necessary. I think the gun owner has been hurt in a big way. I remember I used to be a Teamster. Well, I still am a retired Teamster. And I used to make deliveries, pick up all kinds of gun-related stuff, Colt firearms, and all the way down the line to New York City. And this state was actually built on the gun manufacturing business and the jobbers that made parts and stuff for these weapons. I do oppose 6355 and Bill 6491. And I think it just adds to more stress on the gun owner of keeping up with things. And I don't think it's really necessary. I think the laws we have in place now are more than adequate, and they should suffice for any occasion coming up. As far as suicides and stuff like that, I mean, it's kind of harsh maybe to say, but some families just have that gene in them that somewhere along the line something's going to happen. The brain is a delicate thing, and snap things happen. Feel sorry for everybody that possesses the gene, and it's an awful thing to have to experience. Myself, I was a victim of an assault. The guy assaulted another senior citizen before me, and I was knocked to the ground and almost knocked out. And the guy only got a lousy 6 months out of it, a second offense. And I was kind of really ticked on that. So what I'm saying is, they ought to make more laws stricter and make the penalties lengthier rather than going after, gun owners that are went through background checks, law abiding, pistol permit owners or weapon, long gun owners, and adhere to all the laws that are on the books, and turn it around and go after the criminals, not the gun owner. And that's all I have to say on that. Thank you.
Thank you, sir. Questions from the committee? If not, I appreciate you being here and sharing your story with us and your perspective. Next up will be John Harmon.
Hi, thank you, Judiciary Committee, for allowing me to testify. My name is John Harmon. I live in West Hartford, and I'm here to speak in favor of HB 6355. It's not a trivial matter to label a person at extreme risk and remove their firearms. It is certainly not a step taken lightly by any of the actors involved in the process. But the step for a gun owner to get their firearms back needs a change. That gun owner should demonstrate in a positive way that the risk is no longer there. They were found to be the risk, and they should be the ones to show that the risk is gone. And how about non-gun owners found to be an extreme risk under this law? Should they be allowed to purchase firearms while under this order? If an existing gun owner has surrendered or had his firearms removed, it doesn't make sense at all for non-gun owners under the order to be allowed to purchase firearms. Finally, this legislation removes an important barrier to its use. Under the current law, the process a person at risk contacts and deals with the police. There are many in Connecticut who have difficulty with this. People whose previous interactions with police have made them afraid to contact them. What about individuals who might have a warrant for failure to appear, but are in abusive relationships with a gun owner and are fearful for their lives? Might they be afraid to contact police? The proposed change would allow those people in extreme risk to approach the court directly, where the matter at hand would only be the risk. The judge has more discretion than a police officer. Now, I've not been a victim personally of gun violence, and I hope never to be one, but I regularly attend vigils conducted by the Hartford group Mothers United Against Violence, and I've witnessed the pain and horror of families who have lost loved ones to this violence. For years, Connecticut has been at the forefront of humanely dealing with this scourge of gun violence, and the changes proposed in HB 6355 are a few more small steps of common sense that I think you need to take. Thank you very much for listening to me.
Thank you, sir. And thank you for your testimony. Are there questions? Seeing none, we appreciate you being with us. Next up will be Michelle Voigt.
Distinguished members of the Judiciary Committee, my name is Michelle Voigt. I'm a resident of Greenwich. I'm a volunteer leader with Moms Demand Action and serve as the survivor lead for Connecticut. Today, I'm testifying on behalf of the Connecticut chapter of Moms Demand Action for Gun Sense in America in support of House Bill 6335. My Aunt Louise loved me before she knew me. In my eyes, she was magical. She was beautiful, full of life, full of everything, full of joy and despair. Aunt Louise was my hero and my biggest fan. An unrivaled free spirit, she loved huskies and everything purple. A flag majorette in the Alabama $1 Million Marching Band. Aunt Louise was a true Bama fan. So concerned was she for the horses pinned on a nearby military base, she freed them. Her acts of compassion became legendary. One afternoon, she pulled into a gas station, stood on the corner, and announced, "Free gas." She handed the attendant her ATM card, and the fuel began to flow. A concerned clerk called the bank, and eventually they found my uncle. Upset, he demanded that she stop. The clerk cut off the gas, but my Aunt Louise, undeterred, turned around and gave the next person in line Uncle Joe's Porsche. Aunt Louise was magical. Aunt Louise was bipolar. Each of these adventures secured her return to the psychiatric hospital. Despite interruption, she returned to college, graduated with a degree in business, and became a successful financial advisor. She referred to herself as my crazy Aunt Wheezy. She was not ashamed of her illness, and she worked diligently to end the stigma associated with it. She fought every day of her life to live. In August of 2016, they decided to move, and she was so stressed. She called often, and I felt overwhelmed and powerless. In January, she sent my uncle out for a walk. She stepped out onto the front lawn of their new home and shot herself in the head. My Aunt Louise should have never had access to a firearm. She fought every day of her life to survive her bipolar disorder. With that firearm in hand, all her struggles, all her accomplishments, all her magic, gone, extinguished in one manic moment. Moms Demand Action supports the updates to Connecticut's current extreme risk law as proposed. It would expand the eligibility of those who could petition the court for extreme risk protection order. Family and household members, dating or intimate partners, specified medical professionals, and one police officer would be able to petition the court for an extreme risk protection order in addition to an assistant state attorney. Family members are often the first to recognize when their loved one is in crisis, and that's why we must have a way to take direct action. On average, someone dies from suicide every 3 days in our state. It's unacceptable. I strongly request your support, and I thank you so much for your time.
Thank you, Ms. Voigt, for being with us and for sharing your story. Obviously, yet another story and example of just how tragic the instances of death, suicide death by gun is in our state and around our nation. So thank you. Further questions or comments from the committee? Seeing none, I thank you for being with us and for all your advocacy.
Thank you.
Next up will be Jen Lawler.
Hello, everyone. My name is Jennifer Lawler. I'm a lifelong Connecticut resident. I'm a part of the Everytown for Gun Safety Fellowship Program. And most importantly, I am the mother of a murdered child. I am testifying today in favor of HB 6355, as I believe its update will save many lives. On December 8th, 2018, my 25-year-old daughter, Emily Todd, was shot and killed by a predator she'd met 18 days prior. It was not long after they met that she knew this man was not what he'd been presenting himself to be. On November 30th, she tried ending the relationship. It was then that he began texting her repeatedly, stating he was going to kill himself, that he had a gun, and he had written a goodbye letter. Emily was at work, but she stepped aside and called 911, desperate to help him. When asked, Emily stated clearly she was sure, absolutely certain, that he had a gun. She reported her concerns to the dispatcher, stating, "He's going to kill me for telling anyone this," and also provided his cell phone number, information on his current location, as well as the name and location of the motel that he had recently been staying at. After a 911 call that lasted well over an hour, police action was finally taken. Shortly after the call ended, a Bridgeport police officer spotted the car Emily had described. They made phone contact and asked the driver to pull over. As they attempted to speak with him, he evaded and a high-speed pursuit chase ensued. Minutes later, the pursuit was disengaged. Across the police radios, the on-duty sergeant stated, "If he is going to commit 42, he is going to commit 42. Disengage. We don't want any of our guys getting hurt." I want to reference the fact that 42 is the internal code used for suicide on the police scanners. Not the officers involved right then or any other members of this police department did anything to follow up on or investigate Emily's concerns. The police did not locate and take him for psychiatric assessment or into their custody for evading them. The department had his date of birth, his license plate number, the vehicle description, the knowledge that he possessed a firearm, along with a likely location where he could be found, and made no effort to locate and or apprehend him after disengaging from the vehicle pursuit on November 30th. Emily and myself both tried several times that week to call the police department for an update and got no response. Feeling very unsettled, we also both contacted our local police here in Bethel asking for their help. Our officers tried on 2 occasions to get information. No one in that department responded to the Bethel police. And 8 days later, this man murdered my daughter. I would like you to imagine what a daily horror it is for me, knowing that if the police would have apprehended Emily's murderer in the week that followed her 911 call, it is more likely than not that she would be alive today. Had the police department been as concerned for someone's human life as my daughter was, they'd have found him in possession of a gun he'd purchased in Ohio and brought across our state lines. This man, who she tried to get help for, considered her action a betrayal. He shot her at close range, putting a single bullet in the back of her skull. She was found unrecognizable, leaving me to identify my child through photos of her tattoos taken at a crime scene. Those we entrust to protect and serve failed my daughter in so many ways. She had her whole life ahead of her, and she is dead. The neglect and lack of care shown to Emily by the police has been a life-altering and the powerlessness we have experienced as a family, both before and after her murder is indescribable. Over the past 27 months, I have learned a great deal about Connecticut's IRPA legislation, and I believe the current policy regarding extreme risk is grossly outdated. Our tragedy has me certain that significant changes must be made to save the next young woman who will find herself in a situation she cannot control that calls to try to get help. We simply can no longer have a system that's dependent solely on the response of a 911 dispatcher and a police department as the only resource someone has when they're in a crisis. If passed in this session, HB 6355 would make several critical updates to the current IRPA protections. First, it would expand eligibility of those who could petition the court for an order to include family or household members and specific medical professionals. We've already reviewed the rest of the current law, but I'm going to just finish. 2 police officers right now or a state's attorney can seek the protective order, but with the new proposal, family and household members, specified medical professionals, and a single police officer would be able to petition. Family members are often the first to recognize when their loved one's in a crisis, so it's crucial they have a way to directly petition the court to temporarily remove guns from those who could be a risk to themselves or others.
Thank you.
In this updated legislation, the definition of family or household members includes, which is what is very important to me, dating or intimate partner of the person subject to the complaint, which would have given both Emily and myself options when not taken seriously by the police. This definition can be seen on page 5, lines 132 to 133. One study shows, I'm not going to go there, we've done it. The reduction in the firearm suicides, we've already reviewed that a lot today, and I believe that they are very real. Please know that while I have had my life absolutely shattered with what happened to my daughter, I am her voice, and I am willing to and capable of hearing your thoughts and or taking your questions. There's really, there's nothing else that could be harder than this that comes my way in life. Thank you for your time.
Thank you, Ms. Lawler, and I sincerely appreciate not just your presence here today and your willingness to share, you know, these most tragic and horrifying details, but also your relentless advocacy on and this and so many other issues. I know we've had a chance to connect on a few different bills before this committee, not all of which you agree with all the time, but you are always very, very passionate with your testimony, your advocacy, and certainly are making the best of that voice you were trying to use for your daughter. So I sincerely appreciate you being with us today.
Thank you.
And for your support of this bill. Representative Blumenthal.
Thank you, Mr. Chair, and thank you, Ms. Lawler, for being here today. I just wanted to echo the chair, who I think said it very well. You know, I also feel honored to have been communicating with you on this and a number of other issues, and I so appreciate the passion with which you bring your engagement and advocacy to these issues. It's an honor to know you, and you do tremendous work vindicating Emily's memory so that other families don't have to be in the position that you are in. So thank you for your testimony today. Thank you for your support of this bill, and thank you for all of your advocacy every day in memory of Emily and in advancing the safety of all the people of our state.
Thank you. Thank you for saying her name.
Representative O'Day.
Thank you, Mr. Chairman, and thank you so much for your testimony, Ms. Lawler, and I have no questions. I just want to, from all of us, so sorry for your loss and God bless.
Senator Winfield.
Thank you, Mr. Chair. I just want to echo what everyone else has said. You and I have had some discussions about various issues in different forums, and as Representative Stafstrom said, we're not always in agreement. But one thing that I think is really important is that your voice is present, and the power of your story really helps people who don't always see things the same way to understand why you advocate the way that you do, and why these issues are important, and why we have to take a step back sometimes and look at it from a perspective we might not have considered. So I just want to tell you, when given a chance to tell it to you face to face, thank you for today, but also thank you for the continued work that you, I know, will continue to do, and the conversations that you've helped to generate. So thank you.
Thank you, Senator Winfield.
Thank you again, Ms. Lawler, for being with us. Next up will be Warren Stevens. So you're on mute. Mr. Stevens, can you unmute yourself? You know what, sir, we're gonna skip you and come back to you while you figure out if you can figure out how to unmute. Let's go to Carmel.
I'm here.
Oh, there he is. All right, go ahead, Mr. Stevens. You have 2 minutes.
Well, before you start the clock on me, sir, I just got my COVID shot. I'm feeling a little out of sorts, so please bear with me today.
Well, congratulations on that. So
no, you know what? I hate needles. Let me know when the clock starts, sir.
Go ahead.
Members of the Judiciary Committee, I am the CCDL liaison for the Southington Sportsmen's Association and the Bell City Rifle Club, representing 1,000 members with spouses and family members. We're a voting block of 3,000 people. We vote Second Amendment. We adamantly oppose HB 6355, strongly support 6491. 6355 is flawed, dangerous, violates due process. Risk protection orders in another state have already cost the life of a man it was supposed to save. Current Connecticut protection order system has prevented suicide and mass shootings, so the law is working. Proposed bill violates First, Second, Fourth, Fifth, 14th Amendments at a glance, eliminates investigation by police, opens fraudulent complaints, no accountability for fraud, no standards for judges, and makes a person guilty of a crime they didn't commit. The accused has to prove their innocence after the fact, not the America I grew up in. It could take years and thousands of dollars for an innocent person to recover their firearms. Gary Willis of Maryland, regardless of the circumstances, was killed in his own home by being the subject of a protection order. Protection order removes firearms from a home, but no other means of someone harming themselves or others, such as chemicals, poisons, prescription drugs, sleeping pills, rope, wire, cordage, knives. HB 6355 therefore reveals itself for what it truly is, just another gun control law. Timothy McVeigh carried out the deadliest attack on US soil in 1995 using a homemade bomb, a fertilizer, gasoline, and instructions from the internet. 168 people were killed, 12 children included. A protection order wouldn't have stopped him. A 14-page report by the Rhode Island Civil Liberties Union stated red flag laws go beyond any reasonable effort to keep firearms out of the wrong hands. People have been subject to protection orders for voicing their opinion. A detailed evaluation of protected orders was carried out by the RAND Corporation using 20 years of data from the 17 states that have protection orders, Connecticut included. In the final analysis, effectiveness of protection orders was found to be inconclusive. In an op-ed posted to Doctors for Responsible Gun Ownership, Dr. Thomas Vaughn gave a systematic breakdown of the complete failure, concept, and application of protection orders. His op-ed was titled "Red Flag Laws or False Flags." Lastly, two police officer friends of mine said the most deadliest situation would be serving a risk protection order. They would not go to work that day. It would endanger both parties. The current bill is flawed, dangerous, goes against the very core of the Second Amendment, and another gun control law that does not make us safe. Thank you.
Thank you. Questions from the committee? Representative Veach.
Good afternoon, Mr. Stevens. I want to first thank you for coming and testifying today for us. I appreciate your trusting your knowledge and of laws, and I appreciate the fact that you're supporting your opinion with real life facts. I appreciate that.
They're very real life, ma'am. Thank you.
Thank you.
Further questions or comments from the committee? If not, thanks for being with us, sir.
Thank you very much.
Next up will be Carmel Kostolitz.
Yes, that's correct. Thank you.
All right, go ahead, ma'am.
Thank you. Senator Winfield, Representative Stathstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Carmel Kostolitz. I live in Cheshire, Connecticut, and I'm a supporter of Connecticut against gun violence. I'm a retired health professional who was employed by the state of Connecticut as an occupational therapist, working with people suffering from chronic mental illness. I'm testifying in favor of HB 6355, an act concerning risk protection orders. I have seen from my own experience the devastating effects that suicide of a loved one has on their families, friends, and communities. The rate of U.S. adolescents and young adults dying of suicide has reached its highest level in nearly 2 decades. In 2017, there were 47% more suicides among people aged 15 through 19 than in the year 2000. LGBT youth are also almost 5 times as likely to have attempted suicide compared to heterosexual youth. I cannot help wondering whether Adam Lanza, a deeply disturbed, mentally ill youth, would not have succeeded in murdering 20 young children and 6 female educators at Sandy Hook Elementary School in 2014 if he did not have access to firearms and assault weapons in his own home. If there were more public awareness about the ERPO law in Connecticut, and a family member or health professional could have used the law to remove the firearms from his home, it may have stopped a deadly massacre and saved 26 precious lives. The ERPO serves as a public safety protection in keeping firearms away from people who exhibit a threat of imminent harm to themselves or others. From my own personal experience, I remember a young man in the inpatient psychiatric unit that I worked in who expressed homicidal thoughts and ideation and was in possession of a firearm at his home. Finally, he was hospitalized before any violent action was committed. Connecticut's ERPO law allowed the court to confiscate his firearm temporarily. However, as a healthcare team, we struggled for months on end to decide if and when this young man was safe to return home, as he had potential access to a firearm. Up to 2/3 of Connecticut gun deaths are by suicide. Risk protection laws have proven to reduce firearm suicide. I believe that suicide is an act of desperation, which is preventable in the majority of cases. I ask that you favorably report HB 6355 out of committee so that the General Assembly can vote to strengthen our extreme risk protection law so that it works more effectively to prevent firearm suicide and homicide. I greatly appreciate your time and thank you for your consideration.
Thank you very much, Ms. Sorry about that. I didn't mean to cut you off. Thank you very much, Ms. Koslowitz. Are there comments or questions for from members of the committee? I do not see any. That being the case, thank you very much for joining us today to provide us with your testimony.
Thank you.
Have a great day. Next, we have Getachew Dyers, followed by Christopher Schenk and Harold Ayala. I do not see Getachew Dyers. Is Christopher Schenk in?
Hello, thank you.
You have 3 minutes.
Senator Winfield, Representative Staffstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee, I thank you for the opportunity to provide testimony in support of House Bill 6355, an act concerning risk protection orders or warrants. My name is Christopher Schenk. I'm a resident of New Haven, Connecticut, a medical student at the Yale School of Medicine, and a trainee in injury prevention research, as well as a supporter of Connecticut Against Gun Violence. I respectfully urge the committee to support House Bill 6355 because it will work to protect the people of Connecticut from firearm-related injury and death. In 2019, 190 people in Connecticut died from firearm injury. Over half of these died by suicide. The existing risk warrant statute in Connecticut provides a crucial mechanism for removing firearms from the possession of individuals who pose a serious risk to themselves or others. It is estimated that 1 suicide is prevented for every 10 to 20 risk warrants issued. The raised bill strengthens this life-saving tool by requiring that risk warrant respondents demonstrate that they no longer pose an immediate risk to themselves or others before firearms are returned. It also streamlines the process of obtaining a risk warrant by allowing family members and medical professionals to directly petition the court in addition to law enforcement officers. The COVID-19 pandemic has made urgent action to prevent suicides even more important. Increased social isolation, uncertainty, and financial crisis create dangerous conditions that increase the risk of suicide for many. Even as the incidence of COVID-19 falls and vaccines are widely distributed, many of these risk factors for suicide will persist in the upcoming months and years. House Bill 6355 offers a critical opportunity to protect people at risk for suicide. While writing this testimony, I thought often of a young man I met in the hospital who had survived a suicide attempt with a gun. During his stay, we spoke often about his school, his hobbies, his aspirations for the future. I remember the relief and the gratitude in his mother's voice that he was, in fact, still here with us. I'm also reminded of how fragile this reality is, how an inch to the left or right in a bullet's trajectory separates this reality from an alternate where another life is ended all too soon and another family is left grieving. A person's life should not depend on an inch. Risk warrants offer us a tool so that when a person is in crisis, a gun does not end up in their hands in the first place. When considering this bill, I ask that you think of this young man and his family and all those impacted by firearm injury, some of whom you heard from today. I respectfully ask the members of this committee to support this bill to protect the health and well-being of everyone living in the state of Connecticut. I'll gladly answer any questions at this time. Thank you.
Thank you. Are there comments or questions from members of the committee? I do not see any. That being the case, Mr. Schenk, thank you for joining us today and offering your testimony. Enjoy the rest of your day. Next, we will hear from Harold Ayala. I see Mr. Ayala's. There you are. I do hear you. I don't see you. Now we see you and we can hear you. Go, you may begin.
Good afternoon, members of the Judiciary Committee. My name is Harold Ayala. I'd like to start this off with a quote from James Madison. What is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. I, Harold Ayala, oppose HB 6355, a title, an act concerning risk protection orders and warrants. And I remind our committee of the 14th Amendment, where it states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of the life, liberty, or property without due process of law. nor deny to any person within its jurisdiction the equal protection of the laws. HB 6355 would be doing just that, denying the protection of the law to the good people of Connecticut. Risk protection orders and warrants based on hearsay evidence is one-sided. It's also not needed, especially when no crime has been committed. Whatever happened to innocent until proven guilty? Or are we throwing away the old government and make a new one? Below, on my written testimony handed in, I show some examples of the aftermath in other states, actions of no-knock warrant. Back in Louisville, Kentucky, police killed Breonna Taylor, who was only 26-year-old, when they came to serve a warrant. Also, gun seizure under extreme risk law. We look at other states like Maryland. Police leave suspect dead in the 100 block of Linwood Avenue. Arundel County Police serving the red flag protective order kills Ferndale man after refusing to give up guns. March 14, 2020, Maryland police kills a 21-year-old man while asleep. Girlfriend was injured. Colorado, New Year's Eve, 2017, well-known Matthew Rao suffered a mental breakdown. Rao had not broken any law, so deputies could only take him into protective custody for mental evaluation. Instead, Rao barricaded himself. Deputy Zach Parrish lost his life, as well as Matthew Rao. If they would have just backed off and let him be, I think he would have still been alive today, as well as Zach Parrish. I, Harold Ayala, support House Bill 6491, an act concerning non-lethal electronic device. We always want to use the non-lethal measures when defending ourselves, and that's why I'm in favor of 6491. That's all I have to say.
Thank you, Mr. Ayala. Are there comments or questions from members of the committee? I do not see any, so therefore, Mr. Ayala, thank you for joining us today and offering your testimony. Appreciate it.
Thank you.
Enjoy the rest of your day.
You do the same. Thank you very much. Have a good day.
We next have Eugene Williams, followed by Lucas Jura, and then Christian Song. Mr. Williams? You're in the room. I don't see, or I see you're muted and I cannot see you. Okay. Well, I think up there, we can see you now, and now you'd have to unmute and you get your 3 minutes.
There we go. Thank you very much to the committee and to Senator Winfield. It's been quite an emotional day. I wish to express my strong opposition to HB 6355. It's, to me, as a gun owner, I own guns for self-protection, and it seems that arbitrarily somebody in my life could just choose to, charge me or accuse me of being not a, that I shouldn't have guns. It just seems, I know it's unconstitutional, and I did hear it called constitutional many times today, but it's just an unconstitutional law. My heart goes out to the victims of suicide. There's been suicide in my life also. It's terrible. It happens, and it can't always be prevented. And we try to do our best, but we can. The lack of due process bothers me. Now, there is due process, but there isn't, because what could happen to a guy like me who lives at home with my little wife here in Bristol, Connecticut, is somebody decides they don't like me, or whatever, or that I'm a problem, and they can report me, and I could be laying in my bed, and all of a sudden there's a SWAT team there. I have a few firearms, and but I just believe in the Constitution. I also believe in a civil society. And I believe that we can protect each other without making further laws that will hurt people. I mean, there will be people that get killed because of this law, because say my guns got taken away for whatever amount of time, the due process comes later, and then I live on the edge of a rough neighborhood. Something could happen. Somebody comes through the door, and what am I going to do? I have arthritis. I'm just no taekwondo, no nothing, and my wife, and we'd be total victims. So I think that side of the things has to be seen too. I just strongly oppose this bill, HB 6355. I agree with everything that the people that oppose this bill said today, so I won't repeat it. But I also do agree with HB 6491. I've been a victim of a home break-in. I could call it a double home break-in back in 2008, and when I did not have a firearm because I just did not have one available. I didn't have anything available. I didn't have a non-lethal electronic device available, which would have been nice. It's kind of a long story, and obviously we can't get into it, but it was very, very scary situation that I had to deal with. I had to get involved and help somebody, and basically could have lost my life. Are you saying something, sir?
Mr. Yeah, I couldn't get a time mute. I was trying to alert you that your time has elapsed.
Okay, all right. Well, I'll wrap it up. I just want to say that I have been a victim of a home break-in. It would have been nice to have at least a non-lethal device in that situation.
Thank you, Mr. Williams. Are there comments or questions from members of the committee? I don't see any. Mr. Williams, thank you for joining us today to offer your testimony.
Thank you also.
Enjoy the rest of your day. Lucas Jura, followed by Kristen Song and Brian Rome.
Hi, my name is Lucas Jura. Can you hear me okay?
We hear you quite well.
Hi, relevant to my testimony today, I have severe young onset Parkinson's, and recently my insurance has cut off my medication this week, so I may have difficulty speaking at times. I am a retired state correction officer with no criminal history and no claims of excessive force. I spent a decade on emergency response, assisted with the creation of emergency planning. In early 2016, while extremely sick, I begged my wife to come to one of my many doctor's appointments, having been sick for a long time, where she was strongly warned by my doctor that I was severely neurologically impaired. She stormed out and shortly thereafter filed an ex parte restraining order against me, kicking me out of my home without due process at the height of my illness. It took me over 4 months of attempting to take myself to doctors, homeless, unarmed, and having my kids effectively kidnapped from me. 4 months later, I was diagnosed with Parkinson's and began treatment. I have increased my medication at every doctor's appointment and often in between doctor's appointments. I spent nearly half of every year up until last year, often stuck to the floor, too weak to dress myself, and even unable to tie my shoes. I burned through my accrued time, every type of leave available, and then after exhausting FMLA, was threatened with termination on a quarterly basis, only deferred by the intervention of my coworkers and administration. Each time my medication was increased, I attempted to pursue criminal perjury charges against my ex-wife, offering copious amounts of witnesses, photographic, electronic, and other evidence, and even texted admissions received by my witnesses. And each time authorities refused to take the report of a crime and refused to accept my evidence. Even after having spent the moments before offering me medical assistance, not realizing that I was there to complain. After my initial complaint to state police, and after a hearing, I was chased down by several detectives who apologized to me profusely, realizing that they had made a mistake, and repeatedly cold called numerous times in the weeks thereafter, never leading to the pursuit of an investigation. I have made complaints to state police in Middletown, Troop I in Bethany, professional standards in Meriden, every court agency I could think of, state's attorneys, and even CHRO. And I have been deprived of access and the ability to pursue charges or even allow evidence to be admitted. Each time I have had to give up my pursuit as my body became used to the medication, I became more disabled. The proponents of this law claim on one hand that it is a standard throughout the country, then claim we need to increase it. I am the second victim of my wife's shenanigans of using the court system, of using this system, which not even police officers consider to be, this system is used so much to harass their victims by abusers who know that they will not face perjury charges. And people like myself, and there's more than me, have been victimized by this law with no recourse. Meanwhile, the advocates of this law claim that the recourse that we should seek is perjury, and we are deprived of that. Obviously, I stand opposed to any expansion of this law, Bill 6355. But thank you, and I'll take any questions if anybody has any.
Thank you, Mr. Juror. Hold on a second. Are there comments or questions from members of the committee? I do not see any, but thank you for sharing your story with us today. It's important to our understanding. Next, we will hear from Kristen Song, to be followed by Brian Rome and Olivia Rinks. Kristen Song.
Thank you. Good afternoon. My name is Kristen Song, and I'm from Guilford. I'm testifying in favor of HB 6355. We walked out of the tiny hospital room, and I was panicked. Who's going to say goodbye to my beautiful boy? He was right down the hallway in that bay. If I broke free, could I make it to him before somebody grabbed me? Sarah, our pastor, spoke up. I will carry your messages to Ethan. I will sit with him. I will hold his hand. We huddled in the ER hallway. How do you choose the last words to say to your precious child? I watched Sarah walk towards his room. I could see her shoulders slumped under the weight of her mission. The bay was quiet. Ethan's body and head were covered with a sheet. Sarah held my beautiful boy's hand for 45 minutes, whispered our goodbyes to him, and prayed, Godspeed, Ethan. We sat in silence on the car ride home. There was nothing to say. There was no solution. You can't fix death. My life was violently being sucked out of me. I stared out the car window and saw my reflection, tired, defeated, heartbroken. Who is that woman? I do not recognize her, but I would soon get to know her very well. I walked into our home. It was eerily quiet. I sat on my couch numb. I heard the front door open. I looked up in a daze. It was my daughter, Emily. For the first time in my life, I had no words. I could not even comfort her. I climbed into bed, my body encased in concrete. I stared at the ceiling and reached for Mike's hand. We clasped hands tightly and didn't let go the entire night. I knew if I didn't hold on to him, I would fall into the abyss, never to return. My mind raced. I went through every single detail of that day, every second, a continual loop of agony and despair. My tears fell so fast I gave up wiping them. They pulled on my pillow, each puddle a billboard of heartbreak, sorrow, and anguish. My heart thumped a hopeless rhythm. He is gone, he is gone, he is gone. My flagging will to live was no match for my crushing sense of failure. I could not see a path forward. I was desperate to make the pain stop. I am not strong enough to live without my beautiful boy. Days after Ethan died, I was sitting in the cold kitchen with a cup of coffee. My son, Evan, walked into the kitchen and grabbed the cereal. I stared at him. There's only one. Ethan is no more. I used to love our busy school mornings. I would be busy making their lunches, Mike cooking breakfast, chatting with Evan and Ethan about their day. Now it is so quiet. That morning, after Evan left for school and Mike headed off to his office, I sat and I contemplated suicide. I actually felt relieved. I could escape this incredible pain and be with Ethan again. I got lucky that morning. I did not have a gun at my house. Suicide is very impulsive, and when you are in the moment, killing yourself makes perfect sense. The only people that knew I was suicidal was my husband and my son. I am a very good actress. Thankfully, those feelings passed. But understand this, had I had a gun in my home that I could have accessed, I don't know if I would be here speaking with you today. So for those families that do have a gun in their home, ERPO gives them a fighting chance to save their loved ones. Guns and suicide are a very successful combination. Since Ethan's death, I have sat with many broken parents. One mother shared with me that her adult son, who lived in his own home, was having suicidal thoughts. He would not give her his guns for safekeeping until he was in a better frame. She was frantic. She called the police, his therapist. She called anyone that she thought might help. She had no recourse. He shot and killed himself. This may shock some of you, but I believe and support the Second Amendment. I just think if our loved ones are suicidal, they should mean more. Thank you.
Thank you for joining us today. Are there comments or questions from members of the committee? Thank you for coming back to join us again to inform our perspective here. Thank you. Enjoy the rest of your day. Next, we have Brian Rome, followed by Olivia Ranks and Stephen Holmes. I see Brian Rome is in. Unmute yourself and you have 3 minutes.
Hello, thank you, Senator Winfield. I'm Brian Rome from Granby, and I oppose House Bill 6355 as it would serve to further dissuade those who need help the most from seeking it, and is of dubious constitutionality. I'll begin by quickly making 2 points which I believe could work to curb suicides in our state. By instead making conversations between a patient and some medical professionals, like family practitioners and nurses, regarding self-harm absolutely privileged, requiring patient consent before relaying to other parties, I believe that we will see people who might have otherwise stayed silent step forward and receive the help that they need without fear of government intervention. I would also recommend seeking to collaborate with nonprofit organizations like Hold My Guns, who work to establish a network of federal firearms licensees willing to temporarily house firearms offered by firearms owners on their own volition, who may then regain their firearms at any point after passing a background check. This law cross-sections the rights acknowledged by the state's declarations of rights and the amendments to our federal constitution. It has been argued that this infringes on the Second Amendment and due process. I would like to raise a point to showcase the issue of just how many rights are impacted. Section 11 of the Declaration of Rights reads, "The property of no person shall be taken for public use without just compensation therefore." I believe that a compelling argument exists that public safety would fall under the umbrella of public use. The state should offer compensation to those who have an RPO applied to them for the period of time that their assets are being held for this public use. This is by no means the most important constitutional issue, but is one not yet raised. Ultimately, freedom and security are antithetical. Absolute freedom cannot be achieved when we possess absolute security, and absolute security cannot be achieved when we possess absolute freedom. We must find a balance between the two, and I fall on the side of greater liberty. On House Bill 6491, I would like to quickly state that in my Massachusetts college campus, I have heard of people who carry electronic defense weapons as firearms are not allowed on campus. And I personally know a coworker who is willing to practice self-defense, but takes moral issues with the application of lethal force from a firearm. This concludes my statement.
Thank you, Mr. Rome. I see that Senator Kissel has a comment or a question.
Yeah, thank you, Mr. Chairman. You stated you live in Granby. I have about 95% of Granby, and Kevin Witkos has like 5% of Granby. I'm just wondering, are you my constituent?
I do believe so. I'm in Fawn Drive, down on the southern border.
Okay, well, I just want to tell you, I appreciate the fact that you took the time today. It's been a long day. And you took the time to testify, and that's really important. So thank you.
Thank you very much, Senator Kissel.
Thank you, Mr. Chair.
Thank you, Senator Kissel. Are there comments or questions from other members? I don't see any. So, Mr. Rom, thank you very much for joining us and offering your testimony.
Thank you for allowing me to speak.
Have a great day. Olivia Rinks, followed by Stephen Holmes and L. Maureen Cece. Ms. Rinks, you have the floor.
Thank you. Good afternoon, and thank you, members of the Judiciary Committee, for the opportunity to speak. My name is Olivia Rinkus, and I'm from North Stonington, Connecticut. I am testifying today in opposition to Bill HB 6355, an act concerning risk protection orders or warrants. As written, this bill is unconstitutional. The right to bear arms is a constitutional right that cannot be revoked without due process. The need to protect individuals who require protective orders is there, as is the need to provide care for individuals who are suffering from mental illness and may pose a risk to themselves or others. However, simply put, this bill is just putting the responsibility off of the state and to investigate claims of domestic violence and convict and charge those responsible to the fullest extent of the law. And in return, it provides no additional protective.
You've muted yourself, Ms. Rinks.
In return, it offers no protective services to victims who may very well be in real danger. It also reinforces the over-reliance of the state and justice system on punitive disciplinary actions in response to actual mental health crises, rather than taking the opportunity to create an adequate and comprehensive mental health care service. I am also testifying in favor of HB 6491, an act concerning non-lethal electronic defense weapons, in support of the unquestioned legalization of all means of self-defense. Thank you.
Thank you, Ms. Rinks. There's a comment or a question from Senator Kissel.
I just had a question. I sort of missed it in the beginning when you stated. What town do you come from? Ms. Rinks?
You're muted.
Oh,
Pardon
no.
me. Sorry, I'm from North Stonington.
Oh, I thought you said Summers. Okay, all right. Thank you for your testimony. Thank you, Mr. Chair.
Thank you, Senator Kissel. Representative Howard.
Thank you. Hi, Olivia, how are you? I think you're muted again. I just want to take a minute, because you're my constituent, to thank you for being here, but also to provide a bit of an integrity push for you, for my colleagues, because you often reach out to me and hold me accountable for my decisions as a Republican. And this issue, some of these issues fall along partisan lines. And for someone who consistently reaches out to her Republican legislator to hold them accountable to testify today in opposition to this bill, I really think speaks to your credibility. And I hope that you'll comment on that to tell my colleagues that is in fact the case, because it certainly adds credibility to you. And I thank you for your continued open mind and willingness to not just be partisan, but engage in conversation.
Thank you, sir. Thank you. Yeah, I am definitely in favor of the Constitution in general. Just, I believe, is the strongest protective order in the country, and I'm just in favor of that. Thank you.
Thank you, and thank you, Mr. Chairman.
Thank you, Representative. Are there comments or questions from other members of the committee? I do not see any. Ms. Rinks, thank you for joining us today and offering your testimony. Enjoy the rest of your day. We'll next hear from Stephen Holmes, followed by L. Maureen Cece, and then Michael Reagan. Mr. Holmes, you have the floor.
Thank you very much for your time. I appreciate all the work that our elected representatives do for us and with us. I'm testifying today in support of 6355. I have personal reasons having to do with mental illness and violence. But what I want to do is really concentrate my comments on a very narrow part of the bill that I think should be strengthened. And that is when someone goes through the due process. I do think that there is due process in what I hear described in terms of how this bill functions. When someone goes through that due process and is found to be a danger to themselves or to the community, their firearms may in fact be taken away for a time. I think that it only makes sense that whatever was found in due process to have argued for those firearms to be taken needs to be addressed before the firearms are returned. From my point of view, that's just common sense. And that's really what I want to focus my comments on. And I thank you very much for taking the time to listen.
Thank you for taking the time to join us. Are there comments or questions from members of the committee? Mr. Holmes, I do not see any. I want to thank you again for spending your time with us today and offering your perspective. It is instructive, and enjoy the rest of your day.
Thank you very much.
Next on the list, we have El Maureen Cece, followed by Michael Reagan, and then Philip Beer. El Maureen Cece. I see is in the room. Michael Reagan. Philip Beer. Next on the list, we have Kevin Bushi, Angel Velez, Jordan Levine. Kevin Bushi, Jordan Velez, Angel Velez, sorry. Jordan Levine. After that, we have Nicholas Graminga. Nicholas Graminga.
I missed my chance. What the hell?
Okay, I see Jordan Levine is in the room. Mr. Levine?
Yes, sir.
Okay. You have your camera on?
There we go.
There you go. There you go. You have your 3 minutes.
Great. Thank you, everyone, for being here today. Good morning or afternoon now, honorary members of the Judiciary Committee. I'm testifying today because I oppose HB 6355. My name is Jordan Levine, and I'm the proud owner of A Better Way 2A. A Better Way 2A is something that I started almost a year ago as a way to encourage inclusiveness and diversity in the gun community. I did this when a very liberal gay friend of mine wanted a firearm for self-defense after the Pulse nightclub shooting, but expressed concern that it was difficult for him to find out how to do so in a welcoming environment. Since then, I've made it my goal to show people of all backgrounds, gender identities, races, and political ideologies that there's a spot for them in the gun community. And what I've learned in my time doing this is that there was already this substantial yet underrepresented population of left-leaning gun owners. And the reason I'm saying all this is because in almost every conversation I've had with them from across the political spectrum, and this is gun owners, not left-leaning people in general, is that there was a common and resounding belief that red flag laws are a bad idea. And I'm obviously aware that we already have a red flag law in Connecticut. And while I personally disagree with the concept, how it's currently written at least allows for some discretion on the part of the state attorney or the police in terms of determining the validity of the complaint being made. This is all thanks to one word, the word shall in line 17 of the existing bill, which the co-sponsors of this bill would like to change to the word may. One word, and that removes the need for an investigation that could not only save time for other cases with credible threats, but also save lives. Now, out of the many things regarding this bill that I disagree with, this stuck out to me. It amazes me that after a year wrought with the pain and suffering caused as a result of police unaccountability, that this bill is still being proposed as is. The people, I'm going to chalk it up to an oversight because I don't think people would have the nerve to introduce this bill that would not only force more people into violent encounters with the police, but one that removes the due diligence required to ensure innocent people do not get hurt or killed. Because of a law similar to this, Breonna Taylor was killed last year. If police were required to search Breonna Taylor's apartment to verify the information that they had before acting on it, they would have realized it was inaccurate and she would have still been alive. So in this bill, there is no proposition to include a penalty for false reporting, and police are also not required to validate every outlandish or vindictive claim made by an angry in-law or spouse, but instead can take them as fact and respond appropriately. If this bill passes, there will be casualties the way that it's currently written. Now, even though I feel like your heart's in the right place here, I don't think you've considered this. And I've been a gun owner for a third of my life. I also saw a psychiatrist for 2.5 years at the peak of my struggle with mental illness at the same time. And this is something that I may have thought twice about or avoided entirely had I had reason to believe that I could lose my right to self-defense. A statistic that we don't have is the number of gun owners who have sought help who are still here. Instead of guns being taken away from the mentally unwell, if this bill passes, what we will have is gun owners who avoid seeking help for fear of losing their Second Amendment right. So same amount of guns, but with gun owners who will no longer get help. Overall, this bill is just riddled with issues and unintended consequences. And while I understand the need to reduce gun violence, we have to do so in the right way. Thank you for your time and consideration. If anyone has any questions, I'm happy to answer them now.
Thank you, Mr. Levine. Are there comments or questions from members of the committee? I do not see any. That being the case, Levine, thank you for joining us today and offering your perspective.
Great,
I hope you enjoy the rest of your day.
You as well.
I see that El Maureen Cici has joined us. Can you unmute yourself and you're muted.
I do
You're
not
still
see it.
no, still muted. So what I'm going to do is I'm going to give you a chance to unmute. I'm going to go to the next person and come back to you. Oh, there you go. There you go. All right, we'll wait for you.
All right, I just have to eliminate the feedback. Okay.
There you go. Do you have multiple devices?
I'm having such a hard time with this.
Okay. You may begin.
Senator Weinfield. It's not gonna work.
Are you ready?
Okay, do we have a good connection now?
I think this is manageable.
I do hear an echo.
Okay, let's try that.
Go ahead, proceed.
Okay.
Proceed. Yeah, we can hear you.
All right, thank you for your patience. Senator Winfield, Representative Stastrom, Ranking Members Kissel and Fishman, and distinguished members of the Judiciary Committee. My name is Maureen Cici. I am from Norwalk. I volunteer with Connecticut Against Gun Violence. I am testifying in favor of HB 6355 and that concerning risk protection orders. I chose to speak today on behalf of myself, my friends, and strangers. Yes, strangers, those who must depend on others to stand up and speak out because they cannot. I am here today to look each of you in the eye and truly hope you never answer the phone and hear your good friend just blew her brains out with a recently purchased firearm. That you never hear a family's escalating argument has ended with your friend's mother dead and her father holding the gun because her culture of not wanting law enforcement involved. That not one of you need countdown calendar days thinking the firearm that was removed with due process may be the same one that's pointing at you. If you think you are immune, put yourself in their shoes. It only takes a split second. A life that may have been saved simply by requiring a court hearing. Currently, nationwide, 22 veterans commit suicide every day, most by firearms. Will the next veteran's death be your buddy, your friend, your neighbor? Family members, very aware of all the stigmas, should have the option to petition the court directly. Stand up, senators, save a life. Favorably vote HB 6355 out of committee so the General Assembly can vote to strengthen our extreme protection law.
Thank you. Comments or questions from members of the committee? I do not see any. I want to thank you for joining us and struggling through connecting so that you can offer your testimony. Really appreciate it, and I hope you have a great day.
I would like to thank each and every one of you for your patience with the feedback again.
That's okay. What's important is that we got to hear your testimony. Have a great day.
You too.
Okay, so next I will just keep going down the list. We have Michael Reagan, Philip Beer, Kevin Bushi, Angel Velez, Nicholas Graminga, and are any of those people in? And also we have the stand-in for Jason Levy. Are any of those? I see Jason Levy's stand-in should be in.
Hello?
Hello? Yes.
Hey, perfect.
When you begin, because you're not Jason, can you state your name so that we have it clear?
Yep, my name is Jonathan Walsh. I live in Rowayton, Connecticut. And I want to thank you for bearing with me both times I appeared on camera in my pandemic uniform, flattening the curve. So hopefully I'm a little more professional now, but thanks for the patience. So I wanted to speak to you guys today in regards to HB 6355. I was a former EMT. I've dealt with people in their moments of crisis. And, I've stood shoulder to shoulder through them, with them, helping them work out, some of these issues. And my life has also been, deeply impacted by gun violence. But what I don't think that we should do is I heard a lot of talk about, what's factual, what's legal, what's lawful, what's moral. And I certainly think that the current law as it stands, even though it is an infringement on the Second Amendment, in my view, as the current law stands, I think this proposed bill takes it a step too far past what is known as common sense and into something that I've heard a lot of conjecture on that it may help, it could have helped, it possibly might have helped. And, if we're going to talk about, things that are actually going to make a difference, I think that what we need to focus on is legislation that, gets down to the root of what some of the mental health that some of these people are going through is, and how we can focus on, the root causes of some of this stuff. I've heard that gun violence is a pandemic, but I really do think that the greater pandemic and the greater challenge is the widespread overreach of government that affects everybody. And so I want to, firmly oppose 6355. And I'd also like to take it a step further and support 6391. Again, as an EMT, I think that we should, be giving people who are victims, battered women, minorities, in Norwalk right down the road, there's gun crime all the time. And I think people should be able to defend themselves with whatever modern means they deem necessary, whether that's a stun gun or a pistol or, whatever they need to access in order to defend themselves and their families. So, I don't want to see people disarmed at the hands of their abusers by, somebody who plays the system with a bill like HB 6355. Certainly lives like Duncan Lemp and Breonna Taylor would still be with us if, these the orders like that weren't executed and lives weren't taken. So, having said that, we don't live in a perfect world. There will never be a perfect society. So any way that people can defend themselves, I want to stand firmly in agreement with. So thank you for your time and thank you for the acknowledgement.
Thank you. Representative Palm.
Thank you, Mr. Chair. Mr. Levy, you are the second person who has made reference to Breonna Taylor. Can you run that by me again, please? What the connection is?
Sure. The police officers were executing, a warrant. They had reason to believe, just like anytime you file a warrant, somebody says something about somebody else, and that triggers a visit by the police to come, do an investigation and check that out. And unfortunately, with the state of how the police operate nowadays, we have a lot of police aggression, and some of it undue, and sometimes good people who are either sleeping or minorities or whoever it is that gets involved in a police action. Wrong place, wrong time. Gun violence works both ways. The government can perpetrate gun violence on citizens just as easily. So that's a concern for me when you have police officers, kicking down people's doors and firing and hurting people.
But this bill is intended to, in part, prevent people from harming themselves and others. This is not about police excessive force, which we dealt with in the police accountability bill.
Yes, and I don't doubt that. I'm just saying that, in order to prevent somebody from harming themselves, that would require a police intervention. And with the current state of interactions of minority communities with the police and a lot of the lives that have been lost there, I just fear that, greater interaction with police, in those communities that are most affected by gun violence might not give you the outcome that this bill seeks to provide.
And so you're saying that by allowing people who have mental problems to be able to arm themselves, Breonna Taylor wouldn't have been killed? I'm still trying to find.
Not at all. I appreciate the question. So I think that when you allow people who are mentally ill to arm themselves, the form that you'd fill out, it's called a DPSC-3. That's one form that you fill out, and you also fill out another form when you're going to buy a firearm. And question. Let me see. There's a question on the form, and it says, "Have you ever been subject to a court order for mental health, or are you guilty of a crime?" So I think that having those background checks that we already have in place are stopping a lot of mentally ill people. So I don't see the need for a risk protection law when our background checks are doing a good enough job keeping the guns out of those people's hands.
Okay, well, thank you for your testimony, sir. I would just like to say for the record, I think that's a false syllogism and irrelevant in this case, but
Thank you for being here.
I appreciate it. Just to be clear, are you not for background checks?
Mr. Levy, I think that the representative is the one asking the questions.
Oh, sure. I was just trying to clarify her response. Sorry about that.
I understand. But there's another comment or question from you and Representative Stastrom.
Thanks, Mr. Chair. Just real quick, sorry, I want to just certainly thank you for sticking it out with us. Obviously, I know you had tried to testify early and were respectful enough to wait till the end, and I appreciate that. But on this Breonna Taylor point, wouldn't a solution to your concern about cops kicking down doors and catching folks in unsuspecting situations with guns drawn, wouldn't an easier solution be just to write a law into this law or some other place that said you can't serve a warrant without knocking on the door first?
According to, and again, I'm not a lawyer, but according to what I read on the news, the police did knock in Breonna Taylor's case. So I don't understand how that would have helped anything because she's still dead. So.
All right, thank you, Mr. Chairman.
Thank you. Comments or questions, Representative Sims?
Thank you, Mr. Chair. And Mr. Levy, I just want to thank you for your comments that you made today and also for your testimony. You know, we've been here all day long. We've heard so many different perspectives. So I just want to thank you because you're from Norwalk and not my constituents, but I just want to thank you for sticking it out and testifying. So thank you, Mr. Chair. Appreciate it.
Thank you, Representative Sims. Comments or questions from others? I just want to get it right. Your name is not Mr. Levy, correct?
No, it's Jonathan Walsh, but that's okay.
Right, Jonathan Walsh. I just want to make sure that we have it correct for the record. Thank you for joining us today.
Thank you.
Have a great day. I don't know that we have anyone else who had been passed by in the room. Is that correct? Madam Clerk or Administrator?
That is correct, Senator.
Thank you. That being the case, I believe we have come to the end of this hearing. Mr. Chair or ranking members, anything before we close?
Mr. Chairman, I'd be remiss if I did not thank the members of this committee and also those who testified today for allowing us to move through the list of folks who wanted to testify as expeditiously as possible. Sometimes we have gun hearing days, as folks know, goes super late in the night, and we folks get frustrated and turned away that they didn't have a chance to say what they wanted to say, either for or against the particular piece of legislation before us. Certainly in my time in the legislature, I've never seen of a gun day in the Judiciary Committee that has ended in time for happy hour on a Friday afternoon. And I think it's certainly a testament to the members of this committee, the format, and those who are testifying being able to stay within their 3 minutes. So I want to just thank and applaud everyone as we go off into the weekend. With that, I would also just remind members, we do have a public hearing at 10 a.m. on Monday morning, but please check your emails. There is a good chance, I would say good chance, we have a committee meeting prior to 10 a.m. on Monday morning. So folks, please reserve some time earlier as we're hoping to have a vote. All right.
Thank you, Mr. Chair. Senator Kissel, Representative Fishbone, before we finish, anything?
Sure. I just want to commend you, Mr. Chair, and both chairs. I agree. It's fabulous. It's not 12:30 a.m. like last week. which was sort of crazy. And on a gun bill or gun bills, it could go super long. So I get that. If we're gonna go in on Monday and it's before 10 a.m., I need to know as soon as I can. If it's like 9 a.m., which I can't believe you guys will go in at 8:30, but you could. You could go in at 8, you could go in at 7, who knows? But I appreciate the fact that we have a weekend. I am so far behind on the rest of my life. But it was good testimony, and it was heart-wrenching testimony today too. So I appreciate that.
Absolutely, Senator Kissel, and thank you for your comments. And you and I and a couple of other people were here when we used to go really late all the time, almost every hearing. So it's good to be in this new world. And
God bless you. God bless you.
As far as I'm concerned, anytime we finish on a gun bill this early in the day, or at any time, actually, it's happy hour because it's over. I hope you all enjoy your weekend. We will see you Monday. And Senator Kissel, I don't think we'll be there at 8 o'clock or 8:30, but it will be a little early, most likely. Everyone have a good weekend, and we will see you all on Monday. That concludes this public hearing of the Judiciary Committee.
Thank you, Mr. Chair.